And as I understand it, state intends to recall the detective to the stand and resume its testimony. Is there anything on the part of the state to take up before we would call in the jury?
No, Judge. I just need Mr. Wright in here, but no.
Anything on the part of Mr. Mitchell?
Carmichael, we would just making an objection for Mr. Carmichael to improper impeachment, for the record.
Do you want to flesh that out exactly? What grounds and what is it? Now, before we went on the record, I'll just note you and Ms. Charles conferred on the exact portions of a recording apparently Ms. Lindsay gave to the detective during the investigation. And she indicated which portions she intends to introduce and publish. And what aspects of those do you believe are objectionable?
I don't believe those, whatever they're about to play was anything that the detective denied on the record, or
You mean the witness or
that the witness said.
in the transcript?
Yes, or not even in the transcript, but in her prior testimony, what was asked of him, I believe it's maybe used to bolster or put in evidence that was not even brought into the case. And so those questions weren't asked when Miss Lindsay was present. And so now it's coming in as impeachment, but this witness is no longer here. And so we're impeaching him without her even being able to come back to explain why they're inconsistent. So we were arguing that this is an improper impeachment and used to bolster the case for the state.
All right. So, Ms. Charles, can you point to the subject matter that Ms. Lindsay testified about in the prior trial that now, okay, Ms. Hall's going to cover this, that now these recorded statements are going to come in and show an omission, an inconsistency, or why that is proper grounds for impeachment?
Yes, Your Honor. Your Honor, actually, these are prior consistent statements of Ms. Lindsay. On last week, when defense counsel was questioning our lead detective, he asked him that Lindsay nor the defendant ever had a conversation in the vehicle. The lead detective said that that was correct. And then he turned around and he said, so they never ever had a conversation. And our lead detective responded, not in the vehicle. When Lindsay testified, she testified to them having a conversation in the vehicle when they were going over to the guest inn. So what this is rehabilitating our current witness to prior consistent statements of Lindsay. We're not changing anything from her prior testimony, but he testified incorrectly last week. So we're bringing in this prior consistent statement of what Lindsay said, what she actually testified to in the last trial, and what she said during her interview with lead detective. So that's one part. And then the second part was when defense counsel asked lead detective about the defendant's demeanor, and his response was that she was chill, that he wasn't mad, which is also inconsistent with what Lindsay testified to in the last trial and inconsistent to the conversation that he had with her. So we're rehabilitating our witness through prior consistent statement of.
Well, okay, and I think we're getting a little loose on terminology, but that's fine. I'm really, I mean, what it is that he testified to something, and now he's being shown that why he was perhaps mistaken. Yeah. And so it's not his inconsistent statement. It's just Lindsay. It's evidence of why his testimony last week may not have been accurate. All right, Mr. Mitchell.
The issue is that it seems like he's being used to, are you saying he's being used to impeach what Lindsay said?
No.
I mean, I think to be technical, they are impeaching their own witness.
Their own witness, Mr.
Right.
The detective.
That's right.
That he didn't remember
That's
what
right.
happened or what his interview said. But it's about an interview that took place with Miss Lindsay. And now there could be inconsistency with what Miss Lindsay said. And so he's being used to impeach what Miss Lindsay said, but now she's no longer here to be able to clean that up or explain why it's some differences.
Your Honor, if I may, there's nothing to clean up. The last week, defense counsel asked the detective a question. Was there a conversation? He said no. There was no conversation in the car. Lindsay has testified to and in the previous interview said that in the car had a conversation. That's it. Now, so we're playing the conversation. There's nothing else that needs to be added or taken away from that particular testimony. So we're gonna play the part where she says, we were talking in the car, conversation. So that's it. I don't think there's nothing outside of that that we need Ms. Lindsay for.
All right, so you've identified that snippet, and then the other ones were his demeanor during that time period.
Those are-
And then is just two?
It's two sections, but
Right.
they're four small parts. So I think it's a total of a minute.
Two,
Breaking down.
two same subject matter.
Correct.
Yes.
Understood. Okay. Any final word, Mr. Mitchell?
I would like to put it in context and I'll make sure I look at the transcript to make sure, because there isn't anything where she directly says, I had a conversation with Peanut. It's like she's talking to him and she said he didn't say much. And even on the stand, she said she wasn't really paying attention. So it's a way to kind of get in some type of bolstering evidence of something just for the effect on the jury. You know, this isn't about anything that was said. It's just another way to put in some evidence about an unreliable conversation now.
Right.
And this witness is long gone.
Well, that's fine, Ms. Hall. So to the extent that you think you have something else in her prior recorded statement that provides further context, that in fairness should be considered simultaneously or contemporaneously, you can bring that to our attention.
Okay.
And we can also have that come in. You can do it on recross, and on that exact point. So to your original objection, though, I believe this would be admissible for the reasons that the state outlined, not only to, I think, technically impeach the detective, but it also is a hearsay accession for Miss Lindsay's prior statement. So I'd overrule the objection there, and we can take these other issues up as you spot them, okay? Anything else, Mr. Mitchell? All right, then with that, if we could bring in the jury. Yes, if we could go ahead and bring in our detective. Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. Glad to see everyone safe and sound and sufficiently warm. Thank you for being back right on the dot at 9. Y'all beat us to it. We had some logistical issues we had to work through, but I'll let you know that we have streamlined things while we were working through while you were in the back. And as a result, I do believe what we'll be resting the evidence today and beginning closings. We're on track. And so with that, unless there's anything anyone needs to bring up, we're going to resume the testimony of the previous witness who was here on Thursday with us. And I would say, and remind the witness that you would still remain under oath as to your testimony in this case. And with that, Ms. Charles, you can proceed with any redirect.
Thank you, Aaron. Gary Blaine, Detective, welcome back.
Good morning.
Detective, on your prior testimony, you were asked a series of questions by defendants.
Mhm.
And one of the questions you were asked was whether there was a conversation between Ms. Lindsay and the defendant in the car, to which you responded no.
Okay.
Isn't it correct that when you, during the course of your investigation, you met with Ms. Lindsay twice and spoke to her twice?
Yes.
And at the time, were both of these conversations audio and video recorded?
Yes.
Where was the first conversation?
The first is going to be at Douglas County Sheriff's Office.
And when did you go to her home?
It's going to be, I believe it was April 7th.
And so when you spoke to her at her home, was it video or just audio?
I believe it was video recorded also.
Then at Douglas County was also audio,
Yes.
and videos.
Yes.
I am handing you what's been marked as states 111A and D. Prior to you testify to general to review the audio and video recording for the conversation. Let's just see.
Okay.
Sure.
Yeah.
4 minutes.
Okay.
I have it.
I'm handing you this
Mhm.
into audio and video recordings of your conversation with Ms. Lindsay. When you reviewed your audio and video recordings, it says it did appear to be altered or changed in any way.
No.
They did accurately capture your interactions with Ms. Lindsay on the both times that you met with her.
Yes.
In addition, still would tender into the record states 111A and
It-
111B.
Any objection?
No objection.
Admitted.
Now, for the record, states 111A is 10 minutes and 11 seconds long. That is a conversation at her home. And for the record, the state proposes to play from minutes 5:40 to 6:15.
It's going to be the witness stand, I think, is unmuted. I think so. Testing. All right, you can proceed.
I will share the screen and play the first clip.
And so he ended up, I'm in the car and he wanted me to take him back because he was going to go get his piece. I said, Peanut, it ain't even fucking worth it, bro. I said, why are you even going to go shoot this boy over this shit? I said, let it go, man. I said, you've been in the game too damn long anyway.
And then you testified just now that there was a follow-up conversation at the Douglas County Sheriff's Department that was also on video. Is that correct?
Yes.
Okay. And for the record, that conversation was 2 hours, 2 minutes and 8 seconds long. The state proposes to play again 2 short clips from that interaction, which would be the next slide. The first would be from 22:20 to approximately 22:40, and then 3 minutes and 32 to 3 minutes and 49.
I told him in the car, and I said, are you serious? And he was like, Kim, I'm not in the fucking mood. I said, well, this is just stupid. I said, but, you know, I said, are you really, really going to do this? You really going to color outside the lines like this? But I mean, the whole time he was calm, and he was like, look, don't worry about it. And so, like, literally, even when he was in the car, he never raised his voice. His voice still stayed like, he wasn't like irate, like, you know, like, even when he got on the phone, he was like, he was scary calm, you know?
So Detective, is it correct that when Ms. Lindsay described Mr. Carmichael as calm, she described him as a scary calm?
Yes.
I'm sure you must be Marcus states 111.
Mhm.
C. The 111. Can you take a look at 111 and tell me what you recognize it to be?
Oh, that's going to be Miss Kimberly Lindsay.
And is that an accurate depiction of Ms. Kimberly Lindsay as you interacted with her on April 5th, 2024?
Yes, ma'am.
Here and now, this time state would tender into the record states 111 111A, the excerpt, and 111B, the excerpt.
No objection.
Yeah, I think you already admitted those in their entirety.
Just making sure I had.
Okay, all right.
Okay.
To the extent they're not already admitted, they are admitted.
Thank you. Now, Detective, you also testified that Ms. Lindsay dropped off the defendant at the guest inn. Is that correct?
Correct.
Now, from the guest inn to the Economy Hotel, approximately how long would it take? You would drop it?
I'll say no more than 5 minutes.
I'm heading you in United States 3A. Take a look at 3A and what recognize that to be.
That's going to be the directions from the guest inn to the Economy Hotel.
Okay. And did that appear to be a fair and accurate depiction of the location as far as the distance?
Yes.
Did it appear to be altered or changed in any way?
No.
This time table tended to the record states 3A.
No objection.
Admitted.
And I'm also handing you states 3B, 3C, and 129. Take a look at those and how much you recognize them to be.
3B is a photo of the Economy Hotel, the incident location. 3C is going to be the Valero. And 129 is going to be the guest inn.
Okay. And did they fair and accurately depict the Valero, the Economy, and the guest inn as you recognize them when you interacted with the persons associated with this?
Yes.
This time table tender into the record states 3B, C, and 129.
No objection.
Admitted.
Thank you. Now, when you testified on cross, you were asked a series of questions about what you see on the video. Is that correct?
Correct.
And one of the questions you were asked is what you could see as a.
Correct.
So I'm sorry, what would you say? Repeat that?
You were asked whether you could see the gun.
Okay.
Yes. And you said no, you weren't kind of able to see a gun.
Correct.
But is it correct that you're able to see movement outside of that?
Yes.
And is it also correct you're able to see the body positionings of the parts, the people at that doorway?
Yes.
When we looked at states 106, which contained that sort of snippet of the doorway, when we see Mr. Carmichael with one hand outstretched and one hand cocked at 45, from your training and experience.
Objection, Your Honor. This is gonna be speculation. This is something that goes to the weight of the issue. The jury can watch the video. And so to be able to use the detective to explain what he's seeing is improper testimony. The jury will have.
All right, I understand the argument, Mr. Mitchell. And Ms. Charles, I think we already went, and we already actually had the detectives kind of going, a version of going through the video frame by frame. Is there anything, first of all, if you want to respond to that, or is there anything that's additional that you're getting out here?
But I was just wanting to sort of testify to the positioning of Mr. Carmichael's hands in that last frame that we looked at. And why that would be significant to his investigation.
And did he not already cover that on Thursday?
Not in this way, no, Judge.
All right, you can rephrase and perhaps Mr. Mitchell will be renewing his objection. We'll see.
Detective, when you observed Mr. Carmichael at the doorway, what was significant about his body posture to you? And when you looked at the videos?
Throughout the video, I see that he did go inside of the room a couple of times. One point where he was almost all the way inside the room. And during the incident, as the victim was appeared to be falling to the ground, you can see his leg coming out. You saw Mr. Carmichael standing over him with the left arm stretched out and the right arm cocked at an angle.
You also asked on cross-examination that there were no testing or no ballistics, is that correct?
Correct.
Why were there no ballistics? Can you explain that?
Yeah, so usually when we find projectiles, they're not usually tested unless we have a firearm with it. So if we have a projectile, nothing's usually tested. We will usually send off shell casings for testing. However, on this scene, no shell casing was recovered.
Was a firearm ever recovered?
No, it wasn't.
Why not?
Objection. No, never mind. I'll withdraw that objection.
All right, you can answer the question.
Why was the firearm not recovered?
So usually in my experience, when we have shootings, the offender would usually take the firearm. It's not often we recover firearms in shootings. So in this case, the firearm wasn't found on scene. The suspect wasn't found on scene. By the time the suspect was actually located months later, firearm wasn't around him.
Okay. And I think one of the last few questions you will ask was about probable cause
Yes.
for the warrants of Mr. Antoine Carmichael.
Mhm.
Detective, do you see the person that you took out warrants for here in court today?
Yes, I do.
And he point to an article of clothing and identify where he's sitting here in court?
He's going to be to my left. He's going to be a black male with a black mask on his head. It appears to be a dark colored suit, white shirt, and dark colored tie.
I'm not the record fellow detective. Thomas has identified Antoine Carmichael as a person from warrants here in court today.
The record will so reflect.
Thank you. And Detective, once you took out warrants and submitted your case file, did you, is that the conclusion of your investigation of this case?
No, it's not.
And did you have any further interactions with the as far as collecting of evidence or anything of that nature?
I believe after the warrants were taken, the only thing that I did was get the white Ford F-150 and get a search warrant for that and search warrant for phone records.
Understood. And then once you obtain those, you have those analyzed, is that correct?
Yes.
All right. Thank you. Nothing further.
Recross on those points.
Detective, I want to go a little bit over your previous testimony about Kimberly Lindsay. You did hear any interviews. Based on those interviews, isn't it true that Kimberly, when she's speaking to you, she's speaking about what she was saying to Peanut, correct?
Yes.
But she's never saying whether he said anything back when she's saying, are you going to do this? Are you going to paint outside the lines? All these things are Kimberly talking to you about what she's saying, correct?
He did respond at that instance, but yes.
Okay. Do you recall him saying, yes, I'm going to do it? Or what do you recall that response being?
I recall his response being, don't worry about it.
Okay. But do you recall her ever saying, he said, I'm going to do this?
No.
Okay. The testimony, the statements were more of her asking him questions, but we don't know where those statements came from. The foundation was for her to ask those questions, correct? She didn't say he introduced these issues, correct?
I'm not understanding the question. I'm sorry.
The questions that Kim asked, it wasn't as if she heard this from Mr. Carmichael. She just said she asked him a question.
Objection, Judge. It's cause of speculation.
Overruled. You can start that question over, Mr. Mitchell.
Okay. Essentially, Kimberly was asking all the questions to Mr. Carmichael, correct?
Yes.
Okay. And she didn't say whether he told her what happened, correct?
Correct. She overheard it.
Okay. She mentioned that he was on the phone, correct?
Yes.
Okay. Do you recall her saying she didn't remember, she wasn't necessarily paying attention to what was going on?
I recall her saying that she was on the phone.
She was on the phone too?
Yes.
Okay. Do you recall her saying she was on the phone with Tay?
No.
Don't recall that?
No, she wasn't on the phone. She believed that Mr. Carmichael was on the phone with Tay.
Oh, right. Do you recall her saying she thought he was on the phone with Tay?
Yes.
Okay. Do you know who Tay is?
Yes.
Okay. Did you ever corroborate whether he was on the phone with Tay?
No, I could not locate Tay to speak with him.
Did you get his phone number?
I don't believe I did.
Okay. Did you have Mr. Carmichael's phone number?
Yes.
Were you able to decide if he was on the phone with somebody?
I did not.
Okay. Now, when you spoke with Miss Lindsay, I think it was the second time. Do you recall her saying she had short-term memory loss?
Yes.
Okay. Now, did you ever go to the crime scene on April 5th, 2024?
Yes.
Okay. Did you review any of the surveillance?
Yes.
Did you observe multiple people going into the room prior to the police coming?
Yes.
Could that also be a factor of why evidence is not there?
It's possible. Mhm.
Are you also able to test projectiles to see which caliber they could be related to?
I'm not able to. We send it off, and sometimes they are able to. If the projectile is actually intact, they could possibly give us a possible caliber.
Did South Fulton Police send anything to the GBI?
Yes.
What did you send?
Well, CSI sent. I know they sent blood swabs. I'm not exactly sure they sent the projectile off at that time.
Judge, I think we've kind of gone outside the scope of a little bit as far as this kind of questioning.
On this point, yes, but I'll allow you to follow up if you need to on blood samples only. Is there anything else, Mr. Mitchell?
Yes. Did you, when you took out warrants for Mr. Carmichael, did you get a date of birth for him, an age range of Mr. Carmichael's age?
Yes, I did get a date of birth.
What was that?
I'll have to go and take a look at his date of birth.
If I showed you something to refresh your memory, would it help?
Yes. Okay.
Is your memory refreshed?
Yes.
What was that date of birth?
His date of birth is February 24th, 1975.
Thank you. No further questions.
All right. Anything to follow up, Ms. Charles, on blood samples?
No, Judge.
Okay. All right. So can this witness be excused?
Yes, Judge.
You can step down, sir. All right. Members of the jury, we're going to keep your blood circulating today. There's going to be a lot of in and out, in and out. We need to take 5. We'll have you back in just a minute. Thank you.
Thank you. Okay. Oh, yeah. Yeah.
All right, Ms. Charles, I'll give you a few more minutes, and
Yes,
then I'm
sir.
going to ask Deputy Scott to go ahead and bring Mr. Finney out to the stand. We'll be off the record, holding in place.
It's so, I don't get it. Like, it's something, I don't know what it is, but like, she never. We're gonna have this up.
Thank you. Thank you.
All right, let's go back on the record. How does the state plan to proceed? You still calling Mr. Finney?
Davis Finney, yes.
Okay, if we could bring Mr. Finney out.
Oh, okay. Shit. I thought I had it. I think I'm out of proof right now. One walking about.
All right, Deputy Scott, if you could retrieve the jury.
Gonna, does the witness still remain shackled or chained, anything like that?
He is right now.
That something the jury gets to see or observe?
I've never heard an objection to that for a witness.
I don't know, normally when I was the prosecutor, we didn't allow that, so I just was wondering, is that a protocol?
There's no protocol or rule about it. I think that's the default unless someone requests otherwise, and here we are.
Could we request that he not be shackled or chained?
Is there any particular reason for that on your part?
But it's kind of weird coming from the defense, but I mean, I would just say that it takes away from the witness's testimony of more of observing his appearance as being somebody in jail.
All right, I think I'd have to overrule that. It's going to be an apparent fact, no matter how he presents himself. Thank you, Deputy Scott. Please be seated. State may call the next witness.
State call Davis Finney.
Yes, ma'am.
Raise your hand. You swear according to the testimony matter this case you should give, Mr. Truth, and nothing but the truth.
Yes, sir.
While speaking clearly into the mic, need you to state your name.
Quantavious Finney, QUONTAVIOUSFINNIE.
Good morning, Mr. Finney.
Good morning.
Mr. Finney, you didn't want to be here with us today, did you?
Say, did I want to?
Yes.
No.
You were subpoenaed by the state last week to appear.
Yes, ma'am.
Failed to appear, is that correct?
Yes, ma'am.
Why did you not want to appear?
I talked to y'all, so I figured that I didn't have to show, but I did.
Spoke to us, we said you got to say the same thing to the jury, isn't that correct?
Yes, ma'am.
We're going to start from the beginning.
Okay.
Tell the jury where you were, what side of town you were living in April of 2024.
It's called Residence at the Guest Inn Hotel.
And how long have you been living at the Guest Inn?
I'm gonna say like a year or two.
Who did you live at the Guest Inn with?
My wife and kids.
How do you know Antoine Carmichael?
Since I was little.
Are you friends?
Yes.
How good friends are you?
Who, Mr. Carmichael?
Yes.
Yeah, we good friends. Best friend.
How do you know Quentin Beavers?
Who was that?
He is a man of Trench.
Yes.
How do you know the person that you know as Trench?
I hung around Trench.
And how long have you hung around with Trench?
For a good minute. I want to say I've been on Trench for like a year or two.
Where did you hang out when you hung out together?
Fulton County, Fulton Industrial Boulevard.
I'm going to direct your attention to the evening of April 5th of 2024. Is that okay?
Yes, ma'am.
We're going to start first by publishing what's already evidence. 107B. That night, do you recall the first time that you encountered Trench?
Yes, ma'am.
Where were you when you encountered Trench?
At the Valero on Fulton Industrial Boulevard.
Do you remember what time of night that was?
It had to be around about like 7 or 8-ish.
Could it have been a little later, closer to 10? And for the record, State's 107E is 24 minutes, 28 seconds long. The state proposes to play just the first portion, saying like 2 minutes, 25 seconds to 2 minutes and 46 seconds. Can you see in front of you there?
Yes, ma'am.
Okay. Playing the first portion of State's 107E. And stopping right here at this point. Mr. Feeney, can you explain to the jury who that we're seeing on screen?
With the outfit on, like with the little crosses on his chest.
Yes.
It's me.
And who are you there dapping up?
I don't recall.
Keep playing. Stop. At 2 minutes and 36 seconds. Who are you dapping up here?
That Trench.
How can you tell that's Trench?
Because of the hat. Because of the hat and his dreads.
What color is his hat?
Blue.
Thank you. Now, in front of you there, are you going to see the time and date stamped on the video?
I say it's some blocking right here. But I see, yes, I see it.
And can you read it into the record what it says on the timestamp right there?
It says 0405 2004 0703 22 p.m.
And are you aware at this time that it's closer to 10 o'clock and not 7 o'clock?
Yes, ma'am.
That's moving on to the second part, it says 107E, 8 minutes, 45 seconds to 9 minutes and 18 seconds. Mhm. Mr. Finney, looking there at the bottom there, what is the time stamp at the bottom there now?
Oh, it says, timestamp 0709.
But in reality, it will be 10:09. Is that correct?
No. It shouldn't be that late.
Stopping the video just now.
No, it shouldn't be that late.
We'll come back to that. How do you know what time it is? Why are you saying it shouldn't be that late?
Because no, when I arrived at the store, it wasn't that late. It was round about that time.
And right before that interaction, what were you doing with Mr. Beavers and during that interaction?
It looked like I was buying some cigarettes.
What, if anything, did you hand to Mr. Beavers?
Because he asked
What else did you give to Mr. Beavers that night?
some money,
How much money did you give?
$20.
And why did you give him that money?
Because he asked.
Is that normal for you to give him money when he
Yes.
asks?
Yes, because he do the same for me when I ask.
So you're cool like that?
Yes.
How long did you continue to hang outside the Valera gas station after that interaction?
Not that long. I got gas. When I left out the store, I got gas and I left.
And when you left, where did you go to?
I went to another place. Went to someone's house. Or friends.
While at the Valera gas station, did you interact with Mr. Carmichael?
Did I interact? Yes, I said something. I said something to him. Yes. Mhm.
And when you left, where was Mr. Carmichael?
Where was he?
Yeah.
By the machines.
He was still at the gas station.
Yes.
And when you left, where was Mr. Beavers?
Still at the gas station.
From the time you left the Valera gas station to the time you got back to your room at the gas stand, how much time had gone?
I want to say at least like 20 to 30 minutes.
Okay.
Yeah.
Okay. And so you said from the time you left, it was about 20, 30 minutes, is that correct?
Yes.
Okay. Did you go directly to your room or you said you
Mm-mm.
stopped one place?
No,
else?
yeah, I went somewhere else.
Were you driving or was
Mm-mm.
someone driving you?
Someone driving me.
Now, from your understanding, was Mr. Beavers, Trench, and Antoine Carmichael, were they friends?
Not as I know of.
So you testified just now, you left Mr. Carmichael at the gas station. When was the next time you saw Mr. Carmichael?
I saw Miss Carmichael within those 30 minutes when I got back to my room.
So just to make it clear, you left, 20 minutes go by, and then you saw him again within that sort of 20-minute range after you left the Valera gas station?
No, I didn't see him. I saw him way after, like the 20 minutes. So when I left the gas station, and I was gone. I never went home yet. So when I got home with them in 20, 30 minutes, then that's when I seen him.
Where did you see him?
At the hotel.
Where in the hotel? Outside, inside? Can you explain to the jury?
Outside, he knocked on my door.
And when he knocked on your door, what happened next?
Oh, he just asked me, did I have cigarettes and alcohol shot for sale? And I said, yes.
Why would he ask you if you had cigarettes and alcohol shots for sale?
Because he smoked cigarettes and drank alcohol.
Is it fair to say they sell alcohol and cigarettes at the Valera gas station?
Ma'am?
Isn't it fair to say that alcohol and cigarettes are being sold at the gas station?
Yes.
How much money did he give you for the cigarettes and alcohol?
Well, like $2.
Is that normal?
Yes.
Now, you also testified earlier, Mr. Carmichael lived at the guest inn, is that correct?
Yes, ma'am.
How close was your room to Mr. Carmichael's room?
Like 15 seconds apart.
Okay. Was it like side by side or something?
No, like front to back.
Was there a breezeway in
Yes.
between or you
Yes.
could go straight through?
Yes, breezeway.
How was Mr. Carmichael dressed when you saw him at the guest inn?
How would he dress? Wear the same thing every day.
Which was what?
What you say, ma'am?
Which was what?
Clothes. Shoes, same clothes.
What color were they?
Black.
What color were his shoes?
I want to say white.
How many cigarettes did you give him?
One.
How much alcohol did you give him?
One. A shot.
Was it normal for him to come buy shots and alcohol from you?
Yes, ma'am.
Is that what you do for a living?
No.
How long did he stay after you gave him the cigarettes and the shots?
No more than 10 seconds, ma'am.
Now, when you sold him the alcohol and shots, did he go inside?
I don't know. I know he left my room. I don't know what he did after that.
No. Before he left the room, did he step inside of your room?
Yes, ma'am.
How long did he stay inside of your room?
No more than 10 seconds.
I'm showing you what's already in evidence. States 149.
Okay.
Confirm. When you saw Mr. Carmichael at the guest inn, is that how he looked and how he was dressed that night?
Yes.
What else does Mr. Carmichael say to you while he was at your room?
Oh, he didn't say nothing really. He just bought what he bought and left.
Can you describe how Mr. Carmichael appeared to his demeanor?
He was calm, cool and collected. He wasn't startled about anything. You know. But beside that, he bought his cigarettes and bought his shots and he left.
1 minute. Mr. Finney, why did you give Mr. Carmichael the gun?
Objection, Your Honor. Argumentative. Did you,
Overruled.
what did you, she said D.
Why did you give Mr. Carmichael the gun?
Okay. That was not even in evidence that the foundation is not even there, Your Honor. That he gave him anything.
Because
All right, the witness can answer if he, however he chooses to answer.
Say it again, ma'am.
why did you give Mr. Carmichael the gun?
I never gave Mr. Carmichael anything but what he asked for, what he came and bought, ma'am.
You see Mr. Carmichael here in court today?
Yes.
Can you point out to where he is and identify by article of clothing?
Come again, ma'am.
Can you point to where he's sitting and identify him by an article of clothing?
To the left of me, suit and tie.
Let the record reflect that the witness has identified Antoine Carmichael here in court today.
The record will so reflect.
Did you give him any weapon at all that night?
No, ma'am.
When he left, did he tell you where he was going?
No, ma'am.
Did you ask him?
No, ma'am.
How did you learn that Quentin Beavers was shot?
Just a word of mouth. Word of mouth. Later on that morning, what had happened. Cause my mom stayed at the hotel, so she had called and told me what had happened.
Did Mr. Carmichael contact you afterwards?
No, ma'am.
Did you ever speak to Mr. Carmichael later on after you heard what had happened?
No, ma'am.
Is today the first time you see Mr. Carmichael since that incident?
Yes, ma'am.
One minute, the last question. Mr. Finney, when you met with the state and investigators, do you recall telling us that when you spoke to Mr. Carmichael after the incident, he discussed the fact that his drugs had been stolen that night?
No,
Do you recall that he mentioned to you that Trent had stolen his drugs?
no,
Do you recall when you spoke to our office, you indicated that Mr. Carmichael was your friend and right is right and wrong is wrong?
yeah.
What do you mean by right is right and wrong is wrong?
Cause y'all asked me a question. Yeah, asked me a question, and I answered.
Right is right and wrong is
I
wrong.
said right is right, wrong is wrong.
Thank you. Nothing further.
Good morning, Mr. Finney.
Good morning.
Kenneth Mitchell, I'm the attorney for Mr. Carmichael.
How you doing?
All right. You've made previous testimony that when you were at the Valero, you recognized the people that were in there, correct?
Correct.
You recognized the young man named Trent.
Correct.
Okay. Did you easily recognize him from the video, or could you just tell from the hat?
I can tell from the video.
Okay. Did he wear that hat a lot?
Yeah.
He did?
Yeah.
Okay. Was that hat significant for any reason?
No.
Um, Now, at the Valero, did you see a fight or any type of confrontation between Mr. Carmichael and Mr. Beavers?
No, sir.
Okay. When you left the Valero, had you had a phone conversation with Mr. Carmichael?
No, sir.
Did he call you prior to you seeing him at the guest inn?
No, sir.
Okay. Did he ever call you that night and say he was going to get a piece?
No, sir.
Okay. Have you ever heard Mr. Carmichael speak about a firearm as a piece?
No, sir.
Have you ever called a firearm a piece?
No, sir.
What would you call it?
A gun, a strap. Those words.
Now, when you saw Mr. Carmichael in your room, was there any conversation about an intention to confront someone?
No, sir.
Okay. Did you have any weapons in your room?
No, sir.
Did you see a weapon on Mr. Carmichael when he went to your room?
No, sir.
Now, you said your mom also stays at the Economy.
Yes, she stayed in. Yes, when that happened.
Was Mr. Carmichael, I guess, was it unusual for him to visit her?
No, not really.
Did he regularly visit her at the Economy?
Yes.
Okay. Do you know if he would borrow money from her?
Well, I don't recall.
But that wouldn't be unnormal, would it?
No, it wouldn't be. It wouldn't be on no.
Okay. Were you at the Economy Inn when Trenches was, when Trenches died?
No, ma'am. No, sir.
Did you see, so you didn't see the confrontation?
No, sir.
You don't know if Mr. Carmichael had a firearm, correct?
Correct.
You didn't see how Trenches passed?
Correct.
Thank you.
Can you redirect on those points?
Briefly. You testified that within about 20 minutes of leaving Valero, you saw Mr. Carmichael kind of at your room.
Correct.
How did you know you were home?
Ma'am,
How did you know you were home?
he didn't know I was home.
You testified that you don't call a gun a piece, is that correct?
Correct.
Have you ever had anyone just in your day-to-day call a gun a piece?
No.
Just to confirm, when Mr. Carmichael came to your home, he was there for less than 2 minutes, is that correct?
It was less than 10 minutes, 10 seconds.
Nothing further from the state.
No redirect, no read, pause.
Understood. Thank you, Mr. Mitchell. Ms. Charles, does the state anticipate presenting additional evidence or a witness?
Just some certified, Judge, but no lay testimony.
All right, why don't we, we'll just leave Mr. Finney on the stand for a moment while you do that. Have you conferred with Mr. Mitchell about these?
So yes, Judge, we'll be stipulating to the two.
Can we this approach?
All right, Ms. Charles, I understand you have something else to be admitted. Do you have an exhibit number for that as well?
Judge 155.
All right, and do you want to detail State's Exhibit 155?
Yes, Judge, the state, that's going to be a stipulation by the parties, which reads as follows. Both parties stipulated the following facts. One, Antoine Carmichael was previously convicted of a crime punishable by imprisonment for a term of at least 1 year on indictment 20CR0137 in the Superior Court of Habersham County, Georgia. And on April 5th, 2024, he was considered a convicted felon. Two, Antoine Carmichael was convicted of a crime punishable by imprisonment for a term of at least 1 year involving the possession or use of a firearm on indictment 07CR5276 in the Superior Court of DeKalb County, Georgia. And on April 5th, 2024, he was considered a convicted felon.
All right, any objection to 155?
No objection.
All right, submitted. Anything further on the part of the state?
No, Judge.
State rests?
State's rest.
All right, members of the jury, something else I got to take up outside your presence. We'll be back with you in about 5-10 minutes. Thank you.
Jury's clear, Judge.
All right, thank you, Deputy Scott. I am signing the order to release the hold on Mr. Finney, and he can step down, Deputy Scott, if you need to take him back. Ms. Charles,
Yes, sir.
thank you. Any motions on the part of the defense? Do you need 2 copies of that?
Yes, please.
Okay.
I didn't know if that.
Well, we'll just keep one circulating. We can make a copy if you need one. All right, motions on the part of the defense?
Yes, Your Honor, on behalf of Mr. Carmichael, we go for a directed verdict.
Any particular grounds you want to articulate?
Your Honor, the state has not carried its burden beyond a reasonable doubt, that Mr. Carmichael caused the death of Quentin Beavers. There are elements of, let's see, the elements of murder. There has to be some causation, malice, and the fact that it was unlawful. We submit that at this point, no witness has placed a firearm in Mr. Carmichael's hand. No witness has said that he shot anybody. No witness has been able to confirm how Mr. Beavers passed as far as an eyewitness. No witness has testified to any type of malice that Mr. Carmichael possessed at the time. The descriptions are really just a struggle and a fight. That's what we hear. That does not rise to a malicious intent to take someone's life away. And again, no one has testified to how the firearm discharged. At this point, it's circumstantial. And if there is circumstantial evidence, it considers the hypothesis of guilt, but also it must excuse, or it must be able to exclude, the hypothesis of innocence. At this time, the state's theory is that Mr. Carmichael maliciously intended to take the life of Mr. Beavers. However, it's also on the circumstantial end, as far as the innocence is concerned, is that there was a fight and the gun went off. They heard one gunshot. That is not sufficient enough to be able to show that Mr. Carmichael intended to shoot Mr. Beavers in the head. Again, even with aggravated assault, we don't know what's going on in the video from Mr. Carmichael's vantage point. We don't see Mr. Beavers ever. We heard testimony from Ms. Hannon that Mr. Beavers walked towards them yelling. And so we don't know what Mr. Beavers had, what was in his hand. Many people ran into the room. And so we would argue that the state has not met its burden beyond a reasonable doubt to get over that presumption of innocence. At this point, we're trying to speculate how this happened. And again, and I also go to possession of firearm by convicted felon, possession during the commission of a felony. Again, no witness, including Mr. Finney just now, has placed a firearm in Mr. Carmichael's hand. At this point, it's just speculation. Mr. Carmichael is the one who introduced the firearm. But there's no testimony whether Mr. Carmichael or Mr. Beavers had a firearm at this point. So we would argue that we will move for directed verdict because the state has not carried its burden beyond a reasonable doubt for all elements of every count in this indictment because they cannot prove how the shot was discharged in this case.
All right. Well, applying the standard required for a directed verdict, which is all inferences and potential factual findings in favor of the non-movement, I do not believe as a matter of law that the specific issues of an intent and identity as flagged by the defense are something where a judgment of acquittal is demanded by the evidence or a lack of the evidence. And I would deny the motion for a directed verdict.
Thank you, Judge.
And so we'd move on, Mr. Mitchell. I believe this is the time where I'd have a conversation with your client. And any reason we wouldn't do that now?
Sure.
All right. All right, Mr. Carmichael, a few questions I need to make sure I go over with you and that you understand. So the state is now rested, so it's the opportunity for the defense to present any evidence that you would like. And so my first question to you would be, do you understand that you have the right to testify and that if you want to testify, no one can prevent you from doing so? And do you understand that no one can make or compel you to testify? That is, you have a right not to testify if you don't want to. Do you understand that it's not your lawyer, but you personally that decides whether you testify or not? And you also understand that if you do not testify, I'm going to instruct the jury they can't hold that against you. You also understand that if you do testify, you're going to get examined by your attorney, but you'll also be cross-examined by the state. Do you need any more time to think about whether you want to testify? And do you want to testify? Do you personally want to testify or not? All right, I find the defendant has decided not to testify with a complete understanding of his rights. Mr. Mitchell, would the defense intend to present any other evidence, or any evidence rather?
No, Your Honor, we would just, for the sake of Mr. Carmichael's defense, we would like to accept the facts for the sake of presenting an affirmative defense of self-defense and accident for that limited purpose.
What do you mean by accept the facts?
In order to present a defense, we would like to just to put up, like, I guess, from my understanding from McClure v. State 306, Georgia Supreme Court 856, the Supreme Court stated that a client can accept the facts for the limited purpose of presenting defenses of self-defense or accident. And so I guess I wonder, how do we present that? Is that
I mean, McClure says you can pursue inconsistent defenses.
right?
I think where McClure becomes relevant is during a charge conference where you can ask for both theories. But if you're right now, the question would just be if you have evidence that you plan to present. Sounds like Mr. Carmichael.
Evidence to present.
All right, in which case we would talk about it at the charge conference.
Okay.
All right. And so it sounds like if when we would bring the jury back, defense would be resting
Yes,
and we'd begin with the charge conference.
sure.
All right. So timing's a little awkward. We'll see. Maybe we just do 10, 15 minutes of the charge conference, then bring the jury back halfway, give them an update of where we are. But I would think, actually, first I would ask, is the state planning to both do an opening and close?
Yes, Judge.
And any idea of how long that first opening would be? Are we going through, general principles of law and that are applicable and that sort of thing?
Would allow about 45 minutes.
All right. I think the natural thing here to do would have the state do their first opening, have the jury then break for lunch. We come back and finish the remainder of the closings after their lunch. Just because of where we are. So with that, let's at least get started with the charge conference here.
Want to do the rest
Yes,
first
sir.
or charge conference?
Does anyone need to step out for a minute first, by the way?
There's a quick
Okay.
recovery.
All right, well then let's do this. Let me get the jury in, have this defense rest, and then we'll tell them we're going to need 30, 40 minutes for a charge conference, perhaps less, but I'll also give you all a chance to kind of break and look over your notes. So Deputy Scott, if we could just bring the jury back in for a moment, you can tell them not to get too comfortable. I've already given them 2 of them. Yeah, that should be it. She can have that. That's fine. If you can, and I think Liz usually comes out here to edit up. Want to grab? Say what? She just edited them on that computer. I got it logged in here.
Jerry. Yes.
Thank you, Deputy Scott. Please be seated. All right, members of the jury. Now that the state has rested their case in chief, the defense has the opportunity to present evidence. Remember, of course, the defense has no burden of proof and does not have to present any evidence if they choose not to. And so with that, Mr. Mitchell, do you have any evidence to present on behalf of the defense?
The defense rests, Your Honor.
Okay. So members of the jury, at this point, the evidence in this case is closed. And so now I have to confer with the attorneys to talk about the law that applies to this case that I'm going to read you after closing arguments. That process takes about 20 to 30 minutes at least for me to get the law finalized. After we're done with that, we begin closing arguments, and each side is entitled to present closings. And just the way it's kind of working out here, I think we're going to shoot to try and begin closing arguments. We'll pause, let y'all and everyone else break for lunch, and then come back to finish closing arguments after lunch. So that's the roadmap. Still got a little bit of a wait before we can start closing arguments. We'll be working while you're in the back. Please bear with us. All right. Thank you. All right. We'll be off the record, council, if you need to step out for a few minutes and then come rejoin us when you're ready.
What's the judge? She gonna be that, she gonna be. Yeah. She gonna make it out happy. They did it. Yeah. Yeah. I don't know if you're reading, you're reading the transcript. They were asking questions about what she said. She said that she was asking questions about it. You got a copy?
You want a second?
Please.
Back.
And the deputy is also giving the defendant a copy to take with him to the jail.
Thank you.
I mean, the witness, not.
Okay.
Requested, but I think there is one.
I needed it.
Said you what?
I didn't think I needed it. Guess I was a little rusty.
Yeah, during time.
Yeah, yeah. You can purchase it, whoever that company is, I think. Yeah. Yeah. Really Nancy. Hmm.
Do you see it? You don't have anything?
Hmm.
You don't have anything?
No.
Yeah, we delete that stuff. I'll skip.
Yeah, they do. Question.
Okay.
Started a version 2.
Yeah. I'll stay adamant because sometimes, it may not update right. All right. Did we see our Deputy Scott? All right, Deputy, do you think we can give a knock, see if, I think Deputy Scott may be in the back, and we can need to bring out Mr. Carmichael again. Okay. Ready? We're back on the record. All parties and counsel are present. Ready to begin our charge conference. I provided counsel with a consolidated version that contains both parties' request to charge as well as some additions that I've made. I've labeled a copy as Courts Exhibit 1, and I'll tender for the record for anyone to follow along. And as for the way to proceed, I'll just would say that this will be somewhat informal where I'll proceed through it with any thoughts and alterations in real time. Any point, any party wants to weigh in, feel free to stand, object, make yourself heard. Otherwise, I'm going to keep moving forward. We'll pause on the ones that merit more discussion. And so with that, diving in, I believe we've got our intro pattern here on the indictment tailored to the specific counts. I'll note that I'm going to give them a copy of these instructions once we're finalized, cleaned of all the titles and everything else, just as a summary of them all put together when it's finalized. The remainder on here, you can use Courts Exhibit 1 if you want, and then give that back to our court reporter. We have the pattern charge on presumption of innocence. There's a strike through, which we can revisit when we see how the remainder of the pattern goes as to affirmative defenses. And we'll come back to that. Otherwise, I would give it as written. Page 2, I believe grave suspicion was requested, but reviewing the case law in this particular case, I was not inclined to give it, as I believe the reasonable doubt instruction does adequately convey the principles, and it's been found unnecessary before.
We would just object to that charge.
All right, preserved for the record, but overruled. The remaining, I'm just going to go to ones that I think I'm flagging for you, but at any point, if you need to go back or raise anything else, feel free to. Evidence generally, I would strike anything about judicial notice. I did not take anything of judicial notice in the parenthetical, but we did have some stipulations, so we'll include that. And on that note, the stipulations pattern charge, that was Exhibit 155. So the way I would tailor that one is the parties have entered into a stipulation that has been approved by the court about regarding Exhibit 155. Instead of reading it again, we'll just reference the exhibit, and then I'll give the remainder of that pattern instruction. I'll turn to page 3. We've got direct and circumstantial. And we've got a defense non-pattern request here on circumstantial evidence. All right, and I think what this is a common statement of law found throughout the case law, but I believe it's already included in the long version of direct and circumstantial evidence in paragraph 3, where we talked about consistent with the theory of guilt, but exclude every other reasonable theory. And so I wouldn't be inclined to give the non-pattern because it's included within the pattern, the long version. Mr. Mitchell, anything to add there? Okay. Credibility of witnesses, pattern charge, which I will give. You'll see our notes where some of these requests don't appear to be the latest versions of the patterns. So unless you have some other more particularized argument, the strike-throughs would indicate where we are with those. Beginning top of page 4, witness attacked. This is where it gets into specific things that can be highlighted of how someone can be impeached. We can tailor this. We also have the more broad overall encompassing statement of the witness impeached 1.31.45, which is credibility of a witness can be attacked by disproving the facts to which the witness testified. So one approach can be just to have that sentence just encapsulate all of these kind of arguments, or we can sit there and tailor it where we could talk about bias. No specific instances came out, but criminal convictions did. So if you want to have that highlighted, we can do that. Any preference from the state?
You said criminal convictions did not.
No, it certainly did. Yeah.
The state doesn't believe that we have to go through each and every one of them. I think that the sentence that you just went over is adequate enough as far as the state's position.
Any position, Mr. Mitchell? Really, the only one applicable here would be criminal convictions. So if you want to highlight that as something that can be used to challenge the credibility of a witness, I think that's what that pattern gets at. Certainly something you can argue regardless. And
We don't mind it being included. We would like for it to be included.
you would want it to be included. Okay. All right. So what we would do there to tailor it, I would just in 1.31.40, I would just say in determining the credibility of a witness, you may consider where applicable evidence offered to attack or challenge the witness's credibility. This may include evidence of, and then only the last bullet, criminal convictions, because the other ones I don't think came out. And I'll just say that's generally criminal convictions. Actually, I'll just leave it at criminal convictions, since I think the only ones that came out were felonies, right? All right.
If it's $1 million.
All right. And I would just leave out witness supported, because we didn't get into character of truthfulness or lack of bias. So moving on, we've got witness impeached, prior statements, and expert witnesses, which are all the pattern charges that I don't think need any tailoring.
You think you're leaving out witness supported?
I didn't see any of that was applicable. Okay, that's fine. All right, so yeah, I was leaving that out. I'm now on page 5, just looking at pattern charges here. And we're on defendant's choice not to testify, I would take out the italicized and just have it start with the defendant does not have to present any evidence nor testify. And then all the other things that talk about a defendant's statement come out. I believe I gave some limiting instructions about the evidence early on. And so I would say sometimes evidence is admitted for a limited purpose. And this would also include, I didn't give a limiting instruction on it, but this would apply to the convictions, that's only supposed to be considered for that element, not for any other reason. So sometimes evidence is admitted for a limited purpose or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose or only for the counts for which the evidence is limited and not for any other purpose. I would strike the pattern on other crimes. We didn't have anything formally in the way of 404B evidence. So hearing no objection, we also have at the bottom of page 6 the prior difficulties pattern. Do we believe there's some evidence, that's an instruction we should give here?
Your Honor, the state would object, there was no evidence that came out in trial that these two individuals had any prior difficulties between each other. The only evidence came out was that the defendant thought, which he was wrong, that the victim stole his drugs, but there was no prior difficulties between the others. Actually, the state specifically went into testimony with witnesses that they didn't know of any issues that they had. They actually knew they didn't know each other or that they talked in the store, but that was it.
Anything going along the lines of prior difficulties, Mr. Mitchell, that
I
you recall?
agree. But initially we were told that the Valero would come in to prove prior difficulties. And that was my motion to exclude because there wasn't anything dealing with those two.
I may have been the one to throw that phrase out there. I think they presented it more as a intrinsic evidence and showing motive. So where that line starts, where something becomes a prior difficulty, but before it becomes parting the story of the crime.
Prior difficulty coming.
Okay.
in one day.
All right, I'll remove it then. And we'll go over to page 7. And here's where we have a specific instruction on prior convictions. And I'll note here, you have received evidence of prior convictions of the defendant. And I might double this one up just to make the distinction clear. So here's what we'll do. Well, the first one will just be the defendant. You may consider this evidence only insofar as it may relate to the required element of conviction of a felony for the offenses in counts. I believe it was
7 and 8.
7 and 8. And then we'll copy that pattern a second time and say, you have also received evidence of prior convictions of a witness. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness.
I believe 3 and 4 as well for the defendant.
Okay, good point. We'll add in that as well. And now, because this is explicitly out there as you can use a conviction to attack a witness and their credibility, do we still actually need that old impeached on top of page 4?
If you're asking both of us, Your Honor, the state would say no because you explain it later on.
Right. Well, no, you'd already said we don't need it. So this is more to Mr. Mitchell.
Yeah. You're saying,
We could,
are we still at 1.34.30?
No.
right? So that's what we were working on. And now because we have a specific pattern highlighting that they got prior convictions that can relate to credibility, we'd already discussed that in another pattern, the 1.31.40 at the top of page 40.
Well, the only issue is just when we talk about impeachment or attacking a witness, I think those titles are different. And so when we're dealing with a witness, I think I would just ask that both be included just because we're talking about attacking or impeaching a witness impeachment, and then
They're not going to get the titles, mind you, by the way. We take out all the titles. I would say if you prefer one or the other, we'll keep one, but otherwise we're kind of saying the same thing twice.
okay, well, the newer one is fine.
Okay, so where we double it up, we'll take the witness version of that and put it in the place of the witness attacked, old impeached. And in fact, in terms of the sequence of it, it'd probably be better to have 1.31.45 witness impeached, the overall, hey, you impeach someone that's proving their facts, go first, and then you get more specific talking about criminal convictions. So flip the order there. All right, and then back on page 7 where we left off, we have limiting instructions, which we've already addressed. That was requested by the defense.
From this whole impeachment thing, can you just read the way you would say it for the witnesses?
For the witness, it would be along the lines of 1.34.30 at the top of page 7, which was you have received evidence of prior convictions of a witness. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. All right, so I'll leave out the defense request for limiting instructions that we had already addressed, I believe, or conditional evidence, rather. We didn't really have any conditional evidence that I recall. And that takes us into identification and the factors of identification is, and this whole series of pattern charges on identification, is that still the request of the defense to charge that?
I think the state is required to prove these elements, and so we would just argue yes.
Okay. And so if we'll include the pattern there, and on burden of proof, we'll strike out the parenthetical or that the defendant was a party to it and just keep it at that. I turn to page 8. There's another parenthetical for or there was a party to it, which I would strike. And we get to character of the defendant. And this is a defense request. Are you still asking for this instruction?
No.
All right, so the defense is removing that request, and so I would strike that from the charge. And from here, we move into more offense-specific charges. We've got definition of a crime. I'm striking omission or criminal negligence. That's not an issue here.
Well, I will say, if I go back to the character of the defendant, it wasn't as if we brought it out from the defense side, but it seemed like that was an essential question a lot of the witnesses responded to about a calm demeanor or how was he? So, you know, I would ask if we can still include that character of the defendant.
Well, if you read the pattern here, what this is focused on is not so much, demeanor at the time of the incident or in the past. It's character traits that relate to culpability or morals or values, and again, to show that he acted consistently with that character trait. And it has to come from, I mean, that's just how that pattern is, I think, what that's designed for. I mean, I see your point that you're saying whether he was calm or he's always acts calm. I didn't see that these are kind of two separate spheres. But if you have, I'll let you, anything else you want to add on that?
Yeah, what I would add is that there were witnesses there, so he's always calm and connected. That's the type of person he is. And I think even Mr. Park said something to the extent that he'd never go out looking for a fight, or he's not really that type of person to do that.
Okay.
And so
that was introduced, and that was actually introduced on.
I think Ms. Hannon would say he's always calm, something like that.
All right, Ms. Hall.
Judge, the evidence that was presented at trial is that trenches within Ms. Hannah's hotel room, and this defendant looking for him, which means he's been looking for this crime. What I'm reading this 1.37.10 is saying is that he's a calm person, and in that day he acted calmly when he shot and killed our victim. But that doesn't even make sense here because the evidence didn't present that. They were saying that two people actually, Ms. Lindsay said that he was calm, but he was calm scary, which that was her describing that he is, the way he acts as a calm person, but that had nothing to do with how he executed this murder. And then the other person was Mr. Parks, who said that he doesn't know him to go looking for a fight when he took him to the fight that he was looking for that night. So it just doesn't make sense for this to even be in. It actually doesn't make sense for the defense, but if they want it, we'll explain it in our closing, but it just doesn't make sense because this is more so he's a mean person, and on that day he acted consistent with being a mean person, and that's not what we had in this trial.
I don't know whether they're saying you're mean or not mean. I think it's just.
Well, I just chose the one.
Yeah.
Kind of.
Yeah. So essentially, a character trait doesn't mean you conform. It's up for the trial fact to decide whether that person.
Well, I mean, look, I'll point out, because I made a note of this because I thought it was opening the door where you asked him specifically on cross, Mr. Mitchell, you asked Mr. Parks, have you ever known him to be a violent person? And he said, no, he's a good guy, and said that he doesn't start fights. My note here was that I thought that opened the door to character, and which would make this charge applicable, which he wasn't confronted with that on redirect of, you know, how do you come to form your opinion? Would it change your opinion if you knew about all these prior felony convictions and whatnot? But I do think there was evidence introduced through Mr. Parks relating to character in that sense. So, any response to that, Ms. Hall? Okay. That being said, it's not that doesn't mean, Ms. Hall, that you can come here and just start giving your own personal opinion of what his character is. It could be that, you know, Mr. Parks may believe that, but clearly some other things show that that's not the case. So the focus is solely on Mr. Parks' opinion of his character and why that is or is not accurate. Okay. So we'll include character, and we'll tailor it to say evidence of the defendant's character. I'll just keep the trait undefined and let them recall. But and it could touch on multiple different things, but it's evidence of the defendant's character, if any, has been presented to show that he acts consistently with that character in this case. That can come in the form of the opinion of another witness. We didn't hear any reputation or conduct. So it would just be that evidence would come in the form of the opinion of another witness. And then the final sentence, you should consider this along with all the other evidence. All right, continuing with page 8, we've got intent. Why is this strike? Let's take out that parenthetical or yes, right there. All right, we had the last sentence of intent struck through because there's some notes of caution in the pattern charges related to specific intent versus general intent crimes. I don't think that's applicable here, so I would actually undo that strike and keep that sentence in, unless any party wants to be heard on that. All right, you've got a then I'll move on, not hearing anything else. You got a non-pattern request about weapon. That's coming up later. So we'll strike that at this point in the charge. Presumption of intent. And we've got the pattern there as well. So you've got the presumption of 1.41.12. Are you asking for that one still?
Not really.
Okay, then I'll strike it.
Something I don't have in my pattern chart.
All right, then we'll keep that out. We come to accident. Are you still requesting accident?
Yes, Your Honor.
All right. State want to be heard on accident? Or have a position on accident?
Yes, Your Honor. We will object to accident being given. As you're aware, Your Honor, I was a part of the first trial. The same evidence came out in the first trial, wasn't appropriate then. We argue that it's not appropriate now. Defense wants to argue that what happened there was an accident when there was no testimony that from the defendant or anyone else that the defendant went to this place and somehow his state of mind was that he went to do something else and something else happened. Like, we have no evidence of that. We have evidence that he was at the store mad about drugs, but there's no one that came in here and testified and presented evidence, Your Honor, of an accident or a possible accident. So we will object to accident being given as a charge. And Your Honor, the state also has Bronner v. State and Baldwin v. State, where the Supreme Court has ruled on this in both of these cases. One being that if there's a lack of criminal intent, criminal intent or criminal negligence, in this particular case, Baldwin v. State, in that case, the defendant, just to give you a summary of that case, the the incident happened where the defendant was present on scene. He had a gun. A witness saw him with a gun. She didn't want guns in her house, so he removed all the bullets from a gun. Moments later, he shot his girlfriend and killed her. The court ruled, the Supreme Court of Georgia ruled that, absent criminal intent or criminal negligence, that, the court did not err in not giving accident, because in this case, in this particular case, hold on, I just give you the headlight, Your Honor, I'm sorry. So in, Barnaby State, which is the Supreme Court case, 2021, under Georgia law, in order to warrant a jury instruction on defense of accident, more must be shown than simply an unintended or undesirable outcome. There must also be evidence of an accident. I'm sorry, there must also be evidence of absence, criminal intent, or criminal negligence. The evidence justifying the accident defense instruction needs to only be slight. Here in our case, we didn't hear anything about an accident. We heard Tiaja say that there was a fight, and when I had her go into what type of fight, she said that Trenches was defending himself. She saw that the defendant was punching him and Trenches was defending himself.
That's not what she said.
That is exactly what
Well,
she said.
we're not going to interrupt each other. I'll give you a chance, Mr. Mitchell.
But beyond that, Your Honor, no one else actually said they saw the fight. Even the other people that was actually at the door, Rail testified, Mr. Lawrence testified that when he got there, everything had already started. He didn't see who threw the first punch or what was going on. He just heard a gunshot. Here in our case, we didn't have any evidence of any type of accident being presented. We didn't hear from the defendant of his state of mind of what happened in that moment, why the gun may have gone off, which is what the defense has been trying to put in the trial the whole time, coming from his words, not any of our witnesses. And in furtherance of that, Your Honor, in the other case, Baldwin v. State, that's also a Supreme Court case that was ruled in 2023. It establishes the same thing that I'm sorry, Your Honor, I'll just say the first one was the one that's relevant to what my argument is right now. Brown v. State, the 2021 Supreme Court judgment for accident.
Okay, Mr. Mitchell.
Yes, Your Honor. Sort of like what I was alluding to earlier about accepting these facts for the limited purpose of arguing accident. Again, there's no presumption. There can't be a presumption of criminal intent on behalf of Mr. Carmichael. No one said they saw a gun. No one said they saw him aim it. No one said they saw a muzzle flash. No one said they knew how it discharged. A gun does not always have to be discharged by pulling the trigger. All we heard is they said it just went off. And we didn't see how the shot went off. There's only a single gunshot. Mr. Parks testified that he didn't know, he thought it sounded like a firecracker. And so because the state has not proven beyond a reasonable doubt, well, that's our argument, I'm sorry. But the state has to prove beyond a reasonable doubt that this was an intentional firing of a weapon. They don't have a weapon. They didn't test the ballistics. There's no soot. There's no stippling. The medical examiner said there was an indeterminate range of fire. There are other reasonable explanations for how a firearm can be discharged. And similar to what the state is saying, slight evidence is sufficient to raise an affirmative defense.
So what is the slight evidence here?
Slight evidence is that Ms. Hannon said, it came out from the detective, that there was a pistol whip. Somebody got that he was pistol whipping him. And so if that came out as far as evidence is concerned, a pistol whip is not the normal manner that someone would use a firearm. And so for a firearm to be discharged through a pistol whipping action, that would suggest there's an accident. It's not that he's saying, I think what the state is saying is that this was, well, I don't know what they're saying, but essentially a person shall not be found guilty from Georgia law 16-2-2, effect of misfortune or accident and guilt. A person shall not be found guilty of any crime committed by misfortune or accident where it satisfactorily appears there was no criminal scheme or undertaken intention or criminal negligence. Intention is still an element that the state has to prove. They have to be able to prove that this was an intentional discharge of a firearm. And so without that, and like I said, we do accept those facts, so we would be able to present that defense of accident and self-defense on behalf of Mr. Carmichael. And like I said, that slight evidence is the absence really that no one knows how the gun was discharged. So how can we assume that it was a trigger pull?
And so I'm clear of the prior proceeding, the accident was not given and self-defense wasn't given either.
Nothing
Right.
was given.
None of it was
Yeah.
given, Your Honor. There was
But we
no-
asked for
Well, I'm still talking to Mr. Mitchell real quick here. And I know you asked for it. And so during closing, you weren't able to make any kind of alternative argument. You focused on reasonable doubt, intent, lack of evidence, that sort of thing, right?
right.
Okay.
It was more so that it wasn't him. See, last week, the whole accident defense and stuff, he still was able to argue at closing that he wasn't there, the defendant. So he focused more on this wasn't the defendant last trial versus this, what he did in this trial was, that we didn't see a gun, we don't know how it went off and all that. That was more his focus this trial, but there was still no evidence that there, and Your Honor, if I can highlight the law that I gave you on 1005, conclusory claims by the defendant that he didn't mean to do it, which we don't have that, Your Honor. Nobody came here and said that this defendant didn't mean to do it. And
Do you have any cases on accident where the defendant did not testify? Because all the ones I've found, the defendant testifies.
no, Your Honor, but the state's argument would be that, this case will be relevant because where's the information coming from? The information is simply coming from the defense counsel's questions. He's saying no one saw a gun in his hand, no one can put it in his hand. However, we know for a fact that Quentin Beavers was shot in that moment. And we brought in the people that were present at the door, minus a few people that couldn't access him, to say that they didn't shoot and the people that were around them didn't shoot.
But at the time of the gun goes off, the eyewitness you have, Miss Hammond, didn't say she saw the gun at the moment it went off.
She said she heard it, she ducked down because it was loud right by her. She said she was standing there, she knows the person who approached her is the person who shot him. She just never actually saw a gun.
And it happens at close range.
It happened at close range.
We see a video of, them very close to each other, struggling on video, right?
And the state's argument would be that supports this law that we presented is that what the court ruled was that there must be some other evidence showing that the shooting occurred in absence of criminal scheme, undertaking intention and criminal negligence to authorize this charge. Your Honor, we watched several videos where this man thought our victim stole his drugs. He went and talked to a clerk. They claimed that the clerk may have said that he took the drugs, confirming that. He went and got a gun because the people that we did bring to testify said he didn't have a gun on him. He went and got a gun. Then he went and located our victim. This is a part of a scheme. This is his intention. And when he was confronting our victim, he was standing there less than 10 seconds before he shot him in the head. This is a scheme. This is a plan. This is not absent of anything that the law said it needs to be absent of. This was what he intended to do, which is what we've proven in the evidence that we presented. It wasn't an accident. There's no one who said that, in the moment he was, oh my God, it went off. There was no testimony of an accident. Regardless if we could see a gun or not, we know he didn't shoot from his finger. We know that there was a gun present. He took the gun with him is why we don't have a gun to test. It went with him. And the state's gonna argue in closing that you can see him pull out the gun. We're gonna zoom in on the video. We'll show what we believe to be a gun. That is our right. The video is in. But as far as this accident claim, there is no evidence. There is no slight evidence of an accident. No one, even the people who testified, they said they were fighting. They didn't say a gun fell out of his pocket and it went off. Somehow shot Mr. Beavers in the head. There was no slight evidence of an accident in this case.
All right. Last word, Mr. Mitchell.
There was slight evidence of the testimony that there was somebody that he was being pistol whipped. And there was slight evidence that there was only one gunshot that went off, and that slight evidence that no one saw how the gun was discharged. And none of the witnesses could testify of how the gun was discharged. So for those reasons, we would like to request that accident be included in this.
All right, let me come back to that one. Mere presence, are you still requesting that one, Mr. Mitchell?
Yes.
All right, I mean, I think usually that's dealing with, you know, like a conspiracy or a possession type case.
Well, I think for my argument is that being present, again, if.
No, that's fine. I'll give that
I
one.
put it there. I mean, I understand.
I'll give that part. I'll give that charge as written. Move on to malice murder. And we'll come back to some of those strike throughs depending on these affirmative defenses, because accident is an affirmative defense. It's not the same thing as intent.
Okay.
But otherwise, I'd give the pattern charge as written. We have a non-pattern request on malice. I think that's already covered by the pattern charge.
Okay.
Same with premeditation. That's not one I'm supposed to be giving. And some of these other defense requests as indicated in the consolidated version. Which takes us to the bottom of page 10, where there's a request for voluntary manslaughter and involuntary manslaughter. Anything on that, Mr. Mitchell?
Yes, Your Honor. If there is any slight evidence that, again, this is a fight, this kind of negates an intention to take the like murder or voluntary, you know, those are different grades of homicide. And so it appears there was a fight going on, you know, even perhaps a mutual combat. Ms. Hannon testified that he came towards the door yelling, and then there was a tussle or there was a struggle. And so we would argue that based on a fight happening, and then like that was the sudden passion of provocation of Mr. Carmichael fighting, and then a killing happens after that.
All right. Well, as it comes to voluntary, I don't think I need to hear too much more argument on this. For it to be the result of this kind of a mitigation, it has to be sufficient provocation, and I don't think we heard any evidence of that. We certainly didn't hear any evidence of Mr. Carmichael's state of mind from him, and indicating that it would be rising to that level. And I think involuntary would be inapplicable as well. So I would the objection's just, you know, preserved, but I would not give voluntary or involuntary manslaughter. I don't think there's been any evidence that would come close to those elements. We also have the array of charges at the top of 6 is indicated by self-defense. And in the same way that we've talked, you know, the same issues that go along with voluntary manslaughter for the self-defense request, there has to be some evidence that Mr. Carmichael has both a subjective and objective reasonableness that he was acting in self-defense, and or that the alleged victim here presented some kind of threat to him, and there's just nothing along those lines that's in the evidence that I can point to. Mr. Mitchell, do you have something you can point to other than just we don't know what happened in that room?
Yeah, well, what I would point to again is Ms. Hannah's testimony that Trenches came towards them yelling and screaming. That was her testimony. And Mr. Carmichael, again, then you see a struggle ensue. We don't know, you know, there's an assumption on the state's part, and that's their right to argue that Mr. Carmichael is the one with the weapon, but we don't know what's going on in the room. We don't know what the defendant sees as he's coming towards him. So we would argue for, as far as self-defense is concerned, that there is some slight evidence that he was defending himself from an imminent threat of whatever's in that door. We don't have that camera angle of it that was in that door. And so not having that camera angle makes us assume nothing's going on, but we don't know what's going on. And it's the state's burden to be able to prove beyond a reasonable doubt that there wasn't a threat, and they can't do that as well.
Ms. Hall?
Yes, the defense, he keeps misstating the evidence that was presented at trial. Ms. Hannah testified that when the defendant got to her door, which she was standing there, she is the person who brought in that evidence. Even though we don't have a video camera pointing directly into the room, she stated that the defendant asked Trenches, Mr. Quinn Beavers, our victim, where's his SHIT? His response was, I don't have your stuff, as he's walking towards the door. Not that he's running at him in an aggressive manner, that he has a gun on him. I specifically went through these line of questions with her. Is there a gun in the room? Was there a gun on his person? Was there a gun in his hand? Was he fighting? Was he yelling? He was confronted. He responded. He has all right to respond to someone accusing him of taking drugs. But she never said that he was running towards the door as he was finna attack the defendant or any of that. She is our evidence. She is our eyewitness evidence who was standing there, who's giving us a recount of what happened. I think that self-defense is not appropriate here.
Well, there's some other principles of self-defense that come into play here, which is in response to Mr. Mitchell's argument, words alone aren't going to be enough for self-defense unless those words themselves can be articulated and show the need for self-defense. So just because they were arguing, that's not going to be enough. The fact that there was a struggle, that's not going to be enough to escalate it to the use of deadly force in response to a struggle. There has to be a struggle indicating a potential fear of deadly force, and so the mere argument that we don't know exactly what happened, that to me doesn't rise to that level of the any evidence standard.
Okay.
So again, it's preserved and but overruled. I don't plan to give self-defense, but I'll revisit the accident charge at this point, which is it's another one that's right there on the line, but it's what's pushing me over and is the fact that it is a one gunshot case. They're in close proximity. No one testifies that they saw exactly where the gun was when it went off. We know what Ms. Hammond says happened right before and what was said and what happened right after, but at the moment it's fired, we don't have that kind of direct evidence. And to me, that with the standard being just a slight, meaning scintilla, meaning any at all, I think an accident charge is appropriate here. So that is an affirmative defense, which means that we'd give the accident charge on page 9. Also back on the first page, there was a strike through on the presumption of innocence, and that strike through would be included now, and we would only strike the except insanity. We don't need to have any reference to insanity. So when a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. And then in the malice murder charge on page 9, where there's those strike throughs, we would just include it as the unlawful intent to kill without excuse, since accident would be a excuse. From here to the end, we left off at the top of page 11. We get into aggravated assault. I believe that is tailored to the indictment. Same with possession of a firearm, tailored to the indictment. At the top of page 12, do we have the redacted indictment that you would plan to give to the jury, Ms. Charles?
Yes, Judge.
And so we're omitting the details of the type of offense. So we're going to have to change that at the top of page 12. And so we'll just change at the top of page 12 after, in the first one, after having been convicted of a felony. We're not going to have that a violation of the Georgia Controlled Substances Act.
Okay. Thank
No,
And I think the stipulation is going to cover that parenthetical in bold.
would you like to review the?
That's fine. If you've got it, then that I'll look at it when you compile your evidence. Okay. I'm going to pause right now. Deputy Scott, at this point, I'm told lunch is here for the jury. If you can just tell them to go ahead and get started. And, I think we'd be able to start closings. I think we could tell them 12:30, maybe a hair earlier. But if you could just tell them they should go ahead and get started with lunch. Let us know if any of them decide to leave the building though instead. All right, continuing with our charge conference here, we've got just the pattern charge on venue, and throughout here, just the other kind of wrap up pattern charges that I would give as indicated here.
Oh, well, I guess in light of I think you did talk about those non-patterns. But on page 11, what did you say about the non-pattern request?
About a deadly weapon?
Yeah.
I'm not quite sure what we're getting at
Just
there.
about, deadly weapon may be used so as not to raise presumption of malice, but to leave intent as a question of fact for the jury. Thus, to strike one with the barrel of a pistol instead of shooting victim with the weapon, or strike with the handle of a dirk instead of with the blade, would not be the ordinary way of using such weapon to kill. Intention to kill would be a question of fact rather than of presumption. And so we would like to have Mr. Carmichael include that request.
All right, and so if the manner of death is a gunshot wound, what's the argument here that, why is this relevant that you can use a deadly weapon in non-traditional ways?
Well, again, the argument is more of there's an accidental discharge. And so if it was used in a manner it's not ordinarily used, then this is the way the gunshot occurred and not through the normal way. I think that's how I interpret it, that it did not occur the normal way a gun is used. So that's why we requested for this charge to be included.
Wasn't that what's said in the pattern right before? A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon.
Yeah, but just for our sake, we would just ask for that language to be included, to be able to expand more about, even if you would say maybe used so as not to raise presumption of malice, but to leave intent as a question of fact for the jury. We'd like for that language to be included in, like for all of it, but definitely as far as presumption of malice, but to leave intent as question of fact for the jury, in light of that.
All right. State want to be heard at all?
This they would object. I mean, it's clear that it's already stated that they would recommend the language should be used. And I think that what defense is trying to get the jury to take back to them is that the gun, even though he brought it to the fight and intended to use it, they have discharged when he pulled out his pockets. He wasn't going for that when there was no evidence of that. That's why his accident thing is an issue, because that's not what happened. So he's trying to add on that detail of the use of a gun to try to argue that in closing when that's improper, because where was the evidence that as he's pulling it out, it goes out? There's no evidence at all that, because you could be pistol whipping a person with a gun. People use it that way too, right? And so he's going to try to argue, which is what I addressed earlier in trial. That's why that statement was important, because now you want to use that statement that you didn't want in originally to say that, oh, while he's being pistol whipped, because that's what we heard, the gun accidentally went off. So to use this charge to support that, I think is improper, Judge.
Well, I think my concern as well is that it's simply repeating principles we already have. Another one would be that we already have the pattern charge that we'll be giving, that there's no presumption of criminal intent, period. And that's what this is expressing, and specifically in the arena of firearms. And so all the principles of law that you need to argue this point have already been said. And I think the charge to the jury is supposed to avoid being repetitive. It's also supposed to avoid being argumentative. And I think it's going to sufficiently cover these principles of law. So preserve the objection, but I'll overrule that non-pattern request. That takes us through the charge. Were there any other objections or observations or anything else to be preserved for the record on behalf of the state?
We just stand by the original objections, I mean, not original, but the objections we already had. Yeah. And that, nothing else.
All right, then we will prepare a consolidated version if I catch anything while we're doing that. And we'll have that to you. I'll mark a copy as Court's Exhibit 2 to go back with the jury. And in the meantime, again, we need this, a clean version of that stipulation, printed, signed, marked as an exhibit, because that's going to go back with all the other exhibits. Perhaps, well, you know, Ms. Charles is preparing her closing. Ms. Hall can start compiling the exhibits and that sort of thing, so we're not wasting any time once closings are done, so the jury can start their deliberations. I'll have the time indicated for both counsel again, like we did during jury selection, with how much time they have remaining for their closings. And otherwise, I would say we'll reconvene at 12:30. I already did that. And again, for the record, I'm tendering Court's Exhibit 1, which was the rough draft version of the charge we just went through. Anything else on behalf of the state, Ms. Charles? Mr. Mitchell?
No.
Okay. Then we're off the record. We'll be bringing in the jury at 12:30. I never tendered it? Okay. All right, we'll go talk.
Just adjust them. We'll break. Have that issue.
Yeah, it's gonna be at 12:15. You gonna come back in 15 minutes? You gonna come back in 15 minutes?
That's great. That's really great.
Ken.
A home.
Come back at 12:15? Yeah. Yeah, I need it. I don't want to. Let me get out of here. That's why I said 12:15. Don't fuck with. Y'all need, you need to do all that. You understand that? I gotta figure out how to get this for myself.
Check us if they don't say.
Oh.
That's what they
I hadn't looked at it.
good.
And just gonna get some stuff out.
Let me go to that one.
What y'all bring?
We ain't bring that. Something.
I got this shit on my toes. It's always coming.
It's fine. It's fine. Just saying.
I'm about. Was y'all standing here? Y'all need me to knock it up?
I think she gonna stay in here, so. Yeah, 'cause y'all leave my home. I'm gonna grab anything.
Good.
What do you need?
No, thank you.
Doing too.
Oh, yeah.
Okay.
Course house at 12:30.
Mhm.
Good, you
Yeah, I'm just making some changes based on the church conference. Huh. Yeah. Alright, cool. Not bad. Hey, sorry. Yes. I don't have the proper clicker to clean. Let me see, can I have one? My clicker is on. This is terminal. I just didn't have any.
I can hear two thirds. On Friday, I was off. I woke up, got accident. Just 11 minutes.
What? Ooh. I think you want to get something to eat. He did.
Sis. So I'm going to, yeah, man. Okay, you played it. All right, love you. Okay. Okay.
Is there anything to take off in filings?
It's one, the one.
The one I was asking you about? This one.
one.
I have to take all this off.
Is it not?
Yeah.
It's not, oh, it's, that one?
I think so.
Oh, okay.
I don't need the filing, I just need the certificates.
Okay. No, yeah, I was asking you about,
Take over.
It's on your disc.
no, well, see, it says 133. And
There's a disc that goes with that. The disc that I get, it's somewhere. I figure it out. There was a disc that I gave to.
13180,
That's none of
this
this.
131. You know, this is 132B.
So what's this?
So it says that it says 133. This is 133A. You said it had a 134, but I don't see them. But Mr. Wright is saying this is 134. This one, but
That should be 134.
No, I was saying that at first I thought the second page was 134, but when I looked at the number,
it's not.
it's not.
So I could pick it up.
Yeah. Pick it up.
And then we were saying maybe we could end it.
I went for the old exhibit box or whatever. And whatever was in that exhibit box is what I pulled back out, so
Oh,
I didn't create anything new.
okay.
So maybe if it's not that, it wasn't added.
I was thinking, I was thinking it out.
Oh, I need to give you an updated one because I. Can we just put everything on a flash drive and?
Yeah, that's how
Electronically?
yeah,
Yeah,
that's how you're supposed to do that.
yeah,
But I just can't log it with, to know what I have.
got it,
And I have to give you these two that,
got it.
but I just do it to make sure I have everything. So when I'm. And you don't know what I'm talking about. Cause it's like you move on, you know?
On to the next.
Yeah.
Oh. Oh, boy.
106. Hey. 106 is this. So what is it? A picture.
I pulled the wrong one, it should be this one from the 106.
Huh? Oh, so I just pulled it. So then we did a picture of the F-150X. I just saw it.
But that's on a 6A, B, and C.
No, I saw something in here.
Kevin, sleep videos.
I ain't very long up.
Yeah. No, 6, 8. Is a medium. Yeah. Yes. Some Negro what?
So 106.
Yeah. This is all audio. This is the. Sorry, this is videos. Video of what? Let me double check. The Economy Hotel.
Oh, you separated them?
I did.
Yeah. Where is it? Oh. Where's 108 then? Is it right to remember what we talked about?
For which part?
149 and
Some of the boards.
yeah, Kay already gave me I think it was this one today.
The maps.
Yeah, I should think I gave you that,
Yeah.
but the other two.
I see post about it.
Where'd it go? Got the verdict form thing.
Yeah.
Grab that.
Still can't press it yet?
No, I just need to get the driver installed. Sure, it wouldn't be hard. Keep forgetting to ask.
No, that's old. I didn't know this.
Oh, okay.
I just. That's okay. That's okay. I just used the old sleeve. Since we're gonna put it on a jump drive, I just figured this was
Yeah, yeah.
numbering.
Yeah. Yeah.
Thank you.
What you looking for?
No, I'm taking everything.
Thank you. You have 111?
Yes.
Do you need 109 and 110? I don't. You want the little envelope? The physical, yeah, I use.
what was, ask the, you get the, go through all, start yelling them out, and you took, it's good.
2 seconds, let me get my face ready.
Making sure I had it.
Thank you for giving me one.
Jason.
Is a medium.
I didn't know purpose.
It told you.
I got a million pounds.
It's
I'll
just,
just
it's
say
like, it's okay.
so.
They got it, I got you. There's two. Two is a medium.
Okay.
You put it in.
62. We'll start from that way, the.
All right, I think I saw Deputy Scott. Are you still out in the hallway? Yeah, if we could bring on Mr. Carmichael. Council, I've got a verdict form for you to look at. I forgot to cover that during the charge conference, as well as the consolidated charge, and I'll ask you about that once we go back on the record.
You need one more copy? It's fine.
Ready? We're back on the record. All parties and council are present. And I've handed a proposed verdict form to both sides. And if you've been able to review it, any objections on the part of the state or suggestions? Any on the part of the defense?
No, Judge.
All right, then that's what we'll use. I've also marked, and I will now tender Court's Exhibit 2, which is the consolidated version of the charge, which I've also provided to counsel and the parties. Any reason we can't retrieve the jury, Ms. Charles?
You need to just get this stuff. Do we keep that there or no?
You can if you're going to use it if you want, but otherwise, we need to.
I'll let you go through it, so it's all like, just put this stuff back up.
If you're done going through it, let me first just ask, Ms. Charles, anything to take up on your part?
No, Judge.
Do you have a PowerPoint you're hooking up?
Yes, I'm gonna put.
Okay, why don't you do that? And then Ms. her right is dealing with the exhibits and putting those in order. But I think we're going to have to relocate that.
Good, we fine.
Okay.
You're on mute.
Sorry, hold on. It's me, need to mute.
Yeah, would there be a break between first, her closing, the second defense? Because I'm only asking, wondering if I need to go ahead and tap into the Zoom, or if there'd be a break in between.
I would go ahead and try to get on. I'm going to do whatever the jury tells me. If they want to power through all the closings, then that's what we'll do.
Okay, I'm gonna-
I might need to figure out how to.
All right. So while everyone's getting situated, I think we can go ahead and have the jury start making their way in.
Yeah, but I didn't want to interfere with what they're doing right now.
That's what jury.
Thank you. Please be seated, everyone. Members of the jury, we are now ready to begin closing arguments in this case. As I mentioned to you at the outset, what the lawyers say in closing arguments are not evidence. And what the evidence is, we rely on you to make that determination. In addition, because the state has the burden of proof, they have the right to both open and conclude closing arguments. And so with that, Ms. Charles, the floor is yours.
Thank you, Judge. Ladies and gentlemen, it's been a long few days. We've had a lot of talk, a lot of information thrown at you. A lot of people have come through. And now, as Judge said, it's time for us to present our closing arguments. And we're going to do it in two parts. We will first go over some of the principles that we'll be asking you to consider as you proceed with your deliberations. And then ADA Hall will come and review the evidence of this case. Because fundamentally, this system of ours, when we're sitting across, that V, state V, fundamentally doesn't work without you. Without your careful deliberation, what you've all done this week to listen closely, take notes, and then go back and weigh the evidence based on the law that we'll instruct you upon today. And so we'll start with sort of some broad overview principles. We'll talk about your duty, some legal principles, the crimes that have been charged today, the evidence in this case, the case for the defense, which I submit to you is a bunch of distraction, a bunch of hypotheticals and speculation, a number of red herrings, all designed to get you to look the other way. And then in the end, we'll ask you to render a verdict that speaks the truth to the indictment in this case. And so fundamentally, your duty as jurors is to deliberate. You are bound by the instructions of the law the judge will give you. If anyone amongst you, once you go back, refuses to deliberate, it is your duty to inform the judge and flag that for the court. There are a number of things we're going to ask you to consider, and a number of things we're going to ask you not to consider. Everything inside of that box, you ought to consider. Statements you heard, expert testimony, testimony of the victims, if you heard any, the witnesses, the elements of the crime, motive to lie, all of those things that go to the charge itself, we ask you to consider. What you are not to consider is any passion, public opinion, whether you're unhappy with the police, unhappy with any investigation, any public feeling you may have about this case, sympathy for the defendant, sympathy for the state, prejudice, disagreements about the law, and penalty and punishment. All of those things outside are not for you to consider. Penalty and punishment is reserved solely for the court. You must only focus yourselves on what you've heard from the witness box, any physical evidence you've been presented, and any other evidence like the videos that we'll be going through again. In the beginning, we talked a lot about sort of reasonable doubt and what that means. Your job as jurors is to be fair and impartial. You're not to seek doubt. You are to honestly seek the truth. The truth as it's reflected in the evidence you've been presented with this week and last week. Now, defense counsel talked in open about the presumption of innocence, and that is absolutely true. There's a legal presumption that Mr. Carmichael, when he walks in, that the state has that burden to prove its case beyond a reasonable doubt. But it doesn't mean the defendant is innocent. It simply means, as the defense pointed out earlier, we need to review every element of every charge and match that to evidence in this case. And your verdict must be based on the evidence, not showing favor or sympathy to one party or the other. As we said, it's to weigh the evidence objectively. And objectivity comes with sort of this overarching principle of reasonableness. What makes sense based on your life experiences? What is the most natural result of a set of actions? It isn't based on something that's arbitrary or vague. And as I said earlier, you're not to seek doubt. And finally, it is not to a mathematical certainty. It's not 100%, and that is reasonable doubt. Reasonable doubt is a doubt for which you can put a specific reason. And if that exists, then you have that doubt. Now, we've used this sort of visual aid. It's been going around for a number of years in our office. And the reason we use it because it's very apropos to what we're doing today. It's a visual reminder. When you look at this puzzle piece, you can instantly make out what that is. That's a $1 bill. However, there are a few little pieces missing. But the same way you can look at it and come to that conclusion based on your gut is the same way we're asking you to decide this case today, based on how you decide the important things in your life, based on your common sense and reason. We're asking you to do the same in this case. It doesn't mean that every single piece fits in perfectly. What matters is you've seen the entire picture. And you can put together an entire picture to tell you what happened in that hotel room on April 5th of 2024, even though there may be. For example, a piece that's missing would be nice to have a video camera angle from the inside of the hotel room, but we don't have that. Does us not having that angle change what happened in that doorway? I submit to you, it does not. And as we go on, we'll talk about two sets of doubt. Unreasonable doubt, what does that mean? Unreasonable doubt, you've heard a lot of it through defense's line of questioning, comes from his conjecture, his speculation, the hypotheticals that he puts forward, the what ifs, injected evidence that doesn't exist, injected evidence that was unpresented. But again, calculating these hypotheticals and what ifs to get you to look the other way. It's classic misdirection. And we urge you not to fall for it, because ultimately, in law, there are two types of evidence: direct evidence and circumstantial evidence. And when we began this case, I talked to you about the snowfalls, right? That you could tell when it's snowing directly. And then we talked about when you can tell based on a set of circumstances when it snowed circumstantially. Under our law, both sets of evidence are given equal weight. One isn't graded higher than the other. So the direct evidence, you will see testimony from the witnesses, what they saw, what they heard, what they felt. All of the tangible evidence we're going to take back with you. The videos, you can ask us to replay multiple times. Look at it as many times as you need to reassure yourself you have come to the right conclusion that speaks the truth in this indictment. Review the physical evidence, review the photographs. That is all direct evidence that is going to lead you to a reasonable inference that speaks the truth to the indictment in this case. There's evidence of all of these people who took the time out of their day, out of the week. Some came unwillingly, some came because we had to get them here, but they are here and you heard from them. Shaniqua Jordan, Marcus Traylor, Kimberly Lindsay. You heard her through her words, through her videos, through the reading of her prior statement. Tiaja Hannon, Harrell Lawrence, Marquel Pascal, Tavius Finney, Gaurav Ambari, Dr. Rochelle Simon, the medical examiner, Special Agents James Burney, Detective Calvin Thomas, Officer Justin Miller, all of these people have no personal axe to grind with Antoine Carmichael. But they presented their evidence to you for your consideration. And I urge you, as you're looking at the videos over, remember that there is a time difference, which you heard about during the trial. The Valero gas station videos is a 3-hour difference, and the Economy Hotel is a 4-hour difference. So don't be caught up on the time inside of the video. Remember, when you're looking at 7 o'clock or 7:05, it's really real time in the 10 p.m. hour. And again, what is not evidence? Non-existent, unpresented evidence, any questions by the lawyers, as Judge said, statements by the attorney, and more particularly, as we get into a little deeper dive, conjecture and speculation by the defense. Because you will see, over the life of this trial, the line of questioning by the defense, and when I get done and defense comes and speaks to you, what they're going to argue to you has changed. The story has shifted. But some things fundamentally have remained the same. And those are the facts that you must weigh when you go back to deliberate. And let's look at some of the direct evidence that you will consider. Remember, you talked about the cell phone records. Those records that intersect between the Valero, the Economy Hotel, and the gas tent. Those are records that belong to Antoine Carmichael, and you see him from the very beginning of our interaction at the Valero gas station. He's on that phone. And so you know where that phone is, so is Antoine Carmichael. Identity is not an issue in this case. We know that man in that hallway wearing the same black vest, same black long sleeves, same jeans, white tennis shoes. That is Antoine Carmichael, otherwise known as Peanut, otherwise known as Nut. We know that to be him. Other evidence we know that is uncontroverted. The medical examiner. The medical examiner sat and testified, demonstrated to you there is a downward trajectory into the brains of Quentin Beavers. And what that means is the gun was above. Quentin, when he received that injury, was in a lower position than the shooter. Antoine Carmichael, we submit to you, was standing over Quentin Beavers when he was shot once into the head. And the fans will talk about, well, there is no soot and there is no stippling, but there's an extremely reasonable reason why that was, and Dr. Simon explained that. It's the dreadlocks. It's that thick patch of hair that would absorb the soot, would absorb the stippling. So you don't see that because she had to shave his head to get to the injury. Remember that as you go back to deliberate. And remember we said you can watch the videos as many times as you like. Defense will get up a little bit later on and tell you this was a whoops. This was an accident. He didn't mean to do it. Ladies and gentlemen, you don't accidentally put a shot in someone's head in a downward trajectory accidentally. Not when you're standing above them, grabbing onto them, not when you're confronting them, not when you've armed yourself to do exactly this. This was a directed shot. This was a deliberate shot. This was a choice Antoine Carmichael made that day, and that choice, and all of the choices he made that night ended in the death of Quentin Beavers. I remember when I said in the beginning, I said, you know, one of the last few things that Mr. Beavers tried to do as he lay gasping for breath, brain is swelling, tongue is heavy. Officers asking what happened, who did this? And this is a video you can play for yourself. The state submits that when he mumbles to the officer, if you look at the phonetics on his lips, he is mouthing that word, peanut. And you look at, just before I play that for you, where his head is. When Quentin Beavers came to that hotel room that night, he was getting ready to settle in for the night. He wasn't planning a confrontation. He wasn't anticipating a confrontation. He was chilling, as Ms. Hannon says, listening to music. They were about to kick back. And then suddenly he's confronted at the door by the defendant. And when he stands up to defend and repel this confrontation, he gets shot in the head.
Talk to me. Do you know who did this? Just stay with us, okay?
You here with us, man? Huh?
Talk to me. Do you know who did this? Just stay with us, okay?
You here with us, man? Huh?
Talk to me. You know who did this? Just stay with us, okay?
You here with us, man? Huh?
Peanut. 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 Those were the last few words uttered and mumbled by Quentin Beavers. And so we get to where the story starts to shift, according to the defense, that this may have been accident. But what does the law say about accident? The law says an accident is an event that takes place without foresight or expectation, that takes place or begins to exist without design. So you cannot arm yourself with a firearm, come from the Valera because you think someone is taking your drugs. You drive to your room, your friend's room, get your gun, go back down within 10 minutes span, confront somebody with a loaded fire and say, didn't mean to do it. I couldn't foresee that my actions could end with the death and ending of the life of that person I am going to confront. That defies common sense, that defies reason, ladies and gentlemen. Because the law says to benefit from the mitigation of accident, it has to be your actions and not a result of a criminal undertaking. And we already know he had no business having a firearm. He was unlawfully in possession of said firearm. Full stop. So you've already started from a place of unlawfulness. And everything you do subsequent to that is unlawful, is without justification, is without mitigation, is without excuse. All of Antoine Carmichael's actions were purposeful. Because accidents do not follow people across town. Accidents do not confront people in hotel room doors. Accidents do not inflict downward head wounds. And accidents doesn't make you run after you do what you did. Accidents don't accidentally make you pistol whip someone. Quentin Beavers walked into that hotel room alive, and the only reason he didn't walk out alive is because Carmichael made the choice that he did that night. And those choices ended Quentin Beavers' life. Remember at the beginning of the trial, defense told you, we don't know what happened. That's how they opened. We can't tell you what happened. I submit to you that we have. Defense also said there was chaos. I submit to you, there wasn't chaos. The only struggle that happened in that hotel room doorway, which we saw, Lieutenant Weather took the measurements for you. It's tiny. Was because this man, this defendant, bum rush, as Tiaja Hammond says, he pushed past her to confront Quentin Beavers. That is an accident. That is deliberate. That is the choice. And now we're into the land of pistol whipping. But notice, what didn't change from anything we've been discussing. What doesn't change, Antoine Carmichael followed Quentin Beavers across town. He waited outside of his room. Because you see, the evidence has shown they weren't friends, they didn't know each other. He knew vaguely that Beavers was hanging around with Miss Tiaja. He knew where Tiaja lived. But you see, ask yourself, when he encounters Tiaja and they're stopped at the top of the walkway, and she's going to ask Mr. Beavers whether he had his drugs, why not just wait here? No, he walks. He walks. And he repositions himself right here, hands in his vest. And he's looking, because you see, I submit to you, he's looking to see whether Mr. Beavers leaves that room so he could chase him down, because he was not leaving that hotel room without putting hands on Mr. Beavers. That was his only purpose for being there. And he was going to see it through to the end. I said before, the evidence keeps changing. The facts does not. In our jurisdiction, under our law, all you need to do is apply the law to the facts, and you reach the natural consequence of Mr. Carmichael's actions that night. Because if we say, even if on the furthest reach of our imaginations, we give him some benefit of the doubt, but what he did was assaulted Mr. Beavers by pistol whipping him. And as a result of said pistol whipping, a bullet lodges in his skull. And as a result of said bullet in his skull, he's now dead. What we have now is felony murder. Because you're committing a series of felonies which ultimately cause and results in the death of another. And you have 3 of those counts to consider in that. And by pivoting to, it was a oopsie, we didn't mean to do it, Note what defense is now conceding from where we started last week. They're now conceding Antoine Carmichael unlawfully possessed a firearm. They're now conceding Antoine Carmichael unlawfully began a confrontation, and they are conceding Antoine Carmichael unlawfully assaulted Quentin Beavers. And ladies and gentlemen, Quentin Beavers is dead. I submit to you that is guilty of felony murder. And let's look at what the other objective evidence shows us. Let's look at the medical examiner's report. We'll take that back with you. I ask that you review it. There is no notations of contusions, no abrasions, but for this bullet in his skull and the resulting complications, everything else is unremarkable. That is the objective data in this case. Now, the speculation and conjecture of the defense attorney. His other body parts, his skull, lips, liver, tongue exhibited no evidence of recent injury, but is being punched and stumped and pistol whipped, and his tongue is unremarkable. Nothing. The only injury is up here. I submit to you, there is no credibility in any of defense counsel's speculations or hypotheticals. And credibility, ladies and gentlemen, is for you to consider. It is another part of the law that the judge will instruct you upon. And this is only your job to weigh a certain number of factors, how you weigh credibility. You look at how the witnesses testify, their motive to lie, their interest or lack thereof in their case. And fundamentally, it is everything about their demeanor as you personally observe it and as you personally take it to be. And there is a lot, one of our sort of cornerstones of the law that we instruct the jury upon is that the testimony of one person, just one person. We've given you a number of people, but the testimony of just one person, if believed, is enough to establish a fact. So we don't need to corroborate every single point or every single testimonial that you'd have heard. If you believe one person, if you believe Tiaja, that's enough. If you believe Harrell Lawrence, that's enough. If you believe Dr. Rochelle Simon, that's enough. If you believe Special Agent James Burney, that is enough. I'm going to briefly go through some of the lay witness testimony that we've heard as you go back and deliberate, just the highlights, because ADA Hall will go into a little bit more further with you. Let's look at Contavious Finney. He had to be brought in on a warrant. He didn't want to be here today. He didn't want to be here last week. He was subpoenaed to be. He was avoiding this for days. And we had to take the unusual step of getting him, bringing him here in chains. You saw that. And then he tells you what Miss Lindsay had told you. She dropped him off at Tay's room. And Tay says, yeah, he was there. But I sold him a cigarette and I gave him a shot for $2. Is that reasonable, ladies and gentlemen? He's just coming from the Valera where you see him imbibing in his little brown, whatever is in that brown paper bag. Why would he need to go to Tay Finney's room to get cigarettes and a shot? I submit to you that that's not a common sense answer. He tells you that he has his own troubles, but that the defendant was his friend. They were in the room. He does say he doesn't give him a gun, but I ask you, is that reasonable based on the other things that he said? Marquel Parks, very interesting man. I don't remember. I had a firecracker. Marquel Parks was very, very determined not to be called a snitch in this courtroom. He minimized, he hedged, he contradicted every single piece of video evidence, but we can see why. From the very first video we showed you at the Valera gas station, who is in tow with Carmichael? Marquel Parks. And then Markwell says, I have never seen him like this. Oh my goodness, he's the calmest man I know. Even though he admitted that night he was drinking the Grey Goose. But on April 5th of 2024, that is what we are here to talk about. Not the historical life of Carmichael, but what he did on the night of April 5th, 2024. All of the actions that belie being calm, all of the actions that belie being non-aggressive and non-confrontational, all of his actions that he took that night are completely in opposition to the person Michael Parks was described to you. And Herrera Lawrence and Tiaja Henning, they both told you what they saw, what they felt. They didn't embellish, they didn't add. And you can see from the videos, they were all to the left of Mr. Carmichael. Mr. Carmichael, hands cupped at a 45 degrees up to the right. Tiaja, if she wanted to lie, could have said, I saw the gun. She has never said that. From the very beginning, she's been consistent. I heard the shot. My ears rang, and I ran. And you see it in the video, the minute the shot rang out, Tiaja ducks and takes off. You see the people who are outside, they duck and they take off because they heard the shot. And the person who is positioned in a manner consistent with inflicting a downward shot to the head is Antoine Carmichael, nobody else. And another legal principle we'll be discussing and you'll be deliberating at length about is criminal intent. What does it mean when we say you intended your actions? Because the law has a very sort of clear way of putting it. And it says, criminal intent does not mean you intended the result. It can be inferred. So there is no thought bubble at the top of Antoine Carmichael's head saying, I intend to go kill Quinton Beavers at 10:40 this night at the Economy Hotel. But we can infer his intent from all of the natural and necessary consequences of the actions he took that night. And every action that he took that night was prohibited by law. And therefore, if we look at his actions before, during, and after, we can infer criminal intent from his conduct. And so you're allowed to figure out what Mr. Carmichael did that night. He followed Mr. Beavers, he confronted him, fired a gun into his head, and then he fled. He didn't just flee the scene, he fled the state. Within a week, his room was clear and he was gone. Didn't call 911, didn't seek help, didn't double back. Rel told you when the shot went off, he shot, he spooked, he ran. Got to the top of the hot sidewalk and realized, oh my God, my friend is right there. And he doubled back. He went to go see about his friend. Antoine Carmichael didn't double back, he kept going. And he kept going. And he didn't stop until he was stopped when he was arrested. These actions tell you everything we need to know, ladies and gentlemen. As we said, the indictment is not evidence, but there is a key concept in count 1 of malice murder, which is malice of forethought. And it's one that's some people sort of, it's not intuitive when you say malice, because they think maybe it's ill will or hatred. That is not the case in this case. Malice is, if we want to put it simply, an abandoned and malignant heart. Being completely indifferent to whether someone lives or dies. Imagine taking your heart and sending it to the ground. I don't care what happens to you. Because when you look at what Mr. Carmichael did to Mr. Beavers as he lay there stretched out, Mr. Carmichael steps over Mr. Beavers and runs while he lay there discarded. And so I look at the elements of murder. We submit that we have met every single element because there was no justification. There was no excuse and there was no reason why Quentin Beavers is dead. And then malice doesn't have to be verbalized. It can be expressed under the law or implied under the law. Both forms are equally valid because all of Mr. Carmichael's actions show he did not care if Mr. Beavers legal that he just wanted his drugs back. That was his concern. Didn't get it, and so he did what he did. And when we look at implied malice, no provocation. As we saw earlier, Mr. Beaver was just in his room. There was nothing to provoke any of what was visited upon him by Mr. Carmichael. Absolutely nothing. Now, a lot of us watch court TV and we know, we hear this word all the time, premeditation and motives, two words that come across all the time. But I will submit to you, in law, we don't have to show premeditation. We don't have to show motive. But here we have both, which defense counsel will tell you, but at the time as a DA, how many cases he's done where there was neither. But in this case, we have both. And critically, malice is not something that has to be formed minutes earlier or days earlier. Malice is formed in that moment when you decide to up and take out that firearm and point it at another finger on that trigger pull. That's malice. When he walked down that sidewalk and repositioned himself, waiting, watching. Because, you know, ladies and gentlemen, he didn't just bump into Quentin Beavers. He was lying in wait to accost Quentin Beavers. That is malice. When Tiaja opened the door, he didn't hesitate. He rushed past her, pushed past her, and went straight for Quentin Beavers. That is malice. And then, as we said earlier, his actions after the fact, the running, not stopping, not seeking help. We call that in law the consciousness of guilt. I gotta get out. I know what I did. I gotta go. And so we've gone through all of these before, during, and after. We talked about the deliberation, the premeditation, and defense will talk about it was chaotic. I submit to you, it wasn't chaotic. It was control. Because at no point did he lose control of that handgun. It was controlled, and the person in control, the only aggressor in this case, in this incident, is Antoine Carmichael. No one else. And we talked a little bit about felony murder. Here you have 3 counts to consider, 2, 3, and 4, and they each have various predicate acts. Aggravated assault with a deadly weapon. If you punch somebody hard enough and they die from that punch, as an aggravated assault, and then consequently a felony murder. If you are a felon and you possess a firearm and using that firearm, someone dies as a result, that is felony murder. Here you have 2 counts to consider. Because critically, with felony murder, you don't have to show intent or malice. Felony murder is simply death occurred as a result of a felonious act committed by the defendant. And once that person dies as a result of the felony, we have felony murder. So there's no intent we need to prove, just the causal connection from the felony that was unlawful to the death. It's like math. So here we have it. Antoine Carmichael unlawfully possessed a firearm, felony 1. He assaulted Quentin Beavers, felony 2. Caused Quentin Beavers is dead by shooting him in the head. 3 felonies, Quentin dies, felony murder. 1, 2, 3, quite linear. And we talked about aggravated assault. Again, I submit to you, we've met every single element of the charge. Quentin Beavers is dead. He assaulted him. And the deadly weapon, which you see in the instructions the judge will give to you, what a deadly weapon is, means to end or take the life of another, which we have here in this case. And during the actions of Mr. Mr. Carmichael, he had with him in arm's reach in his person the handgun. Again, we've met every single element of possession of a firearm in the commission of a felony as we outline here. And remember we talked about, you heard this word stipulation. Both state and the defense have agreed. Counts 7 and 8. Mr. Carmichael, without lawful authority, possessed this firearm, and he has 2 felony convictions. That means he agreed. He says, I know I'm unlawfully in possession of a firearm. So if I will suggest something while I deliberate, I say work up, work backwards. Because when you start on a lawful place, it doesn't get lawful as your actions progress. Remember we talked a little bit earlier about that dollar bill? Again, it is clear what we have in this case. Are the missing pieces? No evidence, no DNA, no ballistics. Well, there's a reason for that. The gun is gone. You can't test against a gun you don't have. Gunshot residue. Let's explain that. The GBI doesn't test when the victim suffers a gunshot. It makes sense. There's going to be GSR. And he certainly couldn't test Mr. Carmichael for GSR. He was gone. He was states over. For months, he was gone. And so the phone records, all of that tells you that the dollar bill we looked at earlier, you can now spend it because all the pieces are present. Every element has been met. And if we just apply common sense and reason, we see that there's only one verdict that speaks the truth in this indictment. And we discussed a little bit about the reliability of identification, the reliability of phone records, and Special Agent Bernie explained that to you. Again, if you believe his testimony, you can take what he said as far as reliability as fact. Ladies and gentlemen, a number of witnesses sat at the witness box and pointed out the defendant by various names, Antoine Carmichael, Peanut, or Nut. What is unchanged is that that is the same person, whether they recognize him or whether they're familiar with him. From the Valero gas station to the Economy Hotel, it's all the same person. Only thing that was missing or different was he lost the red hat, put his hoodie up. Why would you do that? Because you're trying to hide. Why would you put your hands in your vest pocket? Because you're trying to hide. What are you trying to hide? You see, defense wants you to be distracted by saying, well, I don't see the gun out like this, so it wasn't present. Ladies and gentlemen, by the entirety of his actions, we can infer Mr. Carmichael was armed that night, and he used that firearm, deadly consequences. And again, we listened to some videos and some clips at the end of today's presentation. I remember when you go back to deliberate, how Kimberly Lindsay describes him. She says the word calm, but she was clear. It wasn't just he was calm and chill. He was scary calm. He was locked in, he was cold. Because he had resolved to do what it is that he was going to do. And nothing she said or anybody said was going to stop him.
And so he ended up, I'm in the car and he wanted me to take him back because he was going to go get his piece. I said, Peanut, it ain't even fucking worth it, bro. I said, why are you even going to go shoot this boy over this shit? I said, let it go, man. I said, you've been in the game too damn long anyway. That's what I told him in the car. I said, are you serious? Peanut, and he was like, Kim, I'm not in the fucking mood. I said, this is just stupid. I said, but, you know, I said, are you really, really gonna do this? You really gonna color outside the lines like this? But I mean, the whole time he was calm, and he was like, look, don't worry about it. And so, like, literally, even when he was in the car, he never raised his voice. His voice still stayed like, he wasn't like irate, like, you know, like, even when he got on the phone, he was like, it was scary calm, you know. I was holding him in the car, and I said, are you?
Ladies and gentlemen, as I end my presentation and I turn over to defense and subsequently, I urge you not to be distracted by the red herrings or the misdirections or the speculations or the hypotheticals. None of that is evidence in this case. When you go back, apply the law to the uncontested facts, apply common sense and reason, and come back with a verdict that's true to the event. Thank you.
Okay. Good afternoon, ladies and gentlemen. I submit to you, and Antoine Carmichael is not guilty, and the state has not carried its burden beyond a reasonable doubt. Again, I do thank you, appreciate you, for being patient, for sitting through the evidence. This is your civic duty. I know it can be annoying, it can be frustrating, but this is essentially, and at a time when the rule of law is definitely important, for all of us, this is probably one of the most essential things that we could do as citizens, and definitely that maintains what our country stands for. Our country stands for justice, for truth, and that right to a jury trial that our founding fathers contemplated is still here, and this remains a vital piece of our society for us. But I want to talk about sort of your role, and I'll get to that point later, but essentially, the state is trying to tell you what to see. You see the video, and they're creating facts or making inferences in their mind, but none of the evidence has displayed these things. None of the evidence has exhibited these things. They're saying, you know, use your common sense, use this. That's not the standard. The standard is beyond a reasonable doubt, and as we're going to also exclude the reasonable, other reasonable conclusions that it could be. So again, what you're doing, it's similar to what the state did. You know, we probably had the same training, but you can't talk about passion. You know, this could be something passionate for. I hate guns. I hate homicides. I hate when people die. Those types of things are not what we're here for. Public opinion. Do you hate Fulton Industrial? You feel like those scoundrels on Fulton Industrial just need to leave? Don't need any place in our society? What is the public opinion about firearms? What is the public opinion about maybe even convicted felons? Those things are not relevant to your job as a juror. Conjecture, just this is what happened, speculating on things that's going on. And like you said, the state thinks that we're speculating, we think they're speculating. Because again, no one knows how the shot was fired, when the shot was fired, who fired the shot. No one knows. And so your difficult job is to just come up with a solution because the state can't figure it out, the police couldn't figure it out, and they would do anything in their power to find somebody to place a firearm in Mr. Carmichael's hand, try to go back and find statements from the very people that they prosecute, the very people who they would bring in here to convict as well, but now they want you to rely on these people's testimony. And so that is the conjecture. Again, sympathy for the victim. You're not to think about that. Sympathy for the defendant, or whether you disagree with the law. We're only concerned with what we heard in court, the evidence, the testimony of witnesses. Again, their motives to lie. Were they under the influence? Were they intoxicated at the time? Could they really perceive what was going on? Were they in their right state of mind? Those things are definitely important when we talk about what our duty is in that circle, from the photos to the videos to the elements of the crime. On legal principles, we want to talk about the presumption of innocence. And I'll read that all the way through. Now, the presumption of innocence, the court will instruct you is the defendant is presumed innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. And so this is important because a lot of times, and I'll talk to you about this in opening, we don't really take that presumption serious. We don't take that as, this is something that this person is already, they're already innocent, they're already in this place under they're not guilty. And the state has to jump that hurdle to prove to you that they're guilty. And so I think about this, there's a funny photo, but about the football. In college football or in NFL, when you talk about the presumption is, I compare it to instant replay. And so if anybody knows how replay works in football, there's a call on the field. The call on the field could be a touchdown, it could be a catch, it could be a fumble. And the coach on the opposing team throws this challenge flag. I guess the Super Bowl's coming up, so we'll probably see something like that. They challenge flag, and then when the flag goes out, the referee say, "What's your challenge?" We want to challenge this as a catch. And they go review the evidence. When they review the evidence, they can only view what angles they have, what videos they have, what evidence they have. The referee can. And so the call on the field would be, if this is a fumble, if they look and they don't see enough that can convince them that it is a fumble or that it's not a fumble, then they won't change it. But if they see something that convinces them that this is what you see, then the play will be overturned. And so here's a demonstration. This was a few weeks ago, the Falcons. This was the angle the referees had, whether it was a catch or a touchdown. And in order to have a touchdown, you would have your elbow can't be on the white line and your butt has to be in the end zone. And so in order for this to be overturned, it was a touchdown call, thankfully for our Falcons. I don't know if we have any Bucs fans here, but the Buccaneers were challenging that elbow on the white line should make this touchdown invalid. The referees saw it and they said, I just don't see enough to overturn the original play on the field. Ladies and gentlemen, we don't have enough. The call already is innocent, not guilty. That's what that presumption is. The call is already innocence. We don't have enough video evidence. And so when the call is upheld, they say the video evidence either confirms the original call without compared to presumption of innocence, or there's not enough video evidence to overturn the call, which makes it inconclusive. That means innocence is upheld, the call is upheld. But it could be overturned if there is indisputable video evidence that the original call was incorrect. And so in this situation, the state brought a lot of witnesses in to tell you what they see, tell you what's going on, slow it down, speed it up, try to separate all these people. But No witness has told you how the muzzle was flashed. No witness said they even saw a gun. They didn't see a trigger pull. And so, again, in this type of case, is there sufficient proof that confirms not guilty? Or is it not enough proof to change the presumption? Or is there proof beyond a reasonable doubt that the crime is committed? We submit to you, the call is already not guilty, and the state has not overturned that. They have not come with reasonable doubt, with evidence that proves beyond a reasonable doubt, that excludes every other reasonable explanation for how this could have happened. And so I would compare it to that. Now, the burden of proof, again, you have reasonable suspicion, probable cause, which is what it takes to get the indictment or the warrant, preponderance, clear and convincing, and then beyond a reasonable doubt. And so no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element. Remember, we're going to talk about elements of the crime charged beyond a reasonable doubt. And reasonable doubt is, as fair and impartial jurors, it is a doubt with which you can give a reason. It is not vague or arbitrary, but a doubt that if you have to hesitate and have to think about, is that really what I saw? Is this really that? That's what reasonable doubt is. A doubt with which you can give a reason. And so, again, I would say this. I am very, very sympathetic about what happened in that case. But when we talk about reasonable doubt, we want to be focused on the law and box in what's relevant, what's in this circle. And so if there are reasonable explanations for what could happen and the state hasn't proved beyond a reasonable doubt to exclude that, then that means Mr. Carmichael is not guilty, no matter how sad it is that this person passed away. Again, we talk about mere presence. Mere presence at the scene of the crime is not sufficient unless the evidence shows beyond a reasonable doubt that that person committed the alleged crime. And then we have evidence, direct evidence. Again, the state has run through these for you, but direct is evidence that points immediately to the issue in question. Circumstantial is a proof of a set of facts. And circumstances that tend to prove or disprove another fact by inference. All right, so circumstantial evidence. To warrant a conviction on circumstantial evidence, the proved fact shall not only be consistent with the hypothesis of guilt, but shall also exclude every other reasonable hypothesis, say that of the accused. So what does this mean? This means that if they have a reasonable hypothesis as far as why he's guilty, then you have to also consider the other reasonable explanations for why he could be not guilty. If you have no reasonable explanation, that's fine. But circumstantial evidence must exclude other reasonable hypotheses. And so if the state gets a hypothesis, the defense gets a hypothesis. And you have to weigh and determine that that's something that's sufficient. And so I put this up because the state normally does the snow analogy, and it's probably relevant for this weekend. I went to bed Saturday night and I was told that it was gonna snow. But I go outside, I didn't see any snow on the ground. But the weatherman told me it snowed. My mom called me and said, you didn't see the snow. Everybody telling me it snowed, but I didn't see the snow. And so just because they're saying, we're telling you there's snow on the ground, it snowed. Well, there's times when it snows and you don't see snow on the ground. And so in this situation, I think we're confusing what the snow is. We want the snow to be body of Mr. Beavers and saying he's dead, you know he got killed. But the snow would be the firearm. We need to know, did the firearm come from Mr. Carmichael? So there's a circumstantial evidence that somebody's dead, you know he shot him. Of course somebody shot him. But we need to know who. We need to know how. We need to know what. We need to know when. And so if there's no reason, there's no explanation, or we haven't gotten enough evidence for how this happened, the circumstantial evidence must be reasonable explanation for the innocent should also be considered. I want to say a word about confirmation bias, which is the tendency to try to prove or accept an answer or evidence of something that you already want to come up with. So it's like if somebody tells you, you know, about your favorite player or favorite artist or something like that, and you only search for the facts that prove this about that person, but you exclude any negative or any other facts that could probably negate something, and that would be confirmation bias. So in this situation, we know he killed him because he came to this place, he did this, he did that. And the state is only going to give you the facts that they prefer. But the witnesses gave you the raw facts that they kind of presented to you. The state is just going to give you the only facts. They want you to confirm because they're the state. Again, we're the state, report to county DA's office. What I tell you, trust me, I'm a prosecutor, so trust what I say, and they want you to accept that. But in order to think about confirmation bias, we have to be careful not to do that. We have to be careful not to just confirm something because the state said it was so. They don't get to say that. That's your job, and that's insulting to your job. You're the trier of fact. You get to see the video. You saw the video, and you know what happened. Now, we also had these witnesses. Again, we had Mr. Trailer, the 911 operator. No caller described how the incident started. No caller mentioned who the aggressor was. No caller described the weapon. No caller mentioned who fired the weapon. And no caller mentioned how the weapon was fired. The caller, Felicia, stated, don't move him. This is important to me because we don't know what was moved inside of that room. We don't know what was taken from that room. And no caller mentioned Antoine, Carmichael, or Peanut. Now, we also have Officer Gyra, who appears on scene, and he described it as chaotic. It's not me. I didn't say this. The officer described it as chaos. The officer said there was a lot going on. He couldn't tell what was going on. He's the first man on the scene, and you see somebody looking into this room. That's what we see. This is an unsecure crime scene, and it compromises the integrity of the case. And so this is immediately after Mr. Beavers falls and collapses. And we see Mr. Rail go in. He moves his legs, he moves his body. You got people watching. I'm just gonna play it and let us watch. There's multiple people entering the doorway, enter the room. So you have all these people going into the room, and what the state brought out through the police or the detectives, this is a high crime area. You have all these people in this area. And so they're going into this room prior to police arrival. We don't know what was taken, and the state cannot prove beyond a reasonable doubt that something wasn't taken. And they're just gonna tell you nothing was taken because believe us, we're the state. Well, what, does the defense not have an argument? Can we say, look at all these people going into the room. Was a shell case taken? Was a firearm taken? Was any other thing? Was his wallet taken? Nobody said anything about a wallet. Mr. Beaver just popped up. You don't just pop up. You were born somewhere. You have a life. You go through places. And like I said, I know, he is a person, and so I don't really want to be insensitive to that. But they just make he just pop up nothing. He has nothing. You know, you don't have a wallet, a license, you don't have any type of identification. And so they just say this is just perfect case where this person just in the room that popped up out of thin air on 14. He just popped up and just friends with Rail, who is the drug dealer and convicted felon, popped up in the room and nothing was taken. Nothing was moved. We saw a body moved. That is not sufficient. This crime scene is compromised. And so when you have a compromised crime scene, you do not know beyond a reasonable doubt what went on in that room, what happened, what was taken. And it's not the prosecutor's fault because they don't know. Just like I don't know. You don't know. We don't know what was taken. So they want you to come in and they want to come in and just say, yeah, I know nothing was taken. You know, they want to, come on, nothing was taken. Well, you don't know that because we cannot see what's going on. This is another statement from let's see if I have any on down and mute something.
Is there volume on your?
Just want to see if I needed to turn something up. Well, I'll just play it. I'm gonna play Officer Dobbs' body cam.
I need to know what happened, man.
I'm telling you, I'm talking. Who after me? Okay, I need to walk up.
Y'all was in this room right here?
No, nobody, none of these people was around. I gave him up there, whoever, I don't know the nigga. He was like, he asked me a question about something, whatever it took. And all I did was walk in my room and ask him, he said no. One day, I don't know. And that was it, and it happened. I can't just take right now. So, y'all know, it's just.
Section, Your Honor.
You know, yeah, I can't.
I'm gonna be honest. You telling me.
Just pause it.
I don't know.
I know. That's what I'm talking to.
See. So ladies and gentlemen, instead of, we won't necessarily listen to what these people are saying, but these were the people present for Officer Dobbs, when he arrives. So this is important because this is, let me see if we go back. So basically, is that for me? Okay. Mr. Beaver's friend, Rail, who was there, and again, I talked to him, Officer Dobbs, when he was giving his statement. And so Rail is still on the scene. Officer Dobbs said he never got a statement from Rail about what happened. He never heard anybody yell. He never heard anything going on. He never heard Rail say somebody yelled. And also understand there was no statement that was volunteered. So this is Officer Dobbs' body cam. We also had the crime scene tech, Gatewood. She mentioned that one projectile was located in the back of the room. How did they get to the back of the room? If they're fighting in the doorway, how's this projectile in the back of the room? You say, well, they kicked it. We don't know. Again, I don't want us to start assuming things to make the story fit for the state. We cannot assume things to make it fit. That's not what our job here to do. Our job is to seek the truth. And Mr. Carmichael has that right for us to seek the truth. And if the truth is unclear, then that is a problem. There was no weapon found. Again, the state's argument, reasonable, you can say it's reasonable that Mr. Carmichael left with the firearm. The defense argument is that the firearm was still there because it wasn't Mr. Carmichael's firearm, it was Mr. Beaver's firearm, and that weapon was there, but for the people who went in that room, multiple people on Fulton Industrial who went in that room and compromised the crime scene. And so it is not fair to just say nothing was taken. Well, we don't know. I wasn't there. Everybody we talked about, when we reported, everyone said they know nothing about this case. So if we know nothing about this case, we cannot assume facts in evidence. We cannot assume these facts. And again, the projectile, I had questions about testing of the projectile or any of those things, because there are ways you can see where a projectile, what it came from, what type of gun it comes from, the unique markings. Is this for 9mm? Is it for 45? What type of projectile did you find? They didn't even bother to try to test. They didn't even say inconclusive. Yeah, we have a projectile. That's all the stuff the police did. I mean, it's not the DA's fault. The DA is just going with what they have, but it's improper to just assume this is the projectile that came from this. We don't know how that projectile got in there because it's all the way in the back of the room. No shell casing found. Again, the shell casing is something that's deposited after a gun is fired, and it's normally something you would see. You would see a projectile with a shell casing. They looked for them, they didn't find anything. There's no evidence of this. No gunshot residue. Again, the policy is that we just don't test people that were victims because we just don't. That's not good enough. Nobody tested the hand of Mr. Beavers. When they had him at the hospital, they had him in an autopsy. Nobody tested his hand and said, oh, we just don't do it. Well, that's not good enough to just say we don't test people, because what if that person handled the firearm? What if it was on them? And so they just, oh, we didn't test it. No fingerprints again, no DNA, no wallet, no money, no identification again, but as far as what's in the room. We just have a person who just popped up on Fulton Industrial with no unique markings identification. I submit to you, like the state submitted, all of the things that are important to Mr. Beavers, his ID, his money, his wallet, the drugs they were smoking that he already had, the weapon was taken when Rail went in first and was touching his body and checking on him, and when other people going in there as well. That's reasonable. It's reasonable that that crime scene was compromised. So we cannot confirm that that crime scene was not compromised. We also heard from the store clerk. He said he don't remember that night. He can't recall what Mr. Carmichael said. And he said he didn't have access to review the cameras. But again, he didn't see a weapon. He never talked to the police. Detective Thomas never even bothered to interview him. But he also never witnessed a conflict between Mr. Carmichael and Mr. Beavers. And so it's important to note that he didn't have access to review the cameras, because Kimberly, who's supposed to be the state's key witness perhaps, he said he saw it on camera. But this young man said, I never said, because I don't even have permission to review it on camera. And so that's important to note. And this is them at the Valero. You can see them. You know, we have Mr. Lawrence, Mr. Rail. He stated on the testimony, he consumed drugs and alcohol on April 5th, 2024. Does this not alter your perception? Does this not alter how you view things? Do you really know what's going on? Can you really comprehend and interpret what you are viewing or what's being said? He said he sold drugs all day. But he stated room 132 was his baby mama's room, not TT's room. So he's not even clear about whose room it was. He didn't witness the beginning of the altercation, but he did state that he witnessed the struggle, which is what everyone's saying. They witnessed the struggle. But he never witnessed Mr. Carmichael with a firearm. And he does not know how the weapon was discharged. And he did not see gunfire. He didn't see a muzzle flash. And he moved Mr. Beaver's body. And so with all of these things, this is what we take from Rail. You don't see gunfire, never see a muzzle. You don't know how the weapon goes off. You just witness the struggle. He came up at the end. And he did mention he was a convicted felon. We have Kimberly, Ms. Lindsay. She stated she consumed drugs on April 5th, 2024. She stated her drug of choice was crack cocaine. She was a convicted felon. She did state he was calm. We can go back and forth whether it was scary calm, real calm. She stated he was calm. And most of the witnesses testify he's a calm person. He's not a fiery, irate person. She stated in the testimony that we read, he didn't say much to her. That's what she said under oath. And so the state wants to play these past recordings about what's going on when the detectives come with her, searching her, trying to make her say anything so she can leave. I mean, so she could tell them what they wanted to hear. And so they want to play these recordings where she's talking about all these things, where she's saying what she thought he was saying on the phone with Tay Finney. Tay comes and said, we never talked, and you have the phone records if you care, but Mr. Carmichael never called Tay. So again, the store clerk said, I didn't tell them anything about I saw it on camera. And then Tay says, I never called Kimberly, I never called Carmichael. And so those are two things right now where Miss Lindsay mentions what was going on, even though she was under the influence and intoxicated, but these things didn't happen. So does she really remember what happened, or is this her going back in time and trying to come up with a statement so she could leave the police precinct because they have her in custody. And she stated in the oath, the statement under oath, there really wasn't any talking. She mentioned she was on the phone. And she was speaking with the people in the car. She didn't know who they were, even though a few minutes later, she consumes drugs with these people, but she don't know those people. And so it's convenient that the detective nor the DA's office can confirm anything else being said, because you have a convicted felon who's admitted to chronic drug use, and then she's been proven wrong on other occasions. This is the key witness that's supposed to tell you he went to go get a piece, but nobody else can confirm this is what was said in the car. She never heard Mr. Carmichael mention Mr. Beaver's name, never witnessed, she never witnessed him with the firearm, never has. And she said, they told me I couldn't leave until I gave them Peanut's phone number. She also said I was more focused on getting high when she was a convicted felon. And Detective Thomas did say that she stated she don't remember some things because she suffers from short-term memory loss. So it's just all over the place. Her statement was all over the place. And so the state wants us to pick and choose what points are credible for Kimberly. But from experience, in your life experiences, you have to determine whether anything she said is credible. And so she says that he goes to Tay's room to get his piece. Tay said he's never heard nobody call it a piece. So again, is this Kim coming up, bringing stuff out of thin air? Is that what's going on? He said he would call it a gun or something different, but he didn't. And he's never heard Mr. Carmichael call it a piece. So the key things about Kimberly is there's no corroboration about anything she said. We got Contavious Finney. He wasn't present at the economy end, so he didn't see the fight. He witnessed Mr. Carmichael in his room. He never spoke to Mr. Carmichael on the phone, and the phone records do confirm it. He did not witness Mr. Carmichael take a firearm, and the state's just gonna say, y'all know he took that firearm. How do you know? You don't know Tay Finney, you don't know what's at the guest in. But again, that's that confirmation bias. This is a convicted felon, this is a guy in jail. You know he got a gun, he went in his room and got a gun. That's conjecture. They haven't proven that he got a gun. They haven't proven that there was a firearm in Mr. Finney's room. He said he just came in to buy some cigarettes, take a shot, whatever he did. And so we just want to default to negative facts. It's not about negative or positive things about Mr. Carmichael. It's about what is relevant and what happened. And he didn't know about a dispute between Mr. Carmichael. He said he was friends with Mr. Carmichael, but he's also cool with Mr. Beavers. So he didn't have a side to choose. He was just saying a firearm was never taken from my room. But that's the convenient narrative the state wants, because they believed on unreliable Kimberly Lindsay to say, yeah, he went to Tay's room to go get a gun. He was talking on the phone with Tay. Well, Tay said he went on the phone, and Tay said he didn't get a gun. And so why would he even be at Tay's room to get a weapon? He didn't go to Tay's room to get a weapon. He went to get a shot. He get some cigarettes. But that perfects the narrative for the state. And he mentioned that he did not know where Mr. Carmichael was. We also have the guest in who said guests usually have weekly leases, but he didn't witness what was going on, and he doesn't know why Mr. Carmichael moved out. But as far as the guest in is concerned, this is also a distraction because it does not tell you what happened in that moment. People have weekly leases. If your money's not there, you gotta go. You can't stay there. If your money's gone, they say he was looking for his money's gone, he can't stay at the guest inn anymore because his lease is up. We had Mr. Parks, again, he was all over the place. Mr. Carmichael's friend, driver of the F-150, but he said he did not witness Mr. Carmichael with a weapon. Mr. Carmichael was not angry. He don't get angry. He's not like that. He was calm. He didn't know Mr. Beavers. And again, that's the thing. The mumble and peanut thing, that's a stretch because there's no indication they knew each other. Mr. Beavers didn't know him. He didn't know what to call him. There's no evidence that Mr. Carmichael knew him. There's no evidence that Mr. Beavers knew Mr. Carmichael. And so Mr. Parks did not witness the altercation. He didn't witness the shooting. He heard one gunshot. It sounded like a firecracker or a car backfire. And he stated Mr. Carmichael would not have gotten in my car with a firearm because I'm a convicted felon. You can't get in my car with a gun. And Ms. TT says she consumed illegal drugs and alcohol on April 5th, 2024. She was intoxicated again. She stated her drug of choice was weed or cocaine. And well, both. She did both weed and cocaine. She lived in 133. She just met Mr. Beavers. She stated when Mr. Carmichael came up to her, he was not aggressive. He was just asking her a question. He was not aggressive. There was no bum rush. She didn't see a firearm there. She didn't see him being mad. He was just asking her to go ask him if he had what was taken. So it wasn't that he came in looking for a fight. He came asking her a question. He was calm. He was not aggressive. No matter how bad the state wants him to be, this monster aggressive person, that's not what we saw on the video. Mr. Carmichael never threatened Mr. Beavers. Mr. Carmichael did not force his way into the room. He's standing at the door talking, and then you see him react. There's a reaction. We don't see him bum rush past TT or Miss Hannon, if you will. We see him, he's there, calm, talking at the door, and then you see a reaction and everybody's pulling the struggle. And that's what everybody described. It was a struggle. It was a tussle. But she did not see Mr. Carmichael with the firearm. A common thing, no one saw Mr. Carmichael with a firearm. No matter how bad the state wants it to be him, why does the state get to say he had the firearm? Why couldn't Mr. Beavers have the firearm? Because he's charged with the crime, he has to be the one with the firearm. But the state has not proven beyond a reasonable doubt that Mr. Carmichael introduced the firearm. And no witness has placed a firearm in Mr. Carmichael's hand. That is a fact that we must stress. And Mr. Beavers, she said, was yelling as he was walking towards the door. So you got this young man walking towards the door, and Mr. Carmichael just asked him a question. He could have stayed on the other end of the room. Why is he walking towards the door yelling? He's walking towards the door yelling with the gun in his hand, and that's when people react to try to fight over this gun. And so that's when the witnesses, that's when they say they witnessed a tussle. They're struggling at the door. So it's not, he's not at the door and just take out a gun out of his pocket and shoot the man. That's not what happened. And we saw that from the video. And so when everybody's narrating, you trying to tell you the arms and positions, they're doing this in slow motion. That is not what happened. You get to make that choice. You get to tell what was going on. We don't know when that shot went off. We don't know how his arms were. We don't know why his arms were a certain way, but that doesn't necessarily mean that's the shot. If that was the shot, you would see a muzzle flash. You would see sparks. You would see smoke. You would see fire. We don't know if just because his arms are bent, that that's the shot that's happening. Again, the state is arguing argumentatively that that is the shot. We don't know that was the shot. And they haven't proven beyond a reasonable doubt that that's the shot. She stated she couldn't see inside the room. None of the witnesses could. She never identified an initial aggressor. She heard one shot. Again, she didn't see a muzzle flash. She cannot describe the weapon. She could not see anyone's hands. And she said she witnessed 8 or 9 people walk in the room. She witnessed rail touch Mr. Beavers after the shooting. We had our special agent, Jay Burney. He says that the report doesn't show when the firearm was discharged. It doesn't say how it was discharged. So placing him there is fine, but it doesn't prove malice. It doesn't prove there was an intentional shooting. It proves no details about the shooting. And so it was great to put him there, but again, mere presence at the scene of a crime does not mean someone committed the crime charged. We have our medical examiner. She stated homicide is a medical classification. Most of the information came from investigators who witnessed the surveillance footage. You get a chance to witness surveillance footage. They're just calling it a homicide because they want it to be, because they're the police. You get to make that determination of how this happened. And if you can't, you can't. And again, like I said, the presumption of innocence has to be overcome. The autopsy report does not prove intent or malice. She mentioned that. She indicated that it is possible there could be a self-inflicted gunshot wound. And I'm not here to suggest that that's how it, that it's a suicide. I'm suggesting that Based on his hand placement, we heard no testimony about whether he's right-handed or left-handed, whether Mr. Carmichael's right-handed or left-handed. But if they're fighting over a firearm and it accidentally goes off, and you do have that charge, then it's reasonable that it could have happened. And you could have a gun up here struggling for it. And so the state is trying to say, they're trying to tell you how it happened. I'm saying they have to prove that. And there are reasonable explanations for how something like this can happen. And so to be downward, you can be fighting over a gun, you can be struggling over it. And again, there's no way that we know what was happening because we don't have that video evidence. The autopsy report doesn't indicate soot or stippling. And if it's some type of close shot, again, you should have some type of residue from the burn of a hot gun going off. And so without that, the range of fire is indeterminate. You don't know where it came from. You don't know where the shot was from. And so those are other things that cause the question, what's going on? Her report does not indicate how the gun was discharged. It does not indicate whether Mr. Beavers was right-handed or left-handed. And like I said, that's important because we don't know how, we don't know what went on with the gun because we don't see it on the video. And so the autopsy report does not reveal whether Mr. Beavers was holding the discharge. Lastly, we have Detective Thomas. He did not interview the store clerk. He did not interview Mr. Finney. He did not interview Mr. Lawrence. He did not interview Mr. Parks. He didn't test the projectile. Did not see Mr. Carmichael with the weapon. He did not, no one saw a fire on Mr. Carmichael's hand, and he did say that he does not know how the firearm discharged. But yet he charged him with murder because that's the salacious charge that you have. But they had no proof that Mr. Carmichael is the one who introduced the firearm, pulled the trigger, and killed Mr. Beavers. So I don't know what the detective did. So when we think about the witness, to wrap it up, the witnesses, what they all can say is that he was calm. They can all say Mr. Carmichael did not threaten Quentin Beavers, which is important because of the malice and the coming to intend to harm somebody. He did not have a firearm in his hand. Nobody placed a firearm in his hand. He did not point a firearm. They witnessed a tussle, struggle, and fight. That's what they witnessed. And so the state saying Mr. Carmichael introduced it, but they don't know for sure, and we don't know. And so it's not up to you to guess or speculate or fill in those gaps. And that's what the state wants because they don't know. So they want you to guess because they want to win that bad. But it's not about winning, it's about truth and it's about justice and what really happened. If you don't have the facts or the evidence of what really happened, then you cannot convict him because they want you to just take a guess, use your common sense and say he's the one that pulled the trigger. No one said they knew how it discharged. There was no muzzle flash. And again, no corroboration for a lot of these salacious claims some of the witnesses had. Pretty much all of them were under the influence, intoxicated. Was their perception really what they thought? Could they really perceive what was going on? And then there were threats of charges to these people. They thought they would be charged. People were put in jail. So all of these things are something you have to take into account when you think about the witnesses. So again, the state cannot prove their case. The state is just gonna argue till the cows come home that Mr. Carmichael was mad about some stuff being taken. He went there to look to kill somebody. Again, we're not talking about somebody in the cartel like it's a brick or something. You know, we don't know what was taken, but I'm sure it wasn't something that you killed somebody on. It wasn't anything that just causes you to overreact. Because again, he was calm. He wasn't that concerned. He wasn't that mad. He just went to go ask the man a question. And things went crazy when Mr. Beavers started yelling. Things went crazy when Mr. Beavers walked towards the door. That's when things went crazy. So Mr. Carmichael didn't commit a crime by just going back to the Carmichael Hotel. He's not committing a crime by doing that. He's not committing a crime by waiting. He's not committing a crime by going to the door. And he doesn't know what's gonna come out the door. So he walks away because he don't know this guy. I'm gonna walk back and let TT do her business. And when she gets out, I'll come back and talk to her. That's reasonable. But we're trying to make this monster who's lying in wait to go do this, and that just, the evidence doesn't suggest this. So I have this acronym EVE for reasons why he's not guilty. Number one, we're missing evidence. Number two, we're missing the elements. And then we're missing the view. I guess that got out of order. But EVE, missing evidence, missing view, and we're missing the elements. You remember that EVE, Mr. Carmichael will be not guilty because we don't have all the evidence we need. We don't have the viewpoint that we need, and we don't have the elements. Missing evidence. So again, we're missing that camera angle. We don't know what's going on from that side. And again, this isn't a red herring, but this is similar to, like I told you with the replay. If you don't see enough to overturn or tell you what's going on, you have the default to innocence. We don't have enough to know if Mr. Carmichael is the one who introduced the firearm, and Mr. Carmichael is the one fighting with Mr. Beavers over a firearm. We don't know. We don't have enough. So that's important. We're missing audio. We don't know what's said. We don't know what's heard. We don't know when the shot goes off. We're missing a weapon. We're missing the muzzle flash. We're missing the shell casing. We're missing ballistics testing. We're missing gunshot residue. We're missing soot. We're missing the toxicology. We don't know what was in Mr. Beaver's system. We don't know what he had. No one tested it. They had the blood work sent to the GVI, but we didn't get those results. We're missing witnesses. Those people that were on the scene, the police were right there. They could have asked, everybody give me your number. Tell me what you know. Give me your name. We'll follow up with you. That wasn't done. A missing search warrant. Go to Tay's room. See if you can find a gun in Tay's room. Since they think it's a gun in his room, go find it. And we're missing corroboration. We're missing people being in places where statements are being said and there's no follow-up to see if this person's telling the truth. If anybody else can confirm what was being said in these cars. So then we have the missing view. Again, there's a limited view of Quentin Beavers. We don't know what he's doing in this situation. We don't know what he's saying, what's in his hand. We don't know what he's doing. This is Mr. Carmichael standing at the door. He's not huffing and puffing. He's not looking angry. He's calm. He's having a conversation. It seems like things escalate as perhaps Mr. Beavers walks to the door, but because we don't have the view of that, we can't say for sure what is going on. And that is important, that we don't know what's going on. And that means the initial aggressor, the person who starts or introduced this firearm, is unclear. It is unclear who introduced the firearm to this fight because Mr. Carmichael is just at the door. And so we don't know what comes on from inside that room. We don't see what Mr. Carmichael is seeing. We don't know what is being done. And so we don't know if Mr. Carmichael, Mr. Beavers just introduces the gun and starts yelling at him in an aggressive manner. And it's unclear how the firearm was discharged. And every witness said they didn't know. If people don't know how it went off and they've been around this before, they didn't see a muzzle flash, this is a very, very weird scenario. And there's only one single gunshot. And so that's why, the state does have to prove beyond a reasonable doubt that this could not have been an accidental discharge. We're not saying it's an oopsie. We're just saying, how did this gun even go off? Do they even know how it went off? And no, they don't. But there's too many blind spots in the case. Lastly, we talk about the elements. Remember the elements. Like I said, you have all these different things with elements, and if you don't have it, it's not there. And last time I was telling you about a sandwich, but think of a BLT. You need all those elements to make something a BLT. You need your bread, your lettuce, the tomato, the bacon, perhaps your mayonnaise. If you don't have those essential elements, you don't have your bacon, you don't have your tomato, you don't have that bread, you don't have a BLT. You have a sandwich, but not a BLT. Similarly with murder or some of these other cases, you might have a homicide, you might have a shooting, but you don't have murder. Murder is one of those crimes that charge when you need to have all those essential elements. So I'll read this again. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. The judge will tell you, after giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. Now, a person commits murder when he unlawfully causes the death of another human being with malice and forethought. So you have to have causation, unlawfulness, and malice. You have to have those three things. Causation. There's no visual confirmation of how the gun, how Mr. Beavers was shot. No witness saw Mr. Carmichael possess a firearm. No witness saw Mr. Carmichael point a firearm. No witness saw Mr. Carmichael shoot a fire. And so they want you to say, use your common sense again. He did it. Well, that's not proven on the video. We don't see the sparks fly. We don't see any of that stuff. Chaotic environment. No evidence for when the shot was fired. No evidence of how the firearm was discharged. No weapon. And so the state cannot prove beyond a reasonable doubt that this was caused by Mr. Carmichael. They just want you to believe it. They just want you to tell us that. So we can all go home. Just give us this decision so we can all leave. All of these things call into question the causation problem. No ballistics testing, no weapon, no evidence of how the firearm was discharged, and no witness can provide it. We also have unlawful. No person shall be found guilty of a crime committed by misfortune or accident, but there is no criminal intent. And there's a struggle over a firearm. So I put this here because if Mr. Carmichael is fighting with Mr. Beavers, fighting for his life and struggling over a firearm, is it reasonable as they're fighting over this gun that Mr. Beavers introduced? Is it reasonable?
Your Honor, I'm about to object. This is the fourth or fifth time that we talked about Clint Beavers bringing a gun to this fight, which is in facts that are not in evidence. I have let it go a couple times, but.
All right, I don't need any more speaking objection. Understood. All right, members of the jury, I would direct you that you're to remember the evidence that was presented during the trial of itself and base your verdict only on that evidence. And with that, Mr. Mitchell, you may continue.
And so, members of the jury, we can't have it both ways. We can't say Mr. Carmichael brought the gun just because they want Mr. Carmichael to bring the gun. No witnesses said Mr. Carmichael brought a gun to the scene. But now we have to just say Mr. Beavers did it. But no witness has said Mr. Carmichael brought a firearm to this scene. And so if the state is going to come up here and tell you he brought it, then it should be also safe for us to say, is it reasonable Mr. Beavers brought a firearm to this, brought a firearm to that fight, and he was in there with the firearm. There's no evidence Mr. Carmichael had one. So we can't have it both ways. If it's good for the state, it's good for the defense. But again, the unlawful nature of it, we don't know how this firearm was discharged. And so therefore, the unlawful component of murder is not there as well, because we don't know how the firearm was discharged. There's one gunshot, that's it. If this was an intentional killing or he intended to shoot somebody, he probably would have harmed the witnesses. He probably would have harmed TT. He wouldn't have waited outside. He waited. If he went there to go kill this man or go even harm him, he wouldn't have waited for TT to hang. He would have went right behind her. He wouldn't have waited. He would have probably shot multiple shots. For this gunshot to go off, and everybody describes that, this is very peculiar. It's very interesting. It's very weird for something like this to happen. And so again, accident. The way we consider this perhaps an accident, because there's an absence of malice. There's a struggle. The witnesses described struggle. No witness said there was any malice. They didn't see it. The weapon discharged during the struggle. They heard one gunshot. It was fast. It just happened. That's what we heard. It was fast and it just happened. No one saw a firearm. The gunshot wound common in accidents. No muzzle flash, no stippling. In an indeterminate range. And so the state's theory of a point blank range killing does not make sense. If it was a point blank range, it would be perhaps in the middle of his head going through and through. It's on the side of his head, goes out on the same side. Those facts are important to show that this is perhaps an accident, and the state must prove to you beyond a reasonable doubt that it wasn't an accident. And the state cannot prove to you beyond a reasonable doubt that they were not struggling over a firearm during this fight and this firearm went off. No malice. Mr. Carmichael did not make any threats. He was requesting to speak to someone. It's not malice. Mr. Carmichael was calm. He was not aggressive. He waited for Ms. Hannon to ask Mr. Beavers. He didn't follow in behind her and try to go start anything. That wasn't how he did it. That wasn't what he was there for. He did not disguise himself. He had on the same clothes. It's April, the beginning of April. It's a little chilly. Mr. Beavers even had a coat or a jacket. Everyone had a jacket on. And so he didn't disguise himself just because he put on a hood. It's later at night. He has on the hoodie and the clothes. He never bum rushed Miss Hannon. He was waiting there, and I'm sure the state will play the video again. He's waiting there for Mr. to ask a question, and Mr. Beavers is yelling and coming towards them. And Mr. Beavers and Mr. Carmichael, according to evidence, were tussling. That's all we get from the witnesses. There's evidence of a tussle, of a fight, and we heard a firearm. But no one said they saw a firearm in Mr. Carmichael's hand. No one said they saw a firearm in Mr. Beavers' hand. So how do we now assume that it was Mr. Carmichael who introduced this firearm just because the state wants it to be him? One is not good enough. This is the most important, perhaps most serious crime in our state. And because I want this guy to be guilty, because I want this guy to have a firearm, then I want you to say this guy's guilty of having this firearm. Once are not good enough in Georgia, Fulton County. And again, there was only one gunshot. I would argue that even if you hear one gunshot, the malice sometimes is more of perhaps somebody having multiple gunshots to make sure somebody's dead. Everybody seemed like they got shot and spooked. Everybody. And even Mr. Carmichael left, he walked away, he left. And why would you come back to Fulton Industrial if you know people are accusing you of something? You going back, you might be harmed. So going back to the scene, again, is not indicative of anything. Again, that's circumstantial. But you have to think about the reasonable explanations. And again, Mr. Carmichael was not seen firing a gun, and no witnesses were injured. And so I continue all these reasons of why we do not have any malice in this case. If you don't have malice, then you don't have murder. Again, this is what we saw prior to the struggle happening. Mr. Carmichael calm, like everyone said. You never heard any evidence of him any a different way. And so we talk about circumstantial because this is a circumstantial case. That's what this is. It's all about circumstantial evidence. The hypothesis of guilt from the state. Mr. Carmichael went to the hotel and intentionally executed Mr. Beavers. Well, the hypothesis of innocence would be he asked about his personal property, a struggle ensued, and the gun was discharged. That is reasonable. That is reasonable because everyone gets to present to you what they think is happening, but they do not know. We look at the video and no one knows. And if the video does not have any other evidence to suggest how this gun was fired, we have to err on the side of innocence and not guilty. So for murder, if there's unclear causation, no malicious intent, no firearm, you have to have him not guilty of murder. That has to be your choice because we do not know how this gun was entered. We do not have any malice, and we do not know if Mr. Carmichael was the sole cause of this firearm. All we know is a struggle. And how can we rule out anything less than a struggle? We can't. We just have to make you believe it. And we have to tell you this because they're the state. The state has to always do that. Aggravated assault. The state must prove the defendant attempted to cause a violent injury to the person with a deadly weapon. Assault. Remember the elements. Mr. Carmichael did not make any threats. This is for the assault. We'll get to the aggravated part. He requested to speak with someone. Requesting to speak with someone is not intent to injure. Mr. Carmichael was calm. He was not aggressive. He waited for Ms. Hannon to speak with Mr. Beavers. He did not disguise himself. Again, he never bum rushed Ms. Hannon, and they were tussling. This is not one gunshot suggests an accident, but this is not an assault. This is not someone coming intending to harm somebody. That's not what we see. Deadly weapon. There's this false presumption that the firearm was introduced by Mr. Carmichael. But again, no weapon was recovered. No witness saw Mr. Carmichael with the firearm, and there's no ballistic testing. So how can you have aggravated assault with a deadly weapon beyond a reasonable doubt if we don't have the firearm or any evidence of it? So again, the presumption that a firearm was intentionally discharged for aggravated assault, that's the presumption that the state wants you to have. The false presumption is that a firearm was intentionally discharged. But the hypothesis of innocence, Mr. Carmichael and Mr. Beavers struggled over Mr. Beavers' firearm and one shot was discharged. That's the hypothesis of innocence, if this is a circumstantial case. So then we have possession of firearm. No witness saw Mr. Carmichael in possession of a firearm. There's a chaotic fight, unsecured crime scene, and no physical evidence. Accident. And so to convict him of possession of a firearm for convicted felon or during a felony, again, we have to have a firearm in Mr. Carmichael's hand. We have to have a witness to place a firearm in his possession. There's no physical evidence of Mr. Carmichael having a firearm. No matter how the state wants to slice it, they say, well, he decided to leave, all these things, but it's their job to prove beyond a reasonable doubt that he had the firearm. That it wasn't just some chaotic fight and that the gun didn't just go off. We don't know where the shot came from. We don't know how it went off. But the only thing we know is that there's a fight. There's a fight going on and there's an unsecured crime scene and people going in the crime scene, we don't know what's moving. So again, there's this false presumption that the state would say circumstantially on their end. There's a hypothesis of guilt that Mr. Carmichael again introduced this, and we would say it's also reasonable that he didn't have the gun, that the gun, there was struggle over a gun that we argued that Mr. Beavers had. And so with that being said, we ask that you find him not guilty of felony murder because we don't have all the elements for murder. We don't have all the elements for aggravated assault. We don't have all the elements for possession of the firearm offenses. And so you cannot convict him of felony murder because we don't have the elements of all the other felonies. And so I talk about these distractions because we have all these things, the Valero, they say he's selling drugs, he goes to the guest in, we have a Faro scan, we have cell phone records, we have the hands in the pocket, speaking with Mr. Beavers. All of these things are circumstantial to try to make you think this is something that Mr. Carmichael did that makes him guilty of murder. But none of that suggests that you're somebody that killed anybody. Have your hands in the pocket is not a crime. It's not a crime. Do you think maybe they're hiding something? Maybe, but we don't know. So we can't assume and speculate Mr. Carmichael with his hands in his pocket is guilty of murder. Wouldn't that be sad if somebody could be convicted of having their hands in the pocket? That's just so, that's something that's just so unfair to just say your hands in pocket means you're guilty of one of the most serious crimes in our society. So again, Eve, reasons he's not guilty. They're missing evidence, they're missing the view, and they're missing the elements. We're missing so much evidence, the ballistics, we're missing perhaps all the things that were in that room before so many people went into that crime scene. We're missing the viewpoint. We don't know what Mr. Carmichael observed when this incident happened. We just see a reaction and no witness can tell you what happened. Witnesses just say they saw struggle. We're missing that view. And if you don't have it, you don't have it, but that's tough because you have to prove beyond a reasonable doubt what happened in that room. We're missing the elements. We're missing all the essential elements of murder, aggravated assault, and possession of a firearm by convicted felon or during the commission of a felon. And again, the presumption of innocence. If you can't tell what happened, the call on the field is already innocence. If you don't know what happened, no matter how much you probably want to sympathize with anybody, but if you don't know what happened, you have to acquit Mr. Carmichael because there's nothing to show that he pulled that firearm. And so again, the judge will instruct you, no person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. And again, after giving consideration to all the facts and circumstances of the case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law and you must acquit the defendant. And so we got 20 reasons why there's reasonable doubt. There was a tussle. We saw struggle. The video was unclear. There's no audio. We don't know what was said. We don't know how it was done. There's one gunshot. There's no weapon found, no ballistics, no witness sees Mr. Carmichael with the weapon. There's too many people on the scene. Number 9, too many people go in the room. Number 10, Mr. Beaver's body was moved. Number 11, no witness identified Mr. Carmichael as the aggressor. Number 12, Mr. Carmichael does not disguise himself. Everybody knows who he was. Miss Hannon saw him. Number 13, he had a calm demeanor. Number 14, Mr. Carmichael was speaking with Mr. Beavers in the doorway. Number 15, we have unreliable witnesses. 16, missing witnesses. The people on the scene, the persons in the car that perhaps may have heard this conversation. No witnesses were heard, which is important because if, this is somebody that wanted to intend something, he would have been so irate that he probably would have done something to somebody else on the scene to make sure he covered this up. The circumstantial evidence, accident, and the state stopped at PC. And so with all these reasons, too many reasons, if you could give many reasons of why the state hasn't proven each element, then you have to convict, you have to acquit. You have to acquit Mr. Carmichael. This is too much reasonable doubt. And so the state did not prove their case. The state does not have proof, and they cannot prove how the shot was fired. No matter how much they tell you, you're all professionals, you're all educated people, you all come from your different experience and walks of life. But we do not know, nor do we have evidence of how this gun was discharged from Mr. Beavers. We know he passed away, yes, that's very sad and unfortunate. But to charge Mr. Carmichael with malice murder, when we don't know for sure that he's the person who pulled the trigger, that is unfair, that is unjust. And the state does not get their way just because they wanted to have it. Again, because we don't have that evidence, he should be not guilty of murder, not guilty of aggravated assault, not guilty of felony murder, not guilty of aggravated assault, not guilty of possession of firearm during felony, possession of firearm by a convicted felon, and not guilty of possession of firearm by a convicted felon. And so I want to leave you with a few words. Don't do their job. You have your own job. Do not do their job trying to fill in the gaps. They want you to fill in the gaps, but that is only speculation. We can't fill gaps in on something so serious as a crime. And so just because we think we're in the right, the state is saying, we're right, go along with us. I beg you, come with us. Give us this charge. Give us this case. Convict this man because we know he did it. We don't know. We really do not know. And so it's not your job to fill in the gaps, cover holes, and speculate on what's going on because we can see the video for yourselves. We don't need a narrator to tell you. You can see this for yourselves. And so remember, when honestly seeking the truth, and that's your job, to honestly seek the truth. Hold the state to their burden. Make them prove every element and do not fill in gaps for them. Because that's what they want you to do. Because they don't have the evidence to prove beyond a reasonable doubt that Mr. Carmichael committed malice murder and Mr. Carmichael is the one who intentionally, personally pulled the trigger and killed Mr. Beavers. We don't have that evidence, and because we don't have that evidence, it's not your job to fill in the gaps. And so I want to leave you with something about Mr. Carmichael again. Mr. Carmichael has his trial. He has a right to a fair trial. He's a calm person. We can't try to use this situation to just throw him away just because the state is charging him with murder. They have to be able to prove this. This is a human being. He has his own right to a jury trial. He needs to be able to, you need to take this case seriously for Mr. Beaver's sake and for Mr. Carmichael, but take it seriously and consider what's not there and consider what's there. And so after considering all evidence, find Antoine Carmichael not guilty because the evidence compels it, commands it, the law compels it because justice demands it, and find him not guilty because that's what he is, not guilty.
All right, members of the jury, as the state prepares to conclude the closings, if anyone needs to stand, stretch in place, or if anyone wants a more formal break, just let me know. Otherwise, we will move forward. All right. We'll just hold in place if she wants to step out. Sir.
That is the main board not sharing.
Yeah, push the button, yeah.
Where? Show me.
On the side of the dock.
Good afternoon, ladies and gentlemen. I want to start by telling a story. I like to tell stories. I want to tell you a story about a red bike, one very similar to the one that you see on the screen. Every day for 30 days, a man crossed the border with a red bike, similar to this, with this basket on top that was full of sand. And every day for 30 days, the border patrol officer searched through that basket, looked through that basket, searching for something. He didn't find anything on day 1, day 2, day 3, every day for 30 days. Every single time that man went to the border, he looked in that basket and there was nothing to be found. On day 31, the same man with the red bike went to the grocery store. It must have been the officer's day off because he saw the officer at the grocery store. He asked him, what was in that basket of sand that you had on the red bike? Every time I was seeing that was a basket. What was inside of it? I could never find anything. You know what he told him? He said nothing. There was absolutely nothing inside of that basket of sand. But what I did do was smuggle a different red bike across the border every single day for 30 days. Because you were so distracted with the basket and the sand and what was inside of that basket that you missed the actual bike that I was smuggling. Ladies and gentlemen, that was a lot that was just covered this morning. And I want to go ahead and apologize in advance because as you've heard multiple times, the state is this, the state is that. It is my job, as I asked you during jury selection, to prove this case beyond a reasonable doubt. And I ask you to hold us to that burden of proving this case beyond a reasonable doubt. So I'm asking for forgiveness ahead of time because I am going to go through the evidence that you've sat through, that you saw all week, that you've already looked at during both openings, closings. But it's important. You know why? Because I want to make sure you know that the state doesn't want you to believe me as the state of Georgia. The state doesn't want you to believe 88 Charles as a representation of the state of Georgia. What we want you to believe is the evidence. Nothing that I say is evidence. Nothing that 88 Charles said was evidence. Nothing that the defense counsel, Mr. Mitchell, said was evidence. What we're here to do is to guide you, to show you, to help you. Because I guarantee you when you go to the back, if you want to see any of these videos, you'll have questions. Hey, do you remember what exhibit number was that? Did you write it down? Hey, did you write it down? You'll have questions because that's the time that you'll have the case. And it's your job at that point to look at the evidence and to determine if this defendant, Mr. Antoine Carmichael, committed the offense that we have charged him with. What I say is the evidence. What I say is a guide. And as I'm talking, if you just take notes, the state would highlight our evidence, our exhibit numbers. You can take those. I saw a lot of you taking notes throughout the trial. But if you missed anything, just take down the exhibit number. So that way, if you're in the back and you have a question and you want to relook at something, you're able to do that. There are some things that you can't play in the back, even if the judge provides you with a computer to use that. There are some things that you will have to come back out here and we'll have to play for you for whatever purposes that the law said. So those are the things that you will have to request and we'll play those out here. But in the back, when you pull up these videos at your own leisure, and Charles covered this, there's Zoom features. If you pull it up in VLS, you can zoom in. We understand that this video isn't the clearest video of what happened. It's what we have. And without the video, you know what we would have still had? The people who were there, who came here and testified to you as to what happened. Defense counsel wants to get up and say, well, don't trust these people because some of them, not all of them, but some of them had prior convictions. Were there convictions of giving false statements? Were there convictions of lying in court? What were the convictions? Because what I heard during trial, and you correct me, when you're looking at your notes, did you hear anybody in this stand say they were convicted because they had previously testified under oath and they were lying? No. So what are the convictions? Was it drug convictions like Mr. Lawrence told you? He said he sold drugs. Has he gotten caught for that before? Because defense counsel didn't go into that. Because what I submit to you, ladies and gentlemen, what he just stood up here and did was try to distract you from the actual evidence. 88 Charles and Mr. Mitchell was not at this scene when this incident happened. What we have is what the evidence has been presented to us. What evidence was collected? What evidence was gathered? The lead detective in this case, he may have come in here almost two years later and say, I don't remember, hey, can I look at my report? Can I take a moment? Can I re-listen to something? He's a lead detective on a case, on a murder case. Do we expect for him to remember every single thing that he did during his investigation without maybe looking at his report or reviewing the videos? It's the same thing that the state has to do to put up the evidence. You can see that we've admitted a lot of videos from the Valero gas station, a lot of videos from the gas inn, and a lot of videos from the actual economy lounge where this incident happened. Of course, we didn't play every single hour of those videos. You would really hate us. What we did was we pulled out what was relevant, not to try to point fingers and just make it look good for us. We pulling out the evidence that matters. Because what matters? Defense counsel got up and said in opening that the Valero gas station doesn't matter. He got up and said to you that the gas inn doesn't matter. He got up and said to you that the victim's life didn't matter. How? How is that? Let's start with the Valero gas station. How does that not matter in this case? Isn't that where everything started? Isn't that where this defendant thought that the victim took his dope, drugs, whatever it was that he was selling that we have on camera? Isn't that where all this started? So how does the Valero gas station not matter? It matters because it gives you context. We want you to see what happened before. Because if we came here and only showed you the graded video of the incident, you're like, well, what happened? What happened before that? I want to know how they got there. So we're giving you that. And in giving you that, oh, it don't matter. It matters because that's why we're here today. It matters because the defendant thought that Quentin Beavers stole his drugs. He was wrong. Oh, he was wrong. But you know what he did, ladies and gentlemen? What he did was called street justice. He didn't give Quentin Beavers what we're giving him. See, we're allowing the opportunity for us to go through each and every piece of evidence that we have against this defendant. He didn't give that to Mr. Beavers. He was at that door for less than 5 seconds before Mr. Beavers was shot in the head. He had made a determination in his mind that because Quentin Beavers was sitting in that seat where right beside his drugs, that he had to be the person that took the drugs. You heard from the store clerk. He said he doesn't have access. He cannot manipulate the videos. He can't go back. He can't show anything. And I'm going to argue to you that that's true. You know why? Because you saw in the video that we showed during his testimony that these two, the defendant and Mr. Parks, they were only at the counter for 14 seconds before they walked away. Ask yourself, and I'm glad he highlighted common sense because I'm going to talk about it a lot. Use your common sense and ask yourself, did the clerk have enough time to go back to the point in time where he thought his drugs were being stolen in 15 seconds of being requested of that information, pull it up, go through it, show it to this defendant, Mr. Parks, before they walked away from that counter? So you have to use your common sense for some of these things because obviously the state can't say every single thing that happened. The state can point out what we saw in video and what the witnesses experienced. But in 15 seconds and 14 seconds and 14.6 seconds, was all of that able to happen? But that's the information that was given. Mr. Parks believes that they were able to see this on the camera. The clerk came in and said, he can't touch the camera. We had to request that through his cousin, the person who owned the gas station. The gas inn doesn't matter. How does the gas inn not matter? Isn't that where he got the gun? Because you heard testimony from his friends and from Miss Hannah. She said that he didn't have a gun. Now, he said we can't have it both ways, but it sounds like that's exactly what he's trying to do. Because if they all testified that he didn't have a gun at the store, but then he got a gun later, then he says that the state is putting in we're going to put it in your mind that the gun just came from Quentin Beavers. But you heard the testimony from the witnesses. When we questioned Miss Hannah, when we questioned Mr. Rail, both of them testified. They were people that were present that Mr. Quentin Beavers didn't have a gun. She testified that she was intimate with him the night before. She knows he took his clothes off. There was no gun in her hotel room. She hung out with him the whole day. They went to the gas station, went back to her room. There was no gun. But now defense, because he don't want you to believe the evidence, he wants you to believe that somehow there was a gunshot. People reacted to a gunshot. Miss Hannah ducked. She runs. You see the big guy with the security shirt on. He falls. And as Mr. Rell testified, he stood there because he was shocked. And when you look at the video, because you know I played a couple times, you'll see that Mr. Rell stands there with his back up against the wall as he testified to. But he wants you to believe that Mr. Quentin Beavers brought the gun to the fight. Why? Why would he do that? He had no idea what was happening outside of that hotel room. He barely even was there for 10 minutes before the defendant came looking for him. It hadn't even been 10 minutes. Then he gets up and say that we didn't test the projectile. Test it against what? We didn't find a gun. You heard testimony there was no gun recovered. So what are we testing it to? Are we testing it to see if that was an actual bullet that went through the head of Mr. Quentin Beavers? See, so when we say use your common sense, think about the evidence that's being pointed out to you, where it's creating some type of, he wanted to create reasonable doubt. But ask yourself, they have the projectile. And in order to test it and compare it to, he wants us to tell you what gun it came from. Well, Mr. Carmichael took the gun with him when he left. And when he was arrested months later, he didn't have a gun on him. So what was the state or the detectives or GBI or anybody he just brought up was going to test the projectile to? I submit to you, ladies and gentlemen, that is a distraction. He wants to distract you, just like that sandbasket. It's a distraction. Our witnesses can't be trusted. That's a distraction. Which ones can't be trusted? The ME, who said that the victim was in a lower position and the person who shot him was in a higher position. And when we freeze the camera, regardless of how blurry it is, who do you see that's bent like this? Defense counsel wants to argue that just because his arm is bent and it's like this doesn't mean he had a gun. Okay, circumstantial evidence. I don't like talking about the snow. I like to talk about the gas pump. So circumstantial evidence, you know, because most of us have regular cars. If you have an electric car, just think about when you had an actual car that filled up with gas. You go to the gas station. Let's just assume for my hypothetical that you don't go inside to pay for the gas. You go to the pump, you put your credit card in, pull it out. When you pull up to the gas pump, we're assuming that your gas is on empty. You put your credit card in, you pull it out, you press whichever grade of gas that you want. You pull the nozzle from, you know, where it's hooked up to, you put it in your car. Some people, like me, a little clumsy, can smell gas because maybe a little leaked out before it went into the tank, right? Some people can feel the gas going into the car as it's pumping. Some people you can smell it. You can't see it going into your car, right? But if you get in your car and you turn on your ignition and the gas nozzle don't move from empty to full, you're gonna have a problem there, right? You're gonna go inside and you're gonna let the clerk know, hey, I put gas in my car, but it didn't fill up. It didn't even move. Something's weird, but it took my $50. That is circumstantial evidence. You did everything that you needed to do to know that once you got done, you put the nozzle back onto the gas pump, that you put gas in your car. That is circumstantial evidence. You never actually saw it go into your car, but you know you did everything that you need to do for it to be there, right? Same thing here. He keeps talking about over and over and over about this gun situation. Oh, well, no one saw the gun in the defendant's hand. No one this and no one that. No one placed it in his hand. Okay, ladies and gentlemen. Did he shoot from his finger? He wants you to believe, he said he's not here saying it today, that our victim shot himself. He said he's not trying to contend that. So if he didn't shoot himself, the only other people that were standing at the door was Miss Tiaja, who said she didn't shoot him. Was Rail, who had his back up against the wall, standing there. You could clearly see him with his all-white jumpsuit on. He said in his testimony he didn't shoot him. They both testified that the only people that were standing right there when the shooting happened was Miss Tiaja, who she testified that she was there, the defendant, Mr. Carmichael, and Quentin Beavers. Those are the only three. So what we have in this moment, when the gunshot goes off, when he intentionally fires the gun, is circumstantial evidence. Because everything else was the direct evidence. Him leaving the gas station, him going to the gas station, getting the gun, him talking to Tiaja, and then coming down and hiding, laying and waiting in that corner for his opportunity. All that was direct evidence. You can see that. You can see him reposition himself. What you can't see is the actual flash of a muzzle, right? What you can see though is the reaction to the people who are standing there. And what do? Fall, run, stand there like you were a ghost. And what does the defendant do? Calmly bend over. It can be argued that if there was a shell casing, maybe he picked it up when he was bending over. But what do we watch him do on the camera? He walks away. He shoots someone in the head and walks away. Because it's exactly what Ms. Lindsay said. He was calm, scary. He wants to highlight this calm word. She never said he was calm. You know, he was chill. He wasn't mad because she said that. She said he was calm, scary. When you go to the back, everyone that was taking notes all week, flip through your notepad. Remember what the testimony was, not what he wants you to remember from what he wants the evidence to be. Calm, scary? What is calm, scary? Exactly what he was. He walked and talked to Ms. Hammond. He then repositioned himself. He walked. He wasn't running. He wasn't doing any of that because he did this with intent. It was deliberate. These are things that he did because it was calculated. He wanted to make sure he carried it out. He was upset. He thought that the victim had his drugs. He was wrong. But because he took that on, he wanted to make sure he had the resolve. And his resolve was shooting and killing Quentin Beavers. Let's talk about some more of the trust issues with our victims. So they don't want you to trust, let's say, Ms. Lindsay, who's been a defendant's friend for 15, 20 years. When you heard back the hearing that she was a part of, what she said was she doesn't want to be here. She didn't want to do what she was doing, telling what her part of what she knew happened. Because she said she wasn't there when the shooting happened. But even though she wasn't there when the shooting happened, please tell me how Ms. Lindsay could have known or to say to the defendant, are you really going to go and shoot him? How would she have known that before the shooting if the defendant didn't tell her he was going to get his piece? And let's not act like we don't know what a piece is. Because whether we know that or we call it a piece, we watch enough movies and shows to know that a piece is a gun. But don't take my word for it. Listen to what was said here. The testimony that came out here through reading of the transcripts, through the videos that we played, was the piece meant a gun. He was going to get his gun because he wanted to shoot Quentin Beaver. Her response was are you really going to do that? And we'll play it again so you can hear her. Because remember, she's giving her recount of what happened before he gets out her car at the gas station. She said to you, he told me to pull up at Quentin's house. Defense wants you to think that there was no conversation between these two. He wants you to think there was no conversation at all. He's mad and she just drove him to the gas station. There was nothing said in the car. Yet she said that he was on the phone. Yes, Mr. Finney came in here and said, yeah, I didn't talk to him on the phone. But what did Mr. Finney say? What did you hear him say this morning? He said that the defendant came to his room. So Ms. Lindsay's memory can't be that bad, right? If she's remembering that she said to the defendant before the shooting, you really gonna go shoot this man? You really gonna color outside of the lines and shoot him? This is before. She said, he told me to pull up in front of Tay's house. And what did Tay just come in here and say this morning? Now, he didn't admit to giving him a gun. He knew not to say that, right? But he got you close. He said, I gave him some cigarettes and he came to buy some. He spent $2. He was in and out. Right? What is his motive to lie? That's his friend. How long he tell you they've been friends? Since we hot. They've been friends for a long time. But doesn't that corroborate what Ms. Lindsay said? Because Tay wasn't there anymore. Remember, he left the gas station. He said that when he got home, then he saw the defendant, which is the same evidence that we've shown. He left the gas station, the Valero gas station, and he went to his home, to the Guest Inn Hotel, and went to Tay's house. That is what Ms. Lindsay said. He doesn't want you to trust anybody that's defense for Mr. Parks. Oh, Mr. Parks. He got on his stand, and he changed, and he changed, and he changed, and he said, oh, I'm scared of this, and my son's locked up that, but yeah, I mean, I took him, I didn't know what was happening, my car was stalling out, I was there for 20 minutes. I don't even know if you were able to follow what he was saying. But what motive does he have to lie? This is his friend. And he told you, I have a son that's in jail, and by me doing this and being on this side, I don't want to do that. I've never been on this side. I don't want to be here. This is gonna be ramifications for my son, period. Why is he understand acting like he don't know that the defendant lost something? He's with him in the store. He's going up to the counter asking, talking to the clerk about it. The clerk testified that he knew they were missing something. He knew the defendant was looking for something, but he didn't know what. He just know that the defendant was mad. What motive does the clerk have to come in here and say that this defendant was mad on April the 5th, 2024, if he wasn't? Now, this is a person that has no skin in this fight. No motive to come in here and tell you something that happened and didn't. He came in here and told you he was mad. So mad that they were yelling outside the store that he went outside the store and was like, if y'all don't leave, I'm calling the police. He talked about the defendant not bringing the gun. I touched on that. I'm not gonna repeat myself in the things that I talk about. But the thing that got me the most, believe the state because we're the state. Oh, I heard it so much. I couldn't even sit still because I heard it so much. Mr. Mitchell got up and said, oh, I know this is how it's done because I used to be a prosecutor. And that's what we do. Well, maybe when he was a prosecutor, that's what he did. He got a case, he just prosecuted because that was his choice. But that's not how me and 88 Charles is prosecuting this case. We're not in here telling you to believe what we say because we're saying. I started by telling you, don't believe what I say. Believe the evidence. I'm going to guide you with the evidence. That's it. But for him to keep saying the state wants you to believe we want to win, for what? We don't want to win. We want justice for Quentin Beavers. Because what happened to him was not supposed to happen to him. He don't get to take justice in his own hands and make a decision. If someone stole something from him, then what do? What would you do as a reasonable person if someone stole something from you? Oh, he can't call the police, right? Because what he's doing is illegal. So the only option in his mind is to go and handle it himself. We don't allow street justice in Fulton County or no other county. And remember what this defendant did. This defendant went to two different counties to carry this out. The gas inn is located in Cobb County. He went to Cobb County to get the gun and came back to Fulton County to look for Mr. Quentin Beavers to execute him. That's what he did. So don't believe us because we're the state. Believe us because we're showing you the evidence. Believe what we're showing you, not what we're saying to you. Believe that what we want here is what the law says. That's it. We have no motive to want to send this to put evidence on this man that doesn't exist. Why? Why would we do that? So it's not believe the state because we're the state and because we work for Fulton County. I mean, he didn't tell you that he was only prosecuted for about 1.5 years. This is probably his most serious case. So that's why he was probably doing all types of whatever. And this is how we all did it. No, this isn't. Because as we shown you, we have evidence on why Mr. Carmichael is guilty of all of these charges. Let's talk about what this case is about. This case is about cold, deliberate intention. His cold, deliberate intention. Think about what's been said through our trial. The defense counsel got up to you just a few minutes ago and said, it was an accident. Now, I don't have to go through a lot, right? Because he just stood up and said, yeah, that was him. Yeah, he was there. He had on the same clothes. Okay, check. I'm going to go through it just so you can remember that that's what was just said, right? He put him there. But the state can't prove how the gun went off, right? That's what we're down to now. But before we get to that, let's talk about all the laws he broke before he even got to a point of some fake accident that we're talking about, right? Was it an accident when he intentionally got into a vehicle and went and got a gun? Was it an accident when he's saying in a car, he is about to go do something to an individual that he don't even know have his drugs? Was it an accident when he intentionally went to the economy lounge? Rail testified that while he's going around serving people, he said he was dealing drugs. And while he's going around serving people, he hears someone say, where is that explicit person at, right? That's what his testimony was. And then that's what drew him to his friends, where his friend was staying, because that's what he heard. You can see on surveillance, you'll have all the surveillance, even what we didn't highlight for you, right? You'll have the whole entire surveillance. And as you go through that surveillance, just, you can just take it and move it and you will see it's like fast forward, right? You will see Rail is walking around the hotel, doing what he testified that he was doing, selling drugs. He's in the front, he's in the back. But remember Mr. Parks' testimony, the person that we can't trust, right? He testified that when he arrived at the Economy Hotel, he saw Rail on the second floor when he went to the back. So when he came around the corner to allow the defendant to get out of his truck, he saw Rail in the back of the hotel. That's his testimony. And he said that when he pulled in, he saw Miss Tiaja on the front. What was her testimony? Her testimony was that she left out the room and she left Mr. Quentin Beavers in the room so she wanted to go get marijuana for them to smoke for the night. Mr. Beavers had just given her $10 that he got from Mr. Tay, who just testified this morning that he gave him $20 because he asked for it. He gave her 10 of those dollars. She left out the room to go get marijuana. Now, but for that marijuana, maybe the defendant wouldn't have located Miss Tiaja, right? Maybe they would have been inside the room and this wouldn't have happened. But because she was out getting drugs, she encountered the defendant going back to her room. And what did she say when Officer Sagal came in and she testified? She said that Miss Tiaja knew who did this, but for giving them a name, she knew that the person who stopped her was the person who shot her friend, Quentin Beavers. That's what she testified to. She said it was common sense. She said it was just her, it was Mr. Beavers, and it was the defendant standing at the door. She heard the gunshot. She even said that she assumed it was from his right hand because she was on his left side, and she knew she didn't see it on his left side. But we all know from the evidence that Mr. Quentin Beavers was shot. And we know that Miss Tiaja Hammond didn't do it. We know that Mr. Rail Lawrence didn't do it. Defendant murdered Quentin Beavers on April 5th, 2024 over a petty amount of drugs. Period. That's what happened. Circumstantially, all the physical evidence, the direct evidence, the medical examiner's testimony, the surveillance video, the witness testimony, they all point where? The same direction to this defendant. The same. Now I want you to, I'm gonna bring the bigger board so you can see it. Like I said, Mr. Mitchell already stood up and said, oh yeah, he had on the same clothes. But it's my job as the state to prove to you beyond a reasonable doubt that this is the defendant, right? So regardless of his defense attorney getting up saying this is him because he had on the same clothes, he was there, I'm gonna still go through it. Defendant, this is at the Economy Lounge. This is when he's about to reposition himself to lay in wait for our victim. This is the defendant inside of the store. What does he have on, ladies and gentlemen? A Nike vest, which is what was the testimony that came out during trial. What does he have on? Some Jordans, which is the testimony that came out in trial. And then when he goes to the Economy Lounge, the same outfit he's wearing is here. Same shoes, same exact Jordans, the jeans that he had on in the store, and the jacket with the long sleeve black shirt up under. I don't have to spend much time on that. You know why? Because he just got up and said, well, this is him. He had on the same clothes, he was there. But when you go in the back, remember your evidence. Remember what you wrote down. Remember what the state showed you as physical evidence. This is direct evidence that this defendant was not only at the gas station with this outfit on, but he's the same person that's at the incident location moments before the victim is shot. Thank you. Let's go through some of the evidence. I remember a lot of you taking notes, but again, this is when I'm going to point out some of our exhibit stickers that way, or the state's exhibit. So if you want to look at it yourself, it'll be in the back. You can look at it. But the 911 call that came in from Shirley Drive, which is Fulton Industrial, where this incident happened, the Economy Lounge launch. It was at 10:44 p.m. That is state's exhibit 1, D as in David. You're able to look at that and you'll see what time that call came in. So you know for sure at 10:44 p.m. someone was calling 911 and you were able to hear those calls. You heard from Ms. Tiaja and she gave a description of what happened. At one point, you were able to hear her have a conversation with Mr. Rail. And she's telling Rail, I didn't let him in my room. I knew he didn't have his SHIT. She repeated that on the 911 call because this is what it's about. Mr. Mitchell wants you to believe that the state created this story to make it be a part of our evidence. No, this is the story. We weren't there. These are the people who were there who can say what happened. She's saying in real time on a 911 call that this is about his drugs, and she knew he didn't have his drugs. She's yelling and saying this on a 911 call. Next piece of evidence, of course, you have the comedy lounge. This has been what we've talked about the entire time, and this is probably the best photo. When you get in the back, you'll have all the photos. But this is one of the best photos that you will see of that hotel, because you can see how long the front is, and you know from the evidence that we've shown you with the video, even though the video may be grainy, you know that Miss Yada stays all the way down here at the end. And you'll be able to get better views of it from the photos that you look at in the back. But you know she stays at the very end, maybe 2 doors down from when Mr. Parks let the defendant out. You know that from the maps that we showed you, that walking, it only took them less than 5 minutes to walk from the Valero gas station back to the hotel. Evidence. I know defense counsel just mentioned that, oh, Rail doesn't know if they, 133 was baby mama room or if it was Tiaga's room. Now, we know that Ms. Tiaga testified that 133 was her hotel room. We know that this is her hotel room because this is also where Mr. Quinn Beavers was at when the murder happened. This is where the police responded to when they came to give him help. He's inside his room, he's taking off his hat, and he's relaxing. He's listening to music, as she stated. They're just relaxing for the evening. Room 133. Dr. Simon, I'm not gonna go over this too much because ADA Charles covered this, but just remember the evidence that she talked about when she was on the stand about the direction of this wound, the entry wound, the exit wound, and how the victim would have had to be positioned for this wound to happen. Front to back, downward, slightly to the right, from left to right. You'll see this video a lot. You may watch it a lot in the back. And not sure if you even know how to work it, but when the Zoom is on for VLC, there's some words right here that says Zoom. You have to click that with your mouse and this box will go away. I know we have it here because we're showing it to you in Zoom form, but when you're in the back, you can make that go away by just touching the letters, right? They're very small, but when you touch it, the box will go away. The purpose of the box is for you to be able to zoom, and you can move that box to the right-hand side if you need to see a better view. But just comparing what the evidence is to Dr. Simon's testimony, this is the defendant, which now we'll have a problem with saying it's the defendant, right? Because counsel just stood up and said this, he was there, he had on the same clothes, but this is him. And because his arm is up doesn't mean anything. Well, does it not mean anything? Do you see anyone else in this moment doing anything with a gun? When it plays, obviously this is a little blurry, but when it plays and you watch it, watch for all your characters. You'll see the security guard, he's standing behind Miss Tiaga. He's pulling her back. You'll see that he trips over the stump, the parking lot stump, he falls. You'll see Miss Tiaga run. You'll see Rail. This is Rail, he identified himself with his all white. He's easy to notice. Every time you see him, he has on his all white. He stands there. And when you're watching all the people who are moving, just focus on what the defendant is doing. Is he calm, scary? Is he executing? Is he resolving? Is he taking out his intent? Is that what he's doing in this moment? Does this look like an accident, or does this look like intentional actions? Where he walks up with his hands in his pocket, but somehow with the fight, you also get your gun out and shoot the victim in the head. Accident? No. Intentional? Yes. This is the surveillance video. You heard from Special Agent Bernie that the defendant was at this area of the gas station between 10 and 10 p.m. and 10:26 p.m. And then you will see the defendant with his phone in the store. Just point out slightly, we know the defendant had a phone. We had testimony that came in that he had a phone registered to him with his phone number. There he is in the store using his cell phone. Here's his T-Mobile records that states exhibit 131B as in boy. And you will see that Mr. Carmichael has a cell phone. Even though you may have heard testimony that he didn't have a phone, there he is using the phone in the store. Ms. Lindsay said he called her. Ms. Lindsay said he was on the phone in the car, but her memory is supposed to be so bad, right? No, she remembers because this was also something that she went through. She knew that she drove him from that store. So she remembers what was important. She may have bad memory. Who knows? I might have bad memory too. I might not remember every single thing I've done from the time I woke up today. But does that mean I'm going to leave out or not remember some important things like my friend of 15, 20 years having a cell phone? Or me picking him up knowing that he's about to go shoot somebody? She remembered that. But it's the same number that TT testified was in her phone saved on the peanut. It's the same number that she said she called the defendant when he asked her to pick her up from the store. Now, this is just a zoomed in video, direct evidence, not anything that state's making up. Video evidence of the defendant doing what? Getting his drugs out at the store. He's hiding them in a little box. He's gonna break that rock thing, which the testimony came in, it was cocaine. That's what he's doing. And you can see who's sitting here. Direct evidence testimony came in that this is Mr. Beavers. That's Mr. Quentin Beavers sitting there. And I guarantee if he could redo it, he wouldn't sit there. Because him sitting there is what got his life taken. He didn't take anything. He sits there, he talks to the defendant. The defendant's doing what he's doing. But because he goes back and those drugs are no longer there, then it's Mr. Quentin Beavers that had it. Ms. Kimberly Lindsay arrives to the gas station at 10:13, and I want you to remember, I know Ms. 88 Charles went over this, but I do not want you to be confused in the back with the different times. We know that the times were off on different cameras. We know that they were inside of, based on the testimony, not what I'm saying, but what you have actually seen. The people who testified, the clerk who said the time was off on their cameras, the lead detective who said the time was off, but at this particular gas station, by 3 hours. So although when you go in the back and you'll see 7:12 p.m., you know that that's actually 10:12 p.m. This is when Ms. Lindsay arrives. You have all the parties inside the store. You have Mr. Quentin Beavers here. We have Ms. Tiaja, also heard TT a lot. You see Mr. Parker here, Mr. Parks here, and then the defendant standing there. All in the store. There's no argument between the victim. There's no disagreement going on. And one of the clips that I showed during one of my direct testimonies, you see the victim and the defendant laughing with each other, talking, having polite conversation, or some type of conversation that created laughs from it. And you know from testimony from both Rail and from Ms. Tiaja that they walked from the Valero gas station at 10:21 p.m. and they walked back to the Economy Hotel. This is the video we showed during trial. It's not something the state can make up. This is something that happened in the past. This is something we gathered as evidence to show you that these three individuals are walking back to the Economy Hotel together at the time that they said they were walking. Now, after they leave, that is when the defendant goes to look for his stash. 10:22. They've been gone for 1 minute. He's looking for his stash of drugs. He doesn't find it. He goes up to the clerk. He asks the clerk questions as he's talking to Mr. Parks. You'll see him come up, talk to the clerk. Mr. Parks wanted to tell you that he was going to cash in a ticket. Do you see a white ticket or any type of ticket in his hand? Did he give the clerk anything? The clerk testified that when they came up to him in this moment, he knew they were looking for something. He knew that the defendant was mad about something that was taken. He never mentioned anything about anyone cashing out a car or winning or any of that. Then after they go to the clerk, They leave the store. They leave out of the store and they go outside where the defendant gets in the car with Miss Lindsay, and then Mr. Park, he gets in that white truck that we've talked about the whole time. Now, you know, when he testified, he said there was no one else that got in the car with him. But from the video that you'll have, that you can see, because the state can't alter that, you will see someone else get in his vehicle with him. You will see the lady with the braids that Miss Tiaja was talking about. She gets in the car with him. The same lady who gets out of his car when they get to the guest inn. This is just the defendant going to Miss Kimberly's vehicle. Clerk comes to the door. And then you have the defendant leaving the Valero gas station going towards the guest inn. That is where Ms. Lindsay and Mr. Parks, they both go together. Defendant is in the car with Ms. Kimberly Parks, and they drive to the hotel, which is 6 minutes away drive. A whole nother county, but y'all know how this is in Georgia. You know, the counties are real close together. So they're in Cobb County now. He goes and get his gun that he's been talking about, his piece, which was AKA defined during testimony as a gun. They leave at 10:26. Based on Mr. Barney's testimony, his phone puts him leaving the Valero gas station, going to the guest inn. Now, I don't need to harp on this because, you know, we have an admission that on somebody's word that the defendant was there, and then, you know, we can't prove that it's an accident, but the evidence that the state is not making up shows that he went from the Valero gas station to the guest inn hotel. Ms. Lindsay, what did they discuss while they were in the car? What did we just play for you this morning and last week? She said that while they were driving, she's talking to him. He responds, but what she said to him was, "You really gonna go shoot this man? You're really gonna go shoot him? You're gonna color outside the lines," is what she said as they're driving to the guest inn. And you know how we know is when they were driving? Because one, she said it, right? And two, we know that Ms. Lindsay didn't go to the economy hotel. We know that he got out of her car at the guest inn, and that was the end for her. So she only talked about what she experienced. Her knowing that he's in her car, scary mad about his dope being taken. And then he got out while she's trying to convince him not to do what she knows he's about to do. Not because she's speculating, but because he's told her. And then she additionally hear him on the phone with whoever he was talking to. She did say, "I think it was Tate." She didn't say, "Oh, I put out every dollar in my bank account on it that it was Tate he was talking to." She assumed it was Tate because then he told her to pull up in front of Tate's house when they got to the guest inn. So it was an assumption. Hey, maybe it wasn't Tate, right? He testified that he didn't talk to the defendant, but he did testify that he went to the defendant, came to his room. He was only there, he was in and out. That's what his testimony was. But see, that for him, that's not nothing. There's nothing wrong with the defendant coming to his room, buying a cigarette or some alcohol, right? Meanwhile, Mr. Quentin Beavers, Ms. Tiaja, and Mr. Rell, they all get back to the Economy Hotel. 10:28. You'll see them walking up. They come. You'll see Rell come first. He's in front of Ms. Tiaja and Quentin Beavers. You'll always see him with his white outfit on. This is after they left the store. They're arriving. You know, when you see 18:28, you know that the time is off at this hotel. It is really 10:28 p.m. That is Mr. Rell walking in. And then you'll see, here comes Tiaja. And then here comes Mr. Quentin Beavers coming down. When you're looking at these videos, ask yourself, when you heard people testifying as to what happened and what they were doing that night, is it consistent with what you see in the video? So they've arrived. States Exhibit 106. Meanwhile, they go into room 133. Right before they go in the room, what did Miss Tiaja testify to? She said, "We stopped by Rell's baby mama's room." And I'll talk to you about that later. So remember that. She said they stopped by Rell's baby mama's room before they went to her room. Here, you'll see in a different video that I'm going to show that they come out of Rell's baby mama's room and they're going to walk down to her room. When I say they, I'm talking about Tiaja and the victim, Mr. Quentin Beavers. They go into her room, and although this thing say 1831, based on the evidence that you heard, from the lead detective, the time is off, is really 10:31 PM at this moment. And there is a victim now about to enter Ms. Tiaja's room. Little does he know, while he's entering her room 2 minutes later, the defendant is at the guest end getting a gun that's gonna be used to murder him. Now the defendant, he's arriving at the guest end at 10:33 PM. Now this is probably the only camera that's right, because it actually says 10:33 PM. Well, it says 22:33, but if we know military time, we know that's 10:33 PM. And you see Mr. Parks, who said he didn't know what was going on, he had no clue what was going on. This is him parking, and then you'll shortly see Miss Lindsay, that's driving the defendant, pull up in their vehicle. And we know, based on the direct evidence, ladies and gentlemen, not anything that the state is making up, but we know based on the direct evidence that Mr. Carmichael was not here long at all. We're gonna see when they leave. So it's 10:34 PM and 19 seconds. This is when Miss Lindsay said she pulled up to Tay's room and she saw the defendant go into Tay's room. What did Mr. Tay testify to this morning? Mr. Finney, Tay Finney testified to this morning that the defendant came into my room, right? That states exhibit 119. Now states exhibit 108. You see the Ford Explorer, which is the vehicle Miss Lindsay's driving, pull right up, not right here beside Mr. Parks, but down there where Mr. Tay's room is located. Your Honor, I'm sorry, ladies and gentlemen, the ADA Charles touched on this in her open close. She talked about how the state doesn't have to prove premeditation or motive. Actually, ladies and gentlemen, I can tell you, because I've been working here 10 years and I've tried many murder cases, and I can tell you that we don't have to prove motive and premeditation, but guess what? We never even have it. Most of our trials that we have, we don't have these things. What we have in this case is not only motive. Why did he do this? That's what motive is, right? Why did he do this? Because he thought Quinn Beaver stole his drugs. Premeditation. The steps that he took to do what he did, right? What did he do? He left the gas station, went and armed himself with a gun. He went and looked for Quentin Beavers. He didn't know where Quentin Beavers was. Ms. Tiaja testified that he had never been to her home before, her hotel room, which is her home. He never been there before. And we know that to be true because guess what he does? He walks right past her room. When he sees her walking, you'll see it, he walks right past her room to encounter her. And what was the question that's been consistent the whole time? Where is that explicit at? Where is he at? Where is Trenches? Because he got my stuff. He stole my stuff and the clerk showed me. Well, he started off not telling the truth. The clerk said he couldn't even access the account. But the clerk showed it to him, right? In those 15 seconds, the clerk showed him a video. And now he's saying that to Miss Tiaja. Tiaja's like, wait, hold up, let me see what you're talking about. Let me go in here and ask her myself. Isn't that what she testified to? Is that not what the video shows? Planning. This was a plan. He didn't have a car. He needed somebody to take him over there. He needed someone to wait for him. Because he needed to do what he was going to do, which was murder Quentin Beavers, shoot and kill him. And then he needed someone to take him away from there when he was done. And who was that person? Mr. Parks. Mr. Parks wants to get on the stand and say that, oh, the state threatened him, the state did this, and the state did that. Well, he also said that when he first initially talked to the state, which was 88 Hall, he said that this defendant pointed a gun at him when he got back in his car. And that's why he drove. He said he heard the shot. But when he came here and testified, he told you at the very beginning of his testimony before 88 Charles challenged him, he said, oh, it could be any shots. It's Fulton Industrial. It's just what could have been a backfire. It could have been anything, right? Because whatever reason that he thinks he's involved, because aren't you involved in something when you take someone to a murder and take them away? So of course, it could have been anything. I had no idea that he was going to shoot and kill anyone. But you told us that he pointed a gun at you to make you drive, right? Now, which one is the truth? The video that we've shown over and over, this is before the actual murder. You see Miss Tiaja leaving out her room? at 10:34 PM, she's going where? To get the marijuana that she testified to going to get. She said she left Mr. Quentin Beavers in the room by himself. He was listening to music, and she went up to another floor and got her marijuana. That was what I was talking about at the beginning of when I first started talking. Had she not left out, this wouldn't happen. He wouldn't have seen her coming back. He wouldn't have seen what room she was in. He didn't know. Back to Mr. Bernie's testimony. Now, not only did he put the defendant at the Valero gas station, he then puts him at the Guest Inn. Now, finally, he puts him at the actual economy hotel. And what's tracking that? His phone. He talked to you about how his phone records followed him. How it's hitting off the towers. It shows that he went from the gas station to the Guest Inn, and Ms. Parks did it. Ms. Parks took him. At 10:40, what do? They leave the Guest Inn, and now they are arriving at the economy hotel. And if you remember Mr. Parks' testimony, he said that he was there for about 25 minutes. You know, it's hard to remember a lie, and we all know that. See, the truth is, they was only there for 3 minutes total, because we know, and I say 4, just if we want to stop it when the 911 call came. We know for a fact, evidence, ladies and gentlemen, that the 911 call came in at 10:44 PM. They get there at 10:40. They couldn't have been there for 20 or 25 minutes while his vehicle is stalling in the back, right? I can tell you that he has motive to not be honest with you. States Exhibit 106C, 10:40 PM. You just saw Mr. Parks' vehicle come past. He's at the end of that hotel. He's turning. Now he's gonna let the defendant out of his vehicle. The defendant's getting out his vehicle. He got his hood on his head, so he's covering up his face. And he sees Miss Hannah walking from getting drugs right here. And he's gonna stop her. They're gonna talk. Maybe a minute and a half, they're talking. She testified that during this conversation, he's asking her, where is he at? Where's Trenches? He got my stuff. She's like, no, wait, no, let me go ask him. That's what she testified to the conversation being right now while they're standing off away from her room talking, right? Evidence. Not anything the state wants you to believe. The state wants you to believe your eyes and use your common sense. Is this really happening? What she said was happening. Do she have a reason to say that this is happening when it really wasn't? And that is stated at 106A. You can see that Miss Tiana is gonna walk away from the defendant. She's gonna come down here to her bedroom, to her hotel room, and she's gonna go in like she testified to, right? That she went in and she asked Mr. Quentin Beavers, do you have his stuff? And she said, Mr. Beavers responded that he did. It is 10:42 and 43 seconds. She's going in the room. The defendant is following her to reposition himself down here. Why is he doing that? Ladies and gentlemen, is that a part of his plan and his scheme and his intent to carry out the killing of Mr. Quentin Beavers? Because why is he moving? Defendant, Ms. Hannah. He makes a decision. He could go in right now, right? If he wants to ask questions about these drugs that were stolen, he could go in right now. What is he doing? He saw what room she went into. He went past it because he wants to reposition himself. And then I want you to pay attention to here. Because remember, Rail testified that he heard someone calling out for his friend. Where is that? It's listed there. He heard him, right? So he said, I came down. I came down to see what was going on. So you'll see him. Make sure when you're looking, you'll see him in his all white because he has it on the whole time. Ms. Tiana said she testified that when she came out of the room, she saw Rail and the security guard man coming, walking. She didn't know what was going on, but she saw them. She didn't see the defendant where she expected to see him. What direction is she facing? She's looking that way, where she left the defendant. Where is he at? He's repositioned himself to the end of her hotel room. Why? Because that's a part of his plan, his scheme, his intent. She said she stood at the door, she talked to him. She said, I know you didn't have, I knew. Then she's gonna walk out. And when she starts walking, here comes the defendant. He's going to the room regardless if she's there or not. Now that she's moved out the way, because she's not the problem. She's not the person he thinks took the drugs. He's going to confront Mr. Beavers and shoot him and kill him. That is what he's doing. His hands is in his pocket. Now, I want you to ask yourself, use your common sense and reason, ask yourself, how does he shoot a gun by accident if his hands are in his pocket? His intent had to be to pull that gun out, right? If he shot it from his pocket, where would the bullet have gone? Just pay attention to what's going on. She sees him, so she immediately turns around to address him. That's her talking to the defendant. He don't want to talk to her no more. He just talked to her for a minute and a half. He's going to the room so he can deal with the person that he thinks stole his drugs. Again, we know it's blurry, but when it's not zoomed in so close, you'll be able to see, this is her standing here, this is the defendant. You can still see that, even though it's a little grainy. You can see who's standing there in this moment. When the tussle starts to go, no, this is Miss Tiaja. She's the only one actually gets into the room. This is the security guard, this is Rail. When the gunshots go off, you're gonna see, he's gonna fall. The security guard falls on the ground. The defendant has his arm up, shooting the victim in his head. Tiaja's right here leaving, and you will see Rail just standing there. Yeah, he didn't know what to do. He told you he was shocked. He was stunned. He just stands there. What is he doing? Standing there with his back against the wall. What could he do? I asked him, did you have a gun on you? He said no. What could he have done to help his friend in that moment? So now that it's not so zoomed in, you see the victim's foot is right here. You see he's falling, Tiaja's left, he's standing there. And the other individual that you may want to know what's doing, he's nowhere near the door. So although he walks up with them, he didn't even make it to the door. And what happens after the shooting? What is the defendant doing right now? He shot him. He's laying on the ground. His foot's right here. What is he doing? What is he doing? Because what he's doing is intentional. He did this intentionally. This is deliberate. And then look at Rail. Rail just stands there. He looks down. He looks up. He's standing there. This is his friend. And I asked him, why did you walk away? Because look, you see Rail is going to walk away. I asked him, why did you walk away? He said he had a couple ounces of dope on him. So he went and put it up, and he came immediately back to help his friend. If it was about trying to see if his friend had a gun and take his gun from his friend, why he didn't just walk in the room and do it? He thought about himself first for a split moment, got rid of his drugs, and then he came back to help his friend. Then you will see the defendant faces it for 106. You'll see him running. And Mr. Parks, who lied and said that he wasn't waiting for the defendant, you'll see his car lights come on. And there's the defendant running because Mr. Parks was waiting for him. Then he picks him up at the top of the hill. If you notice the time, it is 10:43 p.m., not 18:44. 10:43 p.m., 39 seconds. And then what time do they arrive back at the guest inn? Phone records put them traveling from here back to the guest inn. 10:47 p.m. Took him, what was that? 4 minutes, 3 minutes? I don't even remember what time it showed. Don't believe me, believe the evidence. Right? 10:47 p.m. That is what time they get back to the guest inn after he's carried out his intention to shoot and kill Clinton Beavers. Period. Mistake? Where? Where's the mistake? His intent was to do what he did and then get out of there. And then what did the manager come here and testify to? He had been living in the hotel for 6 months. When the detective came back a little after a week later, he was gone. There's the defendant going back into his room. He left. And where was he eventually arrested? In a whole nother state. Months later, leaving town. That's additional evidence of his guilt. Detective Thomas went back on 2 different dates, the 15th and the 18th, and spoke with Mr. Taylor. The manager who came in and testified and told you that he no longer lived there, then him and Mr. Parks left. Mr. Parks wanted to come here and tell you, oh, I lost my business. Oh, I went back and they were giving me the runaround. Ladies and gentlemen, what was the evidence? The evidence was that he abandoned his truck. Why did he abandon it? Because he knew he was a part of it. He didn't want to have any conversations with the state, with the detective, just like when he came in here. Remember how he testified, his demeanor when he was testifying. He was like, I don't want to do this. Oh, I said that, but then I took it back. You know, like he didn't want to do what he was doing. He wanted to in some parts try to be honest, and in other parts still continue to lie about his involvement. Detective going to the hotel on the 18th. Not a coincidence. It's not a coincidence that he moves out of the Guest Inn hotel after being there for 6 months and then being arrested in North Carolina in August of 2024. Not a coincidence. This is a projectile that Mr. Mitchell wanted the state to test and compare it to nothing because Ms. Carmichael took the gun. But this is us collecting the projectile. And as Ms. Charles told you when she was going over the law with you, the testimony of one single witness, a single witness, and the judge will tell you this when he explains the law to you, because he's going to give you the law. The testimony of a single witness is enough to establish a fact. If you believe Miss Kimberly Lindsay when she said, you heard her say it, right? You're really going to go shoot him. You're really going to go shoot this guy? You're going to color outside the lines? This is a friend trying to convince another friend not to do a dumb thing that he's about to do, right? It didn't work, but she said it. You heard her say it. If you believe that she knew that was going to happen, if you believe that the defendant told her that, that's enough for you to believe that fact. That Ms. Lindsay knew about the shooting, that it was going to happen because he told her. When we get mad and we talk to our friends, sometimes we tell them what we plan on doing. In any situation, especially in this situation, she said she's never seen him mad like this before, never. But this day, he's calm, scary. Marco Parks, we've talked about him a lot already. We know that he came in here and he wasn't honest. He said that was because of his son being locked up. He said that because he's always used to being on the other side, whatever that means. He's not used to being on this side. Well, this side is the side that everyone wants, right? This side is the side where you tell the truth. Because if you get it wrong, if the state has it wrong, you get it wrong, right? But when the state has direct evidence and you have people who were standing there who came here and told you, I didn't do it. I wasn't even close enough to do it. Or I didn't even, by the time I got there, it was already happening. I heard somebody calling out for my friend, so I went to see what was going on, right? The same people that stayed around when the police came. The only person that wasn't there when the police arrived was who? Ladies and gentlemen, and that's evidence. That was the defendant. The only person that wasn't there. Mr. Finney, we talked about him. He said the defendant came to his room. He said he didn't give him a gun, but he was there for a short period and he left, right? We know that when the defendant went to the gas thing, he didn't have a gun based on the testimony, but when he left, we know that he didn't shoot the victim with his finger. We know that he had a gun. What Tiaja testified to, she said the same person that stopped her to ask her about his drugs being stolen was the same person who shot her friend Trench. The same person. She knows that. You know why? Because it doesn't take a rocket scientist to know if I'm standing here, there's a person standing beside me, and there's a person in front of me. It's 3 of us standing here, and I hear a gunshot. One of us ends up dead, 2 are still alive, and I didn't do it. What did she tell you on the stand? He did it. She said, I heard the gunshot and I ducked because it was my head was ringing. And what arm did she put up? What ear did she cover when she said her head was ringing? Think about that stuff, ladies and gentlemen. Use your common sense and reason when you're in the back going over this evidence. Think about every step that he took to make sure he did what he did to Mr. Beavers. She testified to, he keeps talking about this gun and Quentin Beavers having a gun. How many people testified that Quentin Beavers didn't have a gun. Matter of fact, he didn't have any money. He didn't have anything. That was what the testimony was, is that he didn't have anything. And then Mr. Finney came in here and testified that he gave him $20. 10 of those 20 he gave to Miss Tiaja to go get drugs. And that was her testimony. He gave her $20. She knew he had gotten it from Taylor. How is all of that consistent except for the one fact of a gun going off, or it just went off? Somebody was this pistol whipping thing. Didn't he have to take the gun out of his pocket for any of that to even happen? For that to even be a thing, he had to take it out of his pocket, right? But when he walked up, wasn't his hands in his pocket? They were. This was intentional. Quinn Beavers in life, he was just simply sitting at the wrong place at the wrong time. I know that's a cliche. We hear that a lot, right? You're in the wrong place at the wrong time. But this is that. This is exactly that. He did not take the defendant's drug. He just so happened to be sitting down at a store where his other friends are hanging out. And because of him choosing the particular chair that he was sitting in, his life was taken. Because of that decision, right there. I want to play a video where you can see for yourself some of the things that I just talked about. So that's the last thing that you hear and see from the state to show that we have no motive. We have no dog in this fight. We don't have to make up evidence. We don't have to want to win so bad and want you to believe everything that we say just to get a win. That's not what we're doing here. Quentin Beavers just deserve justice. But what happened to him? That was unjust. There was no reason why this should have happened to him at all. $18 minutes. It took 18 minutes for this defendant to intentionally create a plan and a scheme. His intent to go and murder Quentin Beavers. He left this gas station at 10:26 p.m. Same thing I've already been talking about. It's the evidence though. It's the evidence I can't change. I can't add or take away from the actual events that happened here that night. 17 minutes. He leaves this gas station. Mr. Parks testified he has no idea about what's going on. But he leaves the gas station with, following behind Miss Lindsay, or leading the way, right? They pull up, he pulls up first, and then Miss Lindsay and the defendant pulls up later. You know this because you saw it. Don't let the defense counsel play with you. Don't let him make you think that what we have as actual evidence, this is direct evidence. What time they left? We know that the time is off. Down there it says 7:26 p.m., but we know it's 10:26 p.m., right? They leave the gas station, and we know that they arrive at the guest inn. They get to the guest inn, where the testimony that came in was that the defendant went to go get a gun. What motive do his friends have to come and say that the defendant was going to get a gun if he wasn't, right? That wouldn't be anywhere in their minds against their friend if that didn't happen. But we see them pull up. We know that this is true. We know that they're there for a few moments. He gets out, he goes into Tay's room, and he comes back, and now he has a gun. We know that after he leaves Tay's room, he goes to the economy lounge, the hotel. The testimony that you heard, which is direct evidence, of the people who were there, Rail says that he was calling out for the victim. He was calling out. So Rail came to see what was going on. How did Rail get there at the exact moment that the defendant reached the door? Because the state contends that that is what happened. That he heard him looking for trenches, that he heard him looking for Quentin Beavers. And when he got there, I'm gonna forward pass some of this because I've talked about it. Technology has been an issue all week, and last week, but this is what I would say. Pay attention to the people who were involved. They are coming out of Rail's baby mama's room, just like they testified to. That is Miss Tiaja, that is the victim, and Rail is now going to go do what he said he do, serve, right? That's what he said he was doing throughout the hotel, walking around. He never really was stuck in one spot because he was serving people out here. You see that Mr. Beavers entered Miss Tiaja's room, and then you will see Mr. Rail come up on the side here because he's out serving people. Miss Tiaja's going to get her drugs, her marijuana, where the victim just gave her $10, and here come Rail right here. They were not expecting the defendant to arrive here on this night. They had no idea what was happening. They are just doing what they are doing. While the defendant is over getting a gun, they are about to relax. There's Rail. You see the defendant and Mr. Parks arrived. They 3 minutes and 15 seconds. That's how long they were there for this accident to happen. No, this was cold-blooded murder. This was no accident. This is his plan. You see Tiaja's coming. She's gonna stop him just like she testified to. Just like she testified to. They're talking. Look at the time going down. 18 minutes that all of this happened, from the time they left the gas station at 10:26 p.m. to the time 911 was called at 10:44 p.m. I know this is a video that's gonna be something you wanna watch. Like I said earlier, when you watch it, there's zoom capabilities. You can zoom in to where this close, just like we have it. You're able to actually see what's going on. You see the defendant putting the gun back into his pocket before he calmly, scary calm, right, walks away. When you're watching the evidence, which is, you'll have all the videos, you'll see that the defendant, you'll see that Tiaja is the first one that goes back into the room. You'll see that she goes back into the defendant, her room, she checks on the victim, and then then after she leaves out the room to call 911, you'll see that Mr. Rail goes into the room and he tries to aid his friend. You'll see him come out, he'll zoom in, you'll see him take off his jacket, he takes off his white jacket and another jacket, and he starts to help his friend. He's not worried about moving a gun. This defendant had 18 minutes to do what he did. 18 minutes. The state has one shot to get this right. To allow him the justice that he didn't allow Mr. Beavers to have. He decided that he was y'all. He was the jury, and he made a decision that Mr. Quentin Beavers did exactly what he said he did, and that was take his dope. He took somebody's life over something that was already illegal for him to be doing. He shouldn't have been selling drugs, and he shouldn't have had a firearm. But those are two things that he was doing, and then he went and tried to take justice into his own hands, street justice. That is not allowed in Fulton County. I ask you to hold him accountable for his own actions, his deliberate intent, and find him guilty on all the charges. Thank you.
All right, members of the jury. The next part of this trial is I have to charge you on the law that applies. That takes about 15 to 20 minutes. Do we want to take a break? We have at least one request. From here, we can go past 5. I want to be on your time from here on out. So you tell me, or we can break for today. I'll await your direction. Turn the light on when you're ready for the charge. All right, counsel, just based on some of the looks on the jurors, I think they're eager to get started. So we'll break for a minute. Don't go far. But before we do that, is there anything we need to discuss as relates to the stack of exhibits that are going back? On the part of the state, do we have the exhibits compiled?
Get started. I think we're more or less done. Yes, sir.
Okay.
Just one, but that's fine.
All right, well, if y'all could work on that when that's done, and then you'll just let me know if there's a point of contention at all. Otherwise, I'll send it back with Deputy Scott, again, along with a copy of the charge, the verdict form, and the redacted indictment. I think we should have that marked and tendered as well.
Okay. I had it.
Excuse me. And did we also get the stipulation marked and tendered?
Yes, we'll be doing this too now.
Okay. All right, we'll be off the record in recess.
Yeah, yeah. This is one.
Because you never gave it to me. I never got it. Like, you know, you remind me of, you know, when the babies come out and they're gonna get a baby curl and you have to curl on the sleep sack. So I think that was good. Yeah, but that's so sad. I think that's so bad. Okay. I think I know this is stuff with that. I meant to slow it down. Ooh, really trying to be sure. Just have it funny. I walk out there. Yeah, I just come back. Yeah. Yeah. Gloria, glory. Sorry, Judge Ashley. Yeah. What did you draw? Like that. be a good one. It's sad. It's very sad. Or they, pardon? To the child, baby? No, it's kind of like a good citizen. And this guy who was had a history of stealing cars and breaking into cars, he was at a lounge looking to see if he had to put it on the alley. So this guy broke into his truck, up on the market managers of the house, had the Carmichael's car. He's like, hey, man. And then the guy kind of runs back and they're just like, stop. What's the over life? Animal. And who is the attorney? It's cold. And then, hey, we're gonna join the issue on reductive map. That's fine.
Okay,
Don't
you wanna do it now?
Yes,
Or
please.
if the judge come back?
So now, so it's started.
Do he need to sign?
Huh?
Do my client need to sign?
Yeah. So this be.
So don't worry about it.
And the other one. Get that. Yeah, we were trying to get this in March for Wednesday. So it's like, we need someone, we only have one fair. So like, but this is definitely going every day. Right, so that's what I'm working with. Open to the table. I love it. Oh, okay. I went to just Simpson Day. Yeah. And then we had a color rental, so we just drove across. She said they got signed.
They don't have to.
They don't have
They don't have to. What's that? Okay, good. Well, that's not going back, but,
Yeah, she said it's not going.
all right, so we got,
It's like fourth, maybe third, fourth, right? I didn't see hot. Let's hear ready.
I see the stipulation that did the end, oh, it's right here.
Yes.
Okay. Okay. There you go. So you just want me to name the numbers for the record again? That's all one exhibit. I've got the other ones in here. Can we bring them out? Okay, I'll do it. Yeah. All right, I'll do that. All right, wait. I don't know where the state went. Maybe we can, okay. Yeah, let's do it. Just disappear. Nice. All right, we're back on the record. All parties and council are present. For the record, state has tendered States 150, which is the Douglas County Sheriff's Office. That is just entered for completion of the record. And the court's ruling in its evidentiary motion, it will not be going back. There's also the stipulation signed by both parties. It's got the old date on it.
I need to correct.
That doesn't really matter,
Okay.
but all right. And that's just States 155. And then we've got a redacted indictment of States 156. All right.
Find the redacted indictment, Judge?
Oh, I mean, you've already joined issue as part of the record. You don't, jury doesn't know about that or need to care about that. All right. So with that, we'll bring in the jury. Still working on the exhibits.
No, I think we're done.
All right.
Well, just these last three we had to just.
Then you
add
can put
to.
these on top. We got a box.
Yeah, we're good.
What we were talking about at the bench about the limited purpose. I mean, the charges, but you want to add it back, the limited purpose? You know.
Oh, no, that's in. That's in. That's in.
Oh, thank you.
Yeah, that's fine. All right. If we can bring in the jury. Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, you are considering the case of the state of Georgia versus Antoine Carmichael. The grand jury has indicted the defendant with the offenses of murder, felony murder, 3 counts, aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon, 2 counts. You will be provided with a copy of the indictment and these instructions during your deliberations. The defendant has entered a plea of not guilty to this indictment, and the indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of each offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and any exhibits admitted during the trial, and stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. The parties have entered into a stipulation that has been approved by the court regarding Exhibit 155. Where parties stipulate facts, that is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touched. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence, by inference, points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances, by direct evidence, from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based on circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence or both, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. The jury must decide the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. You have received evidence of prior convictions of a witness. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant does not have to present any evidence, nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose, or for some counts and not others. Such evidence may be considered by the jury for the sole issue or purpose, or only for the counts for which the evidence is limited and not for any other purpose. You have received evidence of prior convictions of the defendant. You may consider this evidence only insofar as it may relate to the required element of conviction of a felony for the offenses in count 3, 4, 7, and 8, and not for any other purpose or count. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged you regarding the credibility of witnesses. Some, but not all of the factors you may consider in assessing reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; 5, whether the witness on any prior occasion did not identify the defendant, in this case as the alleged perpetrator; and 6, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crime alleged in this bill of indictment. Evidence of the defendant's character, if any, has been presented to show that he acted consistently with that character in this case, and this evidence can come in the form of the opinion of another witness. You should consider character evidence, if any, along with all the other evidence in deciding whether you have a reasonable doubt about the defendant's guilt. The defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances, or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of the words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. An accident is an event that occurs without the defendant planning, expecting, or anticipating it. You may not find the defendant guilty of a crime if the alleged criminal act was committed by accident and there was no criminal intent by the defendant. If the defendant raises the defense of accident, this state has the burden to disprove accident beyond a reasonable doubt. A jury is not authorized to find a person who is merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime, unless the evidence shows, beyond a reasonable doubt, that the person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. For malice murder, the state must prove that the defendant, 1, caused the death of another person, 2, unlawfully, and 3, with malice aforethought. The killing must have been done with malice to be murder. Malice, as that term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without excuse. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If the killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the defendant must prove that the defendant, 1, caused the death of another person, 2, by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault with a deadly weapon and possession of a firearm by a convicted felon are felonies, which I'll define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. For aggravated assault, the state must prove that the defendant, 1, assaulted another person, 2, with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in the reasonable apprehension of or fear of immediately receiving a violent injury. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. For possession of a firearm during the commission of a felony, the state must prove that the defendant, 1, had a firearm, 2, on his person or within arm's reach of his person, 3, while committing a felony, which is a crime against or involving another person. Murder, felony murder, and aggravated assault with a deadly weapon are felonies. The term firearm includes any handgun. For possession of a firearm by a convicted felon, as alleged in count 7, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony, and for possession of a firearm by a convicted felon, as alleged in count 8, the state must prove that the defendant, 1, possessed a firearm, 2, after having been convicted of a felony involving the possession of a firearm. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any other element of the offense. Venue must be proved by direct or circumstantial evidence, or both. By no ruling or comment that I have made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status, for or against either party. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson, and the foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Talk with each other and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Do not begin your deliberations until you receive the indictment and any evidence that has been admitted in this case. Then you may begin your deliberations. We have prepared a verdict form for you that will be included within the evidence that you're permitted to have with you in the jury room. That should be fairly straightforward, requiring an indication as to each count on the indictment and a place to sign and date it. With that, are there any objections to the charge on behalf of the state? Any on behalf of the defense?
No objection.
All right. Members of the jury may now retire to the jury room. I think we'll have those exhibits for you very shortly. I'd ask jurors 39 and 40 to stay back, and we will be on your time. You let Deputy Scott know when you want to break for the day and return. 39 and 40. Does everyone remember who 39 and 40 is? All right. All right, jurors 39 and 40, as you might have gathered, you are our alternates in this case, but that doesn't mean you're off the hook just yet. I've had many trials where we've had to sub in an alternate even after this point. So what I would like to do is excuse you for the day. Deputy Scott will help you collect all your belongings, and you're free to leave. And tomorrow, you're free to go about your business and return to your normal lives. But you do have to stay under the obligations of your oath, meaning don't discuss the case about the case with anyone. And don't do any research about this case. we're going to give you a call and an email if we can't reach you on the phone to let you know if they've been able to reach a verdict without you and that your service is officially concluded. But I would ask, and I'll inquire if anyone would have a problem being within an hour and a half call time, essentially, where if we give a call saying we actually need you back here, you could be here in about an hour and a half. Would both of you be able to make that work? If you could remind me your juror number.
Juror number 40.
Yes, sir.
I'm supposed to be in Jacksonville for a work trip Wednesday and Thursday.
Okay.
Back Friday afternoon.
And you're juror 40?
Yes.
Okay, understood. And so we'll certainly make a note of that. Again, it may be possible that we call you in just for Tuesday, but at any point, if it's getting to where it looks like it's Wednesday, again, that's why we have alternates. Any other concerns? Otherwise, stay close to your phone tomorrow, but we may never see each other again, at least for the next year until next time. And I want to thank you so much for your time, and I hope you appreciate just all the moving parts here, why we needed alternates, and why we may still need an alternate. But certainly thank you for all the attention and work you put into this. So with that, we'll take care. All right, revisiting again the stack of exhibits. As I understand it, the state has compiled the exhibits in a box here that council have been able to review. We've placed the court's exhibits that I mentioned on top of those. Is there anything that needs to be on the record regarding exhibits on behalf of the state? On behalf of the defense?
No objection. No number you can take up.
Yes.
What is it?
Oh, that's in there. It's in there.
Okay.
No, that should be the instructions. 2 is the instructions. I didn't put a sticker on the verdict form. Yeah.
The charge to.
Yeah. Court 2 had already tendered as the charge.
Yeah.
If I didn't, okay, I'll just put this on the record. And if I hadn't done it already, Courts 2 is tendered and admitted as the final version of the charge that is going back with the jury and the one that I just administered. All right, hearing nothing else then, we'll await direction from the jury if they want to get started. If they ask how late they can stay, unless anyone has a conflict, I want to give them the option to work. And I think usually that last bus back to the parking deck is at 7 o'clock, so we may just give them that time. Or they might come back in here in just a minute and say they want to start fresh in the morning. Deputy Scott, you can hand them these exhibits, and if you could, that's everything, and you can tell them to give us kind of an initial indication of what they want to do on the timing. All right? And then if there's nothing else, we will go off the record and be in recess until we get word from the jury.
I don't know how.
Thank you.
What you have is just been immaculate.
Thank you.
That's all we was there. Chris was- and she was gone. She didn't talk about that.
I'm gonna take my time personally. She left.
Thank you. Oh.
Unauthorized access, justice at your tower, second floor. Attention, unauthorized access.
My next one,
Trial.
oh, I have no idea. I'm sorry, let's see. You know, my personal injuries, so. My next one is like, but I think it's gonna be a dog bite case that I have.
I'm on the wrong side.
What'd you say?
And on the wrong side, it's 613. I can get the $3.
Hey,
Hmm.
you said you could give me like dated ones?
I do. I'm gonna get back to print. Yeah, we're gonna go back and get printed out. I'm gonna go back and get it printed out. We're gonna get printed one. That's all I'm not going to change. Maybe tomorrow now, because I don't know. Looks like it. There's a holiday say. That's fine. Who's drinking? Coffee. Oh. Yeah, I thought it was warm, but no. Go for a
This
cup right
one's
now.
tea. This one is hot.
I could go for a cup right now.
The first one of these, at first it was. And then you changed it. Good eye, didn't you? Right. Because 106 and 108 is together. You remember when you came back to George? 106 and 108 was together, and you wrote over it and said.
It was 105 or 106.
Yeah, the questions. Then it was 106 and
Oh, 108.
108. And
Nice.
then you changed it to.
No, I took it to 106. I owe you 108.
Okay. But she
I brought it up.
She referred to 108 as.
I know we're taking snips out of videos.
Yeah.
I'm using it as photos.
Okay.
But it's video.
Okay, 108.
Okay. So.
I gotta get you, it's fresh in your mind.
Do you know what? Where's Clinton? Find Clinton. Where's the big speed on the ball? Because he
On the
was
straight and narrow?
Because he would come in at 8:00, 8:30. He's on me. I'm like, whoa. He's like, yeah, I'm like, yeah, Discover. You're on there. I was like, oh my god. Yeah, he says it's up a little. We were trying a really responsible not to read the field. To the trial, but just keep it the same. I think whatever I added was just go to the back of the list, like it just get.
Okay.
Grab it all, we had it. Says that. Fuck around. I get confused. There's another one, A, B, C, D.
So they said they wanna do it.
Haven't said anything yet.
Huh?
They haven't said yet.
Well, so they have it, I liberal, you know, what we doing?
They haven't said yet.
They said they're gonna try to get it done.
Tonight.
So you-
Oh, okay.
So we on what we on, we still live?
Yes.
Oh,
That
sorry.
will be.
I was trying
to get you the eyes.
When?
Just now.
Oh, yeah, you see how I step back.
Yeah. I was. I'm trying to be non-verbal. I don't know.
Oh.
You can, it's my fault.
I'm sorry.
No, you weren't. Okay.
I just hate it. I hate it. Yeah.
It should have been like Friday or Thursday night. Yeah, they've been.
No, I don't.
I don't even want to check my email.
Yeah.
Because he looked at me like, go try it.
Granddaughter. My God, she her granddaughter texted me like, turn me into an Jenny. Girl, I know who you are. She trying to ask me about it. You don't gotta do all that. You just give me a call, I'll call you back. I knew your mom before.
So she called him. He's like, no, she's saying you're wrong. And I was like, oh, yeah. It's a break. That's how you go.
Oh, Shay.
Gender.
But you need to know what she said.
Oh,
They might fight against it. Yeah. Oh, I really believe. I believe you, but she never gonna change. I don't feel it. Mommy,
So basically, this is kind of talking
so my children, but I'm trying to wait. So this thing. Let me see, she was almost a girl.
yeah, I suggest that she should be open for dating men who
All right.
make him something now we're both in Charlotte. We have any black people put money to think for their partner. I've never seen it and fulfilled me and take care of and have a good year. So everybody's in the comments. Most of them are women. So like at least someone who doesn't. Correct, that's what they told you. That's what you want, that's what we're doing. It's just like, it depends on what you do. But then also, I think it's do what you gotta do until.
I don't.
Deputy Scott, oh, forget it.
I don't get it. Like
Maybe
how
they
it-
took a picture of that and just was trying to like mirror it. I don't know.
Yeah, I don't know. It's a little crazy.
Yeah, that's one of those things that ain't never gonna die, especially this.
It's so
What's the name too? HBCU, PW, how did they, oh my God.
oh my God, that's so yeah.
And everybody know who ain't been there. I didn't go to HBCU. Or the HBCU person, they went to PW, they like, y'all ain't nothing, no, it ain't this, it ain't, you don't know, you can't have a good time. It's like.
Why we're not in school to do that? Like
But every school is unique, you don't know, and you don't know what fun is for me.
yeah.
Everybody got it like deep in their positions and all this stuff, and it's like, it's just opinions.
But
It had a light, I don't know what it means.
yeah.
It went out, couldn't it?
Yeah.
The deputy's back there.
Oh. Let me say what we stay later now.
Right.
Yeah.
I hope not.
What they only.
Strip the bandit out. Either way.
So it is, no turning back. Yeah. So, no, you. So I try to like, I'm trying to be simple. Yeah, this is crazy.
I'm just like,
Oh, man.
yeah, what you mean? But yeah, I just got on the consolidated for next week, so
What's your other courtroom?
Carmichael income.
Oh, you got three? Y'all got three now? This is wild.
Yeah.
Oh, yeah.
That's why I'm just like,
Yeah, you drinking from a fire hose.
you missed a 1.5 year
Right,
prosecution.
Three is wild.
Yeah. And they're like big chunky.
Yeah,
you know what I mean?
Yeah.
That's calling our case.
Huh?
That's calling our case.
Yes. Yes.
But the thing
And
is,
just others moving.
no one else wants to try nothing. It's the,
Yeah.
you don't get to try.
Please leave your message for.
It's no like. When I like at the trial, so they're like, all right.
Let's play it out.
Right.
Yeah.
It'd be like the day off.
I sent you a couple emails.
I
Okay.
see that he covered work. Like, he don't
I
stop.
need discovery.
I'm gonna let my paralegal answer that.
I need discovery.
Cause I'm in
motions.
trial.
Multiple signatures.
I see it.
You and Lil Wimble. Y'all the
Okay.
same thing.
Literally at
Y'all
8:30,
got
they come in.
into up here.
Oh, I have a binder.
Well, see, yeah, they just file them when they see that these cases come, they just file, but I've been trying to tell them, don't do an entry, do discovery and all that stuff. So, yeah.
What's, oh,
No.
I was gonna say. I was saying that.
You wanna bring Mr. Carmichael up?
Yeah.
Wait for me.
All right, as he, before he goes out, let me just, logistically get this teed up. They're asking to watch some surveillance again, so they've even got the exhibit marked here, 106A, which is the Economy Hotel.
You said 106A.
That's what they've got written on the photo. They say Economy Hotel Surveillance, 106A. I know. And my question with y'all, that's silent footage, is it not?
Right.
Was that just given to them on a disc? Or is that on a USB?
It was a disc.
Do you have a USB?
No, it's not, it's,
No,
well,
we don't.
no.
But you don't have a USB handy. All right.
Say what time frame? That's a.
Yeah, no, they've got a very specific. We can bring them out and show it to them, but we also have the capability where they could just watch this since it's a silent video as many times and do whatever they want with it if we had a USB. Let's see if we do. But just if you could bring Mr. Carmichael out.
Do you have it on the way to Conservative?
1380-137.
Yeah.
Give me a signal 10.
Your color was your medicine. Yeah.
They were all day 21.
All right. And I was just, we've got a empty USB to offer. And I think, pretty sure, Commissioner, you can,
Okay.
isn't the standard now, everything is supposed to be submitted on? Yeah. Just a practice pointer going forward is I think there is a standing court order courthouse wide that exhibits are all supposed to be on USBs now. So try to start phasing out CDs.
He was saying.
Yeah.
Won't work.
All right. We're back on the record. All parties in council are present, and Deputy Scott has handed me a note, and I've marked it as Courts Exhibit 3, and we'll tender that for the record. It reads, number 30, we would like to watch the Economy Hotel surveillance footage, and in parentheses, it says 106A, from the time the defendant arrives at the Economy Hotel, in parentheses 1040, to when he leaves, 1044. We'd like to watch it zoomed out and zoomed in, and it looks like it's signed and dated by, I presume to be Juror 30. If anyone wants to inspect that, they may. But my reaction to this would be that this particular exhibit is a silent video, and we do have the capabilities in our jury room for them to log into a computer that has no access to Wi-Fi and has been designed solely to review evidence. And I believe it also has the capabilities to, I think it has a VLC player already installed, so they can pull it up and do with it as they like. And it's a big screen, so they could all be looking around it and reviewing it as much as they want. And so I would be inclined to have the state transfer 106A in its entirety to a USB and then provide that to them.
We make sure that they know how to do that, because everybody don't know how to it's not simple, so.
We'll bring them back in and I'll give them some instructions on that point. Any input, Mr. Mitchell?
No, I think as far as the video is concerned, I just probably need to make sure it's the same.
Nothing's going to be handed to them until you have the opportunity to inspect it. So while that's being transferred over, why don't we go ahead and bring in the jury and I'll give them that instruction. You can bring them in.
Last week here. Here's your presentation.
All right, thank you. Please be seated. Members of the jury, we received your note asking to review State's Exhibit 106A, and we are going to be able to facilitate that. Instead of just playing it perhaps one time here on the screen in the courtroom, we do have a computer and a screen in the jury room for you, and we're going to transfer that video onto a USB and then send it back to you. I just want to give you the instructions that, although I don't believe it's technologically possible, because the computer doesn't have access to Wi-Fi, you shouldn't be using that TV or computer for any other purpose than to review the discovery that we hand you. We can do that for this exhibit. We won't necessarily be able to do that for every video, but you did ask for this specific one. It is one that we can give you. And so we should have that for you shortly in the back. If you encounter any difficulties with it, feel free to let us know. Or if it doesn't do what you want it to with the zoom in, zoom out feature that you asked, you can let us know. But I believe it does have a VLC player installed, and you can make a determination as to who is the most proficient at using that. So with these instructions, I'll tell you to retire to the jury room and resume deliberations. We should have that for you shortly.
All right, jury. It's good, Joe. Make it super fun.
Okay, take it out.
Mr. Mitchell, have you had a chance to review what's on the flash drive and what's been?
Not yet. I think we have a question about,
The request was for the entire incident, including when he leaves. And when he leaves is on a separate
those
video.
are different camera angles.
It's still
and different
106, but
exhibits.
it's B, so we had it on the drive as well, if, just to clarify.
And so, I mean, what I would say is to go ahead and include all of 106, if it's all a silent video. I mean, really, if there had been any video that was silent and it was on a USB, it'd all be back with them right now. It just happens that they were submitted by CD, so we don't have that ready. Anything else then to add, or any objections to the charge that I gave them?
No, I think I'm just trying to make sure was any video submitted for the limited purpose of anything?
No, it's
Surveillance?
body cam.
Okay,
There were only two things that were limited.
okay. I just got
All right. Then otherwise, Mr. Mitchell, if hearing no objection, then USB, we can give that to Deputy Scott. It has all of states 106 on it, and we'll await further word from the jury. We're in recess, off the record. Here you go.
Why are you not giving us the evidence? You keep giving us a statement. I did. Exactly, because it never happened. You know. No. That's a part of discovery. Reciprocal. Yeah.
Follow the law, that's not.
I know. For a prior statement.
It's not a prior statement, he never told me.
Read it this.
No, we don't.
I'm saying that there are any statements of the defendant that you need to provide.
No, don't.
Any witness statements you have to provide.
No, we don't.
Okay, and I say we agree, disagree. You look at the discovery statute.
Well, you know, you lost the argument in court too.
Because he, I mean, okay, I lost. I disagree with him. I do.
Come up with a better strategy than talking about the state. How about that?
Okay.
That's your go to.
But to go to the circumstantial, you can't tell them what they see. That's the only thing.
Why can't I point out what's on the video?
Because it's your opinion.
It's not my opinion.
You didn't see nobody shoot nobody.
You got up and say, this is enough money, got me in the same clothes. So now for me to say, this person who got me in the clothes that he pointed out.
And to tell them what he's doing and you can clearly see he's not doing something.
Do we not have direct evidence of what he was doing?
Okay, all right, let's relax.
I'm not hyped up, I'm chill. I'm scared of chill, right?
If you want to.
I'm just sitting here, I'm just, you know, the one standing up.
All I'm saying is, if he made a statement,
I just didn't.
it's good practice to give that to the.
I wouldn't.
Sure.
Well, that's a dangerous Brady.
Okay, yeah, that one.
It could be dangerous. I'm saying it's
Okay,
dangerous.
sure. Yeah, cause I need the other one.
Somewhere else or it was somewhere else. He didn't say, he said what happened to him. I mean, she probably should, but I don't do that, because I don't have to.
You do?
I know.
I'm not gonna keep on that wrong.
Why'd you win? Why'd you lose? Sorry.
What are you talking about right now? Because
Why did you trust? 'Cause I know you said that.
I trust you.
I know, because you don't even want to hear what I got to say.
I do, but because I don't agree, just because I don't agree on y'all trust you.
But I'm saying, like, if you talk to us, so, somebody else would.
Hey, Deputy.
I don't know. Who's up there that you know?
Like, it could even be the sex cases. If the victim say, or witness say, this is X, Y, Z, and then I don't know about it, and then you come in and say, you remember you told me X, Y, Z? It's like, damn.
That's me impeaching him for
All right, when you impeach him, where's this prior testimony?
Where does the lawsuit have to have something written down or something reported for me to be able to rely on?
That's what impeachment is. So you're just going off of memory.
Oh, you think I don't remember?
Yeah,
You said, no, you don't think I remember?
I'm saying, yeah, I mean, that's not reliable.
It's like they determine credibility.
Okay, and that's why I don't agree with it.
You don't agree with the justice system of it, or you don't agree with my
I don't
interpretation?
agree with your interpretation. of
Okay.
Impeachment, yeah, no.
Well, y'all think you gotta impeach all our justices when we can refresh them, so like, I know that y'all two ain't even got no. Cause you go, you
Same
impeach
energy,
them, like, no, we're not. When you show a report, the asses that don't refresh us, you find reaching. You know, when you say didn't that we have and didn't you say, that's impeaching.
But it's introducing a fact that hasn't even been testified to. That's like, you didn't lay a foundation for that. You say a question like, hey, you remember you told me so-and-so kicked you? It's like, wait, when did I say that? The better practice.
But then he said he said it. He just said that he came back and changed it after.
He said I was lying or something. I don't.
He said he changed it.
My point is to introduce a fact. You can't just say, you remember you said you combed your hair. It's like, what did you do? Did you do anything to your hair? Like, it's almost like you're trying to coach the answer.
Nope. He came in and talked that day.
You got another light.
Light on deck, Scott.
He's like, I didn't fish that out of him. I didn't even know that was a situation. He did. Oh, bad. You know what I'm saying? Like, and being in the her, he was like, I want to come and tell you how.
I want to say.
You know, like, I'll say, that was what he cried when he told me. He was emotional.
He
He
thought
told
he
me
was
how
about
he
to get
was
charged.
speaking.
That's all the pizza thought he was gonna get
No,
charged.
because before we started, I was in the charge, period. This ain't about that. This is about the truth, period.
That don't sound like nothing he'd do.
Huh?
That ain't nothing that man would do. Why would you do it to your friend in 30 years?
Why would he come in and think that? Why would you do that anyway?
Yeah.
Why would you say that?
If
If
it's
they
me
didn't,
and my home,
why would you say it?
because he didn't want to get charged.
Before I started talking, I told him what. You know what I'm saying? It's like me. Why would you? Okay, then why not say it? And then I saw him, and then he said he go forward to the case. Why not add more facts if she's lying? You know what I'm saying?
Yeah, she didn't like
lie.
overly exaggerate, because she was
Yeah.
still taking up for him,
She
like.
was.
But she wasn't there.
She was who?
She didn't go to the place. She
No,
didn't
no,
see
no,
it.
no.
No, but she saw his demeanor on the way over to the guest inn.
You know what I'm saying? She could.
And that's what I'm saying. That's circumstantial.
It is. It's her observation of the
It's fine. That's his life.
But you, it's hard. Yes, you know that's it, right?
Yeah, cause I mean, now like he should be aware of the issue, because other than it being your words, he don't believe, because he's saying that's not how it went down. He don't dispute that, he's just saying he didn't take his gun out and kill him, that's what he said. I don't know. It was a pistol. That's what they said. He got pistol. No, that's he's
Did they write a note or they just told you?
You want, I can get a note.
No, that's fine. We'll realize it.
I had asked.
Was he a student or you just know?
No, he's an attorney now.
We're back on the record. All parties and counsel are present. Light just went on shortly after we went off the record. Deputy Scott went back and he tells me that the jury just informed him they're having technical issues. They didn't commit it to writing. And so it appears from what they conveyed to Deputy Scott that the program's not installed for them to be able to review this video. So I want to check, is it VLC Player that does it?
Yes, Judge.
All right. And so possibility we have here is I can send back Mr. Derryberry, our judicial assistant, to try and start troubleshooting. I'll instruct him not to discuss anything with the jury and try to work through these technical issues back there and try to maybe get the program installed. Any issues or
No.
thoughts on that from the state?
No, Judge, but that's fine.
Any objections from the defense?
No, Your Honor.
All right, that's what we'll do. We'll be off the record.
That's speculation. Stop sign evidence. Outside the scope. It's go. As we should.
You know what they say? You got too much.
Oh, which one? Oh, yeah. I'm right. I have to be with Inspector tomorrow. I don't.
You know what?
That's it, really, for that. Right.
It's something I'm not big. This.
That's good, you already ready for it.
I'm not for that.
And you got probably ready the whole thing.
I know. I told him.
That's on another day. I gotta get, but I gotta give Malik down with this, we have talk. So.
You know, when you're in.
Question for the state. Are you all able to download the program
It's-
or upload it to the USB? I
Mm-mm.
thought y'all did it before.
Well, they.
In a previous trial.
Yeah, so I don't.
I could have sworn we had the state put it on the USB before.
The actual.
Because we might have some IT hurdle. Who's he? I think that was a blank USB.
Are you talking about moving the actual program to the USB?
Yes.
I don't know if it'll let us do that because
I could have sworn the state had done that before.
Now you might be talking about a different surveillance program.
Or even if it was.
I thought it was VLC.
It could be possible, it depending on who it was, it could have been on our evidence, you know, sometimes we get that. we
The
get
player
videos.
is with the player.
It could have
Huh.
been that, you know, where we
Interesting.
already with our evidence, and then so it was easy to.
With your
First,
evidence.
they just gave us the videos and we got it.
Remember what trial?
Okay, I think I
So yeah, if
understand.
you remember which trial, then.
I couldn't
could
tell you,
call.
we've done so many.
Cause you know.
Don't we have the CAC laptop, you know, the one that's kind of blank and then you can use it? It's like.
That's We can certainly try, but I don't think it'll do it. Cause we have to get access key. We get some salt on there.
Should I call, what's his name?
Well, why don't we both try on both ends to get it on there simultaneously?
I'll call Sean and see.
Hey, Michelle, quick question, I'm sorry.
Right. That's why I knew like that. Oh, yeah.
A couple times.
Yeah, cause I feel we know where it's going. I'm like, Via, I'm thinking about your.
Oh, ACI.
Right.
How many times have I let you go?
Did you?
I don't care. Y'all talking, so.
Yeah. And it don't mean
Like legally. Hello. What's up?
I don't know. Especially, I forget what the question was exactly.
Oh, come on, man, Maurice wrong?
No, it's like, and it was said.
Yeah, I think you're before him, if I'm not mistaken.
Exactly what the question was. That's what I'm saying. I was like,
Yep. No problem.
Oh, yeah. Yeah, that was anything.
Well, I got 5 courtrooms, I got 6 courtrooms, so.
Last time I thought you said it was 4.
I got 2 more after that, so I have a total of 6. Plus the high profile cases. So technically I got 6.5.
yeah.
You probably got guys yet. Probably is not going.
Yeah.
Yeah.
They might call you.
Is that the case, right?
I never would have turned it.
Go ahead, Tom.
What do you think we should do for it?
I would thought we best friends.
I told me, yeah, I told her, you can still put it in.
Oh, she did. Oh, they have.
Yeah, yeah.
I'm gonna see. What? Okay. Yeah, he was trying to see if he can have the videos and stuff.
Oh, happy birthday, dear.
Oh, I see what you mean. Play around with it, see.
I've actually never been to that child, and I literally could see it outside my window. Don't want it, but yeah.
Well, right, but did I get it in? Okay, let me try that and see if that works. Nice. Nice.
Yes. Yeah. Present and former. So last me a little while.
Right, yeah, me too. Me too.
After this week.
It's like.
Anyway, that's no, that's no good. It's out there.
Yes, I can't just do the same thing.
Hey.
Yeah.
They wanna come out?
Yeah, just coming up.
Okay. Yeah, I'm on. It's a motion to hearing, but it's, I think, Fridays. Also the defense. So it's gonna be, it's a 4-4-B. I'm not sure, but Adam was gonna try to throw. In kind of stuff, not here. The one we have here is on the 4th. It's 4-4-B.
Mine?
No, ours is a motion to suppress. And the other one is a 4-4-B.
Nem se ele coloca na hora.
All right, we're back on the record, and We attempted to play the files with VLC player, and it tells us that it is in a format that's unreadable, .dav file, which is some kind of proprietary software, meaning state didn't include the codec or other appropriate software to play them. So at this point, I think we just need to bring the jury in and we'll publish it in court. Doesn't play with a VLC player downloaded. So can't get it done.
I don't know. It plays on ours, but
I mean, you may have something installed on your laptops that isn't installed on anywhere else.
got it. I was, Deputy Abadi was gonna bring something up on a flash drive, that was gonna be helpful.
So it's what kind of what?
Just gonna try to put the program on a flash drive and bring it up to us.
That's what we need is the program. But for now, I think we can just publish it in court and go from there. So we can bring in the jury. Why don't we have the state come get the note so you know exactly what to publish and what they want. Thank you all. All right, members of the jury, we are experiencing some technical difficulties of our own. I don't think we can get takes a special type of program to play the surveillance footage that we don't have installed yet. We're going to keep working on that. But in the meantime, we thought we would publish it here in court as you originally requested, and we'll keep trying to work on that. So at this point, I would ask the state to publish 106 in the portions and manner indicated by the jury on the note. All right. Before he gets to the door. All right, I'll direct the state to, and I'll just summarize that for the record of various jurors asking us to take it back 1 minute and replay it again. Unless council has anything else to add, I'll direct the state to do that. All right, and so with that, members of the jury, we'll keep working on this. I'll direct you to turn to the deliberation room and we'll await further word from you. The state has provided me with another flash drive, which I imagine might have the program on it to solve our issues. I'll give it a shot. And if it works, I'll give that to him. And unless there's anything else for the record, we'll be in recess once more. Let me go try it out first.
I just supported 4B down. I just gave two breaks to. You better call him. That's why I called him.
That would make nothing. That would make nothing. But they don't come to. You ain't got to try.
One from that surface might be. It depends on what kind of phone.
The 15.
Oh, lunch. Oh, a lot of money.
You bars in here.
What's up? Delivery? Let me go get my.
That's the lady over there charging.
Who told
Ready.
I didn't realize she didn't have, she makes sense, she needed one.
I'll make a change that.
7.
All right, bro.
Got 30 scribes. They
They
said,
should miss 2 more going in front.
they said they want to stay.
They saw it, huh? I don't know, they said they trying to get it done. It's still gonna be ugly, bro. Who?
Don't worry about it. It ain't you.
You tell me who, Reed.
Check this out, son.
God,
I was doing my nails.
you got a key?
Yeah, I got one, I got one.
We'll go in.
Let me report that out.
Oh, sure. How many times?
Huh?
How many times?
I'm going to ask.
Where you going?
She get ready to go on vacation, she ready to leave.
What is it?
You better be inviting her tomorrow to help too.
Yeah, where you going?
That's mine, going, that the key she give in.
Somebody leave 7 plates. Somebody leave 7 plates. You tell me there's 7. He's on candy burger. All right.
Everything I got.
Scott, where your office at? I need your office. You got a locker right here?
Yeah, right there.
No.
I can come in tomorrow.
Come in tomorrow?
You like that, like?
Come in tomorrow?
I put in for all, but I ain't trying to maybe I'll
I'll see you tomorrow.
and do it tomorrow night.
Oh.
But I'm not for that. Thank you, God. You such a good coworker.
Yeah, you owe me lunch all next week.
I really
When
got
you
a
come
t-shirt.
back.
I gave you a t-shirt.
Look, man, what? No, bring me a shot glass.
You collect them?
Yeah.
I'll read you some.
All right. What it is?
7, yeah, 7, 6, and 7, 4, 9, 3, 11.
Oh, you need a top?
I think it's one he gave me one.
Oh, okay.
Thank you. That's, yeah. Well, you're about to charge me.
Yeah, I ain't no deep.
I don't know. Personal one, back one, thank you.
I'll make sure you get it before everything.
Okay.
It's not gonna walk out.
Oh, no, I don't need it right now. Okay. Yeah, but don't let me forget it, though.
It is a nice charger, man.
Well, no, it's not the one that I need for my phone, so I need it for my iPad.
Somebody stole my charger downstairs.
Oh, yeah. I mean. They stealing this building?
Yep. I actually left it. I was working on it. I didn't take it home.
It's a commodity. Chargers are a hot commodity. They burn out so quick.
But you would think you would be deterred from this building.
Oh, yeah.
To not steal.
Yeah.
I went to the police officer that's going to stay.
We still, man. I remember being on patrol. I used to leave my flash drive in the unit and leave it in there and go back. Like I left my flash drive. Somebody, hey man, you set a flash drive in there? How you see, bro?
How long y'all been delivering?
They really started that out. What time they started? Like 4:30, 4
Or
to 10?
something. I don't know.
Like 4:30.
How long was the trial? 2 weeks?
No. Just like
4 or 5.
4 days.
Started Tuesday.
It's Tuesday.
And then we ain't had court Friday. So Wednesday, Thursday.
She went out there when you came in. She went this way. Right, just next to me.
Looking.
It was, what's his name? Teasley. We used it for Teasley.
Oh, we use it for Christian?
Yeah.
On Christian last case?
We did.
Antoine.
We used it for Teasley.
Oh, no, that's Danielle.
Yeah.
Caesar.
No.
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 Oh.
Atkins, yeah.
Okay.
Were you in here? I think you closed.
Yeah, I sat with him. Did I call? I did one of them.
Yeah,
I think y'all did the same way that you did.
yeah.
They just be using me. I don't even remember that case.
They do, that's what they do.
Now, here you go.
They use you.
Here you go.
They use me too.
I'm sorry I had to shade you. You shaded us for 3 hours.
So, but why gotta be me? I said state, I ain't say Cassie.
But you know, you was talking about us. It's only 2 people representing the state.
No, I'm talking about the whole system.
No.
I'm not talking about y'all.
So that's what you did when you were prosecutor? You just prosecuted people because?
Yeah, look
No,
like
you
it.
did.
It looked like it. I'm saying, when I look back now on this side, a lot of times, you know, Mr. Howard, we couldn't even get no deals. It was life or nothing. And it wasn't even no in between. Now looking on from this side, like sometimes it's some gray area. It is some gray area. And so from my experience.
I've done plenty of numbers.
Huh?
Because I've done plenty of numbers, because I think that whoever your supervisor are, they look at you and what you, you know that you looked at everything, and it is what it is. Like,
Right,
everything isn't life.
right. But it was with us. And for
But
rape.
that was Howard, right?
Right, yeah, that's what I'm saying. For
Yeah.
rape and murder, it wasn't no conversation about
Yeah,
that.
yeah.
You going to trial.
You know, I should have told him that. You worked under different administration too.
Well, I worked on the funding too.
Yeah, but not, because she don't do that.
Right now, but it's a whole, like, it's a backlog. It's a lot of stuff going on with it.
There were people there.
Because the detective.
If you're going to
Understood. There's a fight going on.
We all like it.
Huh?
We all like it.
So you grab him or you got a gun?
No, he grabbed his gun.
People like that.
But his gun, like, look at his gun. And you, like,
But that's what you think. You don't know, I'm telling you, Cassie, you don't know what's in his head. You said you experienced this with him. Huh?
What was in his head?
Because he don't have to.
He don't.
Yeah, that's what I'm saying. Legally, we gotta make sure we do all the right, all the law. So he don't have to do that.
No, he don't.
Cause y'all gonna impeach him with his history. Y'all
You're still good at that.
But y'all gonna impeach him with his history.
Only the issue that applies to him being impeached.
Right.
What they should have done when he first went and lied, said he was the first to go out there and impeach him with his history. When you open the door to his character.
That's fine.
That's the shit happened because he.
But I didn't open the door. They did that. They kept saying he's coming. He was coming.
She described what she did. She said, he's not, like, he's not, I got no kids about, he's not doing it. He's controlled. It's controlled. Like, so have you ever been mad and not been yelling? Yeah.
That's when you really.
It's controlled. Like, and his friend of 15, 20 years described it. She said, she was so weak. She was so worried about him and everything. After all of them, she called him to see what happened. Like, are you okay? Then,
Okay.
because you scared me. You know that, because you was in the first try and the second one.
I'm done. Like,
I know that.
Because that whole, like, I don't want to win so bad. Like, I go home and
I won't be the
Right.
It ain't about that for me. It's not true for me.
but I think it was something that happened suddenly. He didn't go there to kill. That's
How do you
not
do that?
because he told me.
He told you after the fact. How do you know that in that moment?
But see, how do you know that? So you think you're right, but that was my whole point today.
I'm not saying I'm like, just not the company focus on. I'm doing you because you are you. So I'm like, well, let me talk about the gas.
But the thing is, if you just because somebody steals something, you don't think nobody stole from him on 4th Industrial Development?
Okay, cool. If he can find shoot and kill him, which this is one of my last 45,000. If he can find and shoot and kill him, why did he? Why did he shoot?
Shit.
We got enough of this my car in the truck.
Everybody, somebody had to put their drugs down.
That's because police was there, but that's before the police go.
Because, but why y'all always assuming? That's my point.
No, that's the thing. No, why you just go shit to the economy? He's right there.
Who else said they had to put their drugs down?
Real, and then my cousin.
Your
He was selling drugs. He was like, I'm not about to go.
The sign that have was, remember that stole it, so he didn't have to put his drugs down.
We only know what, it was only something, we don't know what was stolen, really.
Well, Lindsay said it was 40 grams.
Lindsay, and y'all see, Lindsay is lying. She was high.
Why would she have to lie?
Why would she lie?
How long did she know him?
Years.
My point is, you're assuming everything she said was true. That's what I'm
It's because it's corroborated.
The testimony of a single witness.
And see, that's the law, but I'm talking about for Lindsay.
And then they determine credibility.
They do.
And so that's why you kept saying, so what, oh, she overdosed, what they got to do with her memory?
I didn't say she overdosed.
Yes,
I never did.
A relapse or some shit.
No, I didn't.
I mean, not overdose.
I made sure I didn't even want to talk about how she died.
Not overdose. You said she
Relapse.
Oh, yeah, she said she relapsed. Yeah, that's what she
why
told the
that's why
detective.
you're gonna highlight stuff like that, because you want them to not believe her, because why would the friend of 20 years say? You gonna cover this up?
Because who talks like that? Her.
She, friend, and my friend come tell me, they said, well, she's not like, girl, really? What? No. That's what friends do. So she tried to talk to him, but he wasn't trying to hear it. He's like, okay, I got it, cool. And that is a conversation, even though it ain't a conversation. You like,
That my point is, we don't know verbatim what's happening, but you want, and that's why I said the state. The state wants to believe all these things happen, but I can't come with an alternative
no, you can't.
conversation.
He can, you can't, and you know that. See, what you wanna do is you wanna talk for your client and then don't put them on stand. You can't do that.
Well,
That's all
I
you're
can
doing.
argue.
Right, but you're arguing.
I can
his
call into
mind,
question.
but you're arguing his state of mind. Like witnesses that were actually there saying, oh, yeah, she, yeah, I know she just. And so because of those things, you can't believe what she's saying. Like,
I'm not saying you can't believe it, I'm just saying consider it. We just criminal. Did it work? Did it charge you? I'm still on it.
I was just in the room, doing the security, he was like, oh, damn, yeah, I know you were doing it.
It's otherwise, it's really more of a system thing. It's a system.
He takes everybody. I'm sorry, you gonna go to the another guy. Still go. Sometimes.
Yeah.
oh, is that the flash drive? Okay. Did I just hand it to you? Okay. What, I did. Oh, I just had it to you.
Mhm.
Okay.
What wings?
You can drink a Red Bull, they get that.
Something fat and greasy.
It's not nice.
Oh, because that's just like how it is.
That's how we were, right? And that's what I was saying.
Yeah. So you got the one grape. Yeah. Oh,
That was funny.
you guys want to start?
Yeah, I want coffee or tea.
Not you guys want to.
Coffee or tea? Yes, please.
I'm very surprised, I used to lose so much weight. When I was being tried,
I had some grapes. They got
I used to be losing so much weight being in trial because I ain't eat. Huh? Probably like 15. 20. Huh? You said trials? I said maybe 15 or 20. Yeah. More than, yeah, it was a lot. But in Major K, they running ragged. I got stopped by the pandemic, right? When the pandemic came, that's the only thing that stopped. Because I had Judge Russell and they snuck me into Judge Russell.
What we gonna do with Miss Tucker?
Adam and Brian and all them guys.
Who? Which Brian?
Piachinsky.
Oh my God, Ryan.
They all
You mean
kind
Ryan?
of, somehow they came up with a plan to put me in Judge Russell because they knew she tried all the cases.
She was so cute. I remember.
She was mean.
She was looking at him.
I'm about to say, she thought about she was cute.
Judge Russell did not play.
At least everyone else.
You was in Judge Russell before Cassie?
Clint Russell brought me to
She'll be like,
she
move
came off
on.
the bench.
She's so smart, but she is smart.
But she was the sweetest thing in jail. I was like, oh.
She would never,
Like, you know, he just so nice.
she never let the record reflect stuff. And I used to be so confused. I'd be like, y'all let the record reflect. And she'd be like, I will not.
I will not.
And I used to be like, what am I doing wrong? Is this something unprofessional? Like, what's going on? I'd be like, y'all let the record reflect.
No.
He's identified the defendant. And she'd be like, I will not. And they was just like,
She was messing with you.
yeah, it must have been because she but she'll be making, they was like, she did not continue cases for no trial. Like,
Really?
if this wasn't your courtroom, she.
Stay ready. No matter what.
No, we're not. What do you want to do with Miss Tucker?
I don't
Miss Tucker's in college. She's trying to get.
That's nice. Thank you.
Next, I want coffee or tea.
I'm about to look at it. Are those crinkles?
Yep.
I'll put the bill in the mail for you.
What'd she say? What'd he say?
Bill in the mail for you.
Oh, okay.
All right, I got
Thank you.
2 items.
Thank you.
Hey.
I don't need that bill.
Why is that?
I don't need none of it. No, nothing. I used to love those. This is from the school chair. Oh, no.
Why did everybody serve after school kids the same stuff? We used to get that, I mean, with some red juice.
Yeah. Same.
Yeah, you in Louisiana. So I'm in Georgia, Atlanta.
And I used to like that though. I'd be like, after school. Cause my mama only coming around this side. Forgive me.
Mom, bro. I'm on the teacher.
No.
And then she'll come up and start gossiping with the teachers.
Yes.
So I'll be waiting till the last person to leave. And my mama came probably at 5:30.
So basically, we had the same situation, cause my mama made it.
And
And AKA.
yeah, she gossiped to all the people. I couldn't move wrong at the school. My mama probably came.
So my mom never tried Catholic school, but my grandmother did.
Okay. At the same time, she did too.
I thought you said Catholic school. You know what? I don't know. Oh my God.
But I do. I'm catching strays.
You really are. No,
I do.
it's the hate.
They've been in all like that for real.
D'Angelo gotta come back.
Oh. You know. Now.
Friday, he said he gonna come back.
You can't just try to.
He full of life. He gets a hard fire.
I haven't seen him in a minute. I saw him about the city. But we ain't get to talk about it. You know, you have those big parties. It's hard to just like, how you doing? What you?
Yeah, that's not happening.
Smoking and drinking.
I see D-Lo and Vito.
All the time.
Yeah. It's if they.
I keep wanting to do it all this year. I feel like Elaine will go. It's time.
Now you need to go.
Yeah, okay.
I thought information that. Yeah, it's every Monday, it's every, month. It's like one Friday of the month. So maybe like Juneteenth. That's like the one that is popping.
You gotta look it up later.
Chanel be,
I'm gonna send you the video. I'm gonna send it to you.
I've been seeing the picture.
I'm gonna look it up.
I missed it. You know, I get to a point where you do it and that day comes, you like, I got to.
I'm tired. I mean, I don't get there until 5 o'clock. Yeah, I don't actually skip the house ever.
Instagram.
My homegirl.
Oh, there it is.
Did I go with? She takes the whole day off. I work.
When I was young, I feel like,
But you gotta put
Yeah,
up
that's
shit
why I
here
go.
first.
I wanna be
And then-
done at
And
that
then
time.
watch.
I don't like nice stuff. I'm sorry.
Don't say it loud.
Like, I didn't get that.
which one are you?
All the way out there, it's like stone creek.
Oh, okay.
That's still good. And so they was like, I was struggling.
But you gotta listen to
I was
how he
so ready to
said
go home.
You know, I did about
I don't wanna be out doing nothing.
Oh my
That be because
I was
you
for the
know, I
record.
hate to say it like this.
For record purposes, yeah.
I'm not necessarily like going out and juggling. Single is in the because that stuff is not that fun to me.
Yeah.
But I'm to meet somebody. Because I don't all of it onto I hate going down here
You personally.
yeah, I'm like trying to run. Like, you know, and
Oh.
It's crazy for real.
I haven't moved on from it.
It's hard to understand this, but I think it's more like, this is what you're doing.
Yeah, that's how everything, we don't think like
I
that.
have the breath of
You look like this, and she still look good. Cause I mean, my hair got laid.
You feel you wanna come to show.
Yes. Yeah.
I think it's the best selling one.
But I like to be very early.
Another time.
Like, I do wear makeup. Like, I'm fine with it, I'm not going to stroker. Sorry, I have to go to the that doesn't work. That doesn't make me feel good. That doesn't make me feel good about this. I don't like this stuff. I'm sure, but I ain't trying to talk to her.
They told him to get him there. You look like. So, you look like.
Right. The only reason I don't know is because I ain't talking right. I don't know what.
No way.
That's extra.
Back to Atlanta.
Cause like, that's the only type of way that you don't see people. I'm just still working. I'm gonna be there.
I keep missing it. I'm always busy. Last time I went was like 20.
Okay.
I miss every year. And I've been having trips and stuff.
But like, even that, like, even someone that's like, that's not real. It's like, no one's really seen either.
Just who's our age, yes, but. Oh, you talking about this one? The women are.
Yeah. The men are here. And it's like.
African, like, people in the basement.
He ain't talking. Like this, so you get either married. Not talking about it. He said what? Yeah. Well, why even talk to me?
Never know what can happen.
Yeah.
Stick around. Stick around. It might change.
Not interested in that. Cause I feel like if that's what you're doing now, when it's supposed to be the best ever, like nothing to look forward to. Yeah.
It's like, even if
Yeah, I'm not into it like that. I mean, I don't know. So I don't know what we made, but I probably think about the same. Or better. So, you know what I'm saying? It's like, what's it to me?
Yeah.
You gotta deal with somebody that ain't got shit. And they probably don't have shit without you. Which I think that's feasible for somebody that been over backwards. Yeah, because like, the thing about you is that they are very different. You know, for my man.
Somebody I got back. Guess what?
No.
I couldn't my bike turned into a and as my driveway, my driveway just like it's like 2 it's like
Yeah, I mean, it's like, that's kind of like I'm earlier. Like, he don't have he's a tribe.
I ride my
Like he has all the markers, but it's like, that doesn't necessarily make for a partner. Like, you need to probably do some work.
Right, yeah. And it's like, wow.
Cause you really, like, in the head.
And he's mad. It's like, man, it's you go to the wall, I guess I can't get nuts.
Correct.
Well, we can help out.
Like, that is so true. I think that's like one thing. I haven't even talked to you about this. My ex was trying to get me, and it was like, he thought that was me. The one that, like, I think he was here. He was attorney. He apologized to me, like, the other day. I'll show you the text. Yeah, we follow each other, but I don't. Like, so I had posted it. Got somebody.
My homestead license.
I'm at the place to see how the license don't go for that.
Yeah.
I'm going for that. Like, I'm not a person, but you just not love it.
Right.
It's just like, something that I if I say something, you need to do. So I know how to
I had all my
explain
calls.
that.
Well, and that's like you say, what else is there? One more shit. What else do you recall?
And the thing
Not you,
is,
but Karen.
so I have some of this issue too. I'm just like, you're not above correction.
Come down.
Like, so you're not infallible. You're not God. So you're gonna go. So if I bring it to you, you need to at least hear me out. It shouldn't be like, no, I think that I'm because you're not paying, you're not bankrolling. Imagine like, you're not bankrolling. So like, if you were, maybe we could talk. Not paying money. So, like, I think it would have been different. If it was family. Then I'll have to shut up.
But that's, I just really want to have. All these checks, you know, like you said, follow me.
Yeah, so like, the argument. In anticipation. You know, like, man, don't commit to it and you take some of this call
Yeah, that's all.
and then and out there.
Okay.
So we'll do that.
You tell me. I'm sure. I'm sure. She got married. Very generous. Like, I think things that had to hang in my shoes too. I guess I
Deputy Scott. The light.
Is that Scott, Adam?
I thought it was a.
Yeah, that's what I thought.
Oh, there, that boy.
They kind of.
Yeah.
You're silly.
Yeah.
So crazy. Every other day. You are.
They wasn't able to use it.
And that's a problem.
He tried.
It's still not. Yeah, whatever. Sleep keepers everything. I've got it. I've got it. There you go. What do you want to sleep on it? It's 16. What? What? I just put it out there. Cassie just wishful thinking on her part. Look at him napping.
You can call him, tell him, hold on.
Huh?
Yeah. that-
I didn't know that was, I thought that was Adam. He sounded like Adam.
Yeah.
Judgment.
Oh, it sounded like Adam.
He sounded like Adam to me.
They ain't see it. Oh, come to work.
We're back on the record. All parties and counsel are present. I've been handed another note by Deputy Scott, signed by Juror 30. I'll mark it as Court's Exhibit 4, intended that for the record. Jury's been deliberating a little under 2 hours now, I believe. It reads, if we have reached a unanimous decision on 7 of the counts, but cannot be unanimous on the 8th count, would that prevent us from ending deliberations? Signed by the foreperson. And I have that available for council's inspection.
No, I'm saying you have to keep going until you get to that. Yes.
All right, and so this situation that presents itself is, I think we would classify as a partial verdict, where the question is, options presented are we can tell them to continue deliberating, But we can also ask them to go ahead and sign the verdict form and publish the verdict on the counts that they have reached an agreement to. And they could then be told to continue deliberating on that remaining count that they haven't reached a decision on once we know the results of those 7 counts. That's one option. And I think a lot of that's going to be up to the parties here and their preferences. So, any input or position from the state?
Yeah, I think our initial thoughts are if we could encourage them to keep going for a little bit while longer before we accept a partial verdict.
Same from the defense.
Or if they want to come back.
All right. I will, before we answer that though, I do want to confirm some case law that we have on point, just so you can confirm your options here.
It is 7:08. Did you see my text? Let me see what the law is going to say. Yes, give me a minute. Well. Yes, yeah. Kenny. I've only accepted like 6 or 7 months later. And did everything I found child when he came back and changed things.
All right, I do just want to provide for
Yes, sir.
council's benefit, using Daniel's criminal procedure as a guide. We'll see if there are more recent opinions, but we have a Disby versus the state from 1977, 238 Georgia 178, where there was a situation where a jury indicated it had reached a decision on some counts, was still working on others, and council agreed to split it up, let them publish their verdict on the counts that they'd reached a decision on, and keep deliberating on the ones they hadn't. And the court said that was not error in and of itself. But in this particular case, they did require consent of the parties. So just want to point that out. Disby, Disby.
I got that one. His name was in Dale.
Daniels.
Daniel.
All right. So with that, is your position remain the same, Ms. Charles?
No, Judge, we would accept a split verdict.
And to be clear, that wouldn't foreclose whatever that remaining count is. I think that, but in all likelihood, if the jury could very well be coming back tomorrow morning to continue on that one remaining count. The option being that if they remain deadlocked, you go through all the procedures of whether to declare a mistrial on that one count. So it's I think it's something that's within the party's hands. Any position, Mr. Mitchell?
Yeah, we would just ask for your verdict to be unanimous, without having to publish anything. We would just ask for the jury to stick with what they have and keep. And, you know, we would not accept the motion.
John, can you give us a citation one more time?
I can. That is 238 Georgia 178.
Thank you, Judge.
All right. So then I would plan to write a response and saying that they should continue to deliberate on the remaining count. And because they implicated that they are not unanimous, and we have a jury note suggesting they may be deadlocked or using similar language, I think I can inquire how they stand numerically, but making it clear that they're not to tell me what side of the equation that number falls on. So I can start the process of whether we're getting close to a mistrial on that remaining count and the analysis that's appropriate there. So I would propose to write in response to this that, again, they should continue to deliberate on the remaining count, period. And let us know how they stand numerically on that count without telling us the nature of the division, I suppose, or what side each member stands on. Is that fair? Anything else in that note? I'll work on the wording here.
No.
All right. All right, so I've written here, you should continue your deliberations on the remaining count. Without telling us the outcome, how do you stand numerically on that count? Anyone want to review this before I would send this back to Deputy Scott? Feel free. All right, hearing no other objection or input from council, I'll send that back to him and we'll hold in place. Maybe. Hmm. All right, there's been an addition to the bottom of Courts Exhibit 4, and they write 1 versus 11. So, there we have it. All right, so with that additional detail, looking at the factors that go into an Allen charge or a mistrial, it having only been 2 hours, don't think I would be at the point where I think a mistrial should be declared. And so, unless the parties have reconsidered their position in light of the numeric breakdown on the sole remaining count, I would be inclined to tell them that that the bus that would take them to the parking lot is going to be gone soon. So I think we're going to just wrap it up in 5 minutes, and that they'll resume tomorrow morning. I think we would say 9:30, and we'll continue from there. Anything on behalf of the state, Ms. Charles?
No from the defense.
All right. Then I'll keep Court's Exhibit 4 as part of the record. I'll have Deputy Scott tell him we'll go another 5 minutes, and then we'll be wrapping it up. We'll bring him back in, and I'll excuse him. We'll see him in the morning. So I'll be back in 5 to excuse him for the day.
First, it would have been, I need to stay in, if you left in them.
Within the
They can't say, they're not like, you know what, ain't all enough.
Yeah. Cause I don't. It's a-
They won't get, they won't stay, they just ain't $100. They say $100, just comes that they maybe music. I'm telling you ain't got it. I snuggle with the honey.
I got me. I snuck over there, honey. Y'all gave those folks over there. I heard y'all. At least I worked for it. You didn't put me on game. Okay, got me on it too. See, you overstayed. You both out got you got flagged. They don't punish me. They go, it's over. I know that's how she. I said she has to move. I said she like good company like this man. I said, "God, you know I'm in the house, yeah." He didn't even realize what I'm telling you. Then when she came on my phone, I said, "Oh, man, I'm gonna give it up for vacation." I thought they would call me on vacation. Be like, "Oh, why? That's because he goes." I couldn't believe she did, but I said, "When the chick he couldn't go like, before he could take her." So he, when I said, she like. Yeah. I can pay her. How do you pay? 1, 2, 1. Okay, was he going to give you? Oh, no, I already said, I didn't call up. I just because I was sleeping. Like nobody watching me. I never watched who was the thing. I never really broke overtime, so I came in, I helped my business, I stayed. So I live. I'm just saying, because I'm kind of, I ain't gonna be I was telling him, when you get it on, back in, I ain't in the car down. Get his phone, get you a center. I don't even know what's the message, but I know. Not. I didn't even know. What's his? If you tell me before I said I didn't say that.
All right, we're back on the record. Deputy Scott, if you could retrieve our jury.
Yeah, the lights got.
Thank you, Deputy Scott. Pleased to see it, everyone. Members of the jury, we know you've been hard at work the last 2+ hours. And at this time, though, I think the bus has to go. So I leave you with the same instruction as always. Please don't discuss the case with anyone, including amongst yourselves on the way to the bus. And you can only begin deliberations again once all of you are present together tomorrow morning. And don't do any research about anything involved in this case. Everything must now rely on your recollection of the evidence and your review of the exhibits in the jury room and the other instructions that I've given you. I would propose that y'all can reconvene at 9:30 tomorrow. I won't call you in. Just once you are all there, you can resume with your deliberations. We'll be here waiting for more word from you. So unless there's anything anyone needs to hold back and notify us about, if there are any conflicts for Tuesday that we may not have addressed during jury selection, let me know. Otherwise, we'll see you tomorrow morning. Thank you.